mo mọ̀ pé ẹ̀jẹ̀ Ìbàdàn wà lára wọn ṣùgbọ́n wọn ti wálé. Pásítọ̀ Odùtọ́lá mo kí yín, ẹ ṣé. Gbogbo àwa tó kù náà mo kí ní ti tológun mo kí yín ní tẹ̀ṣọ̀tẹ̀ṣọ̀, gbogbo ọ̀rọ̀ ni mo fi kí yín, ẹ kú kalẹ̀. Ẹ máa wá gbà mí láàyè láti ka ìwé àkàbọ̀ mi ní òyìnbó. Mo fi dá lójú pé ní agbára Ọlọ́run tó bá máa di ẹ̀mí tá máa ṣe àpéjọpọ̀ báyìí, màá ti lọ mọ bí màá ṣe kà ní Yorùbá dáadáa. Ẹ dáríjì mí, ẹ má bínú. A ti sọ wípé gbogbo ètò ẹgbẹ́ amòfin a máa ṣe ní Yorùbá ni, ṣùgbọ́n àwa kan wà tó yẹ pé ọmọ bọ̀tá ni wá, ẹ ṣáàmọ̀, ẹ dáríjì wá. Ó jẹ́ lè jẹ́ pé a wá ní láti ìsàlẹ̀ òsì, bọ̀tá ni wá láti ìsàlẹ̀ òsì, ẹ ṣeun. It gives me a great pleasure, it gives me great joy. Akọ́mọ̀nà mi wà ní orí ewé kẹrìndínlógún, page 16 of the brochure. Mo rò pé gbogbo wa ní ìwé yìí. Ó wà ìwé mo ti pín káàkiri, ẹ jẹ́ ká wo orí platform wa. Tó ń bá dẹ̀ tí pín, Alhaji Ìpínlẹ̀ Adégòkè ẹ bá wa pín sí gbogbo platform káwọn lè bá rí. It gives me great joy, honor and privilege to welcome our excellencies, distinguished leaders of the bar, learned brothers, Sikhs, colleagues and other illustrious sons and daughters of Yoruba extraction to another gathering of great minds in our land, the second in the series of annual national conference of Egbe Amofin Oodua, tagged Eko National Conference 2024, with the theme Economic Recovery for Nigeria, Prospects and Challenges. May I extend a special welcome to our friends from other parts of the country who, despite their very tight schedules, found it worthy and expedient to register and attend this conference. My deep appreciation goes to all the governors of Oyo, Lagos, Osun, Ondo, and Ekiti states for graciously accepting our invitations to be part of this great event. Though they are in absentia, I believe that they will send their representation as we proceed. I most humbly appreciate our trustee, Mr. Lawal Pedro SN, the Attorney General of Lagos State, and my noble Lord, the Chief Judge of Lagos State, Honorable Justice Kazim Alugba, for their support. Every one of us who was at the cocktail last night will testify to the fact that we really enjoyed ourselves. That was when I saw many people dancing happily to the tune being released by the DJ. May Almighty God continue to endow and honor you all. I must emphasize for the record that Egbe Amofin Oodua came into existence when the first meeting was held in the residence of our beloved late leader, Chief Bandila Eko SN. On the 21st November 1998. We must commend the effort of all our leaders who had been sustaining the existence of Egbe Amofin to date. We must appreciate the effort and support of Chief Wole Olanipekun, Chief Awomolo SN, the Kindele Adeshina SN, and our younger leaders. I must appreciate Are Olumuyiwa Akimboro SN, and my brother from Ibadan, Dr. Obatunde Ajibade SN. Thank you very much. Egbe Amofin is now fully please give them a round of applause, please. Thank you. Egbe Amofin Oodua is now fully registered under Part C of Communist and Land Matters Act 2020, with trustees spread across all Yoruba-speaking states of Nigeria. That is, we have trustees in Oyo, in Ogun, in Ondo, in Osun, in Ekiti, in Kwara, and Kogi State. Please give us a round of applause. The main aims and objectives of Egbe Amofin, as stated in the Constitution, include, but not limited to, promotion and protection of interests of members of the forum, and inculcation of values and cultures of Omoluabi, articulating and protecting the interests of the members of the association within the NBA, promotion, maintenance, and defense of honor, integrity, and independence of the bar and the bench in Yoruba-speaking states, encouraging the interest and participation of members in the affairs and activities of the association and that of the NBA. It is very important I state this, that the forum, Egbe Amofin, is not and shall not operate as a parallel body with the Nigerian Bar Association, nor shall it have a competing interest within the NBA. This conference is very essential for the Egbe Amofin Oodua. It forms part of our efforts in reuniting our bond and strengthening the core aims and objectives of the establishment of Egbe Amofin Oodua by our founding fathers. The Egbe Amofin Oodua promotes an invaluable platform for fostering the development of lawyers and for addressing socio-economic and legal issues affecting its members. When this administration came on board, we desired the reunification of lawyers of Yoruba extraction. We desired the reunification of lawyers of Yoruba extraction to claim our rightful place in the NBA, reunite members and empower the young members to attain greater heights in the legal profession, which is in tandem with the aims and objectives of this great body. With the word of Mahatma Gandhi, unity to be real must stand the severest strain without breaking. We must stand firm and work assiduously for our unity. We must not allow anyone and anything to divide us. We say no to them. Egbe Amofin shall not fail. May I, on behalf of the Great Council, of the Governing Council, convey our immense gratitude to the elders of the Egbe Amofin for your counsel and undying support in fostering the unity and growth of this body that has been our guiding light since we took over the mantle of leadership. Ọlọ́run kò ní jẹ́ kí àgbà kó tán lórílẹ̀. As we are aware, this is indeed a challenging moment for every Nigerian, particularly our young lawyers. We have the responsibility and duty to give them hope that better days are ahead. Hence the theme of this conference, Economic Recovery for Nigeria, Prospects and Challenges. I have no doubt at all that our keynote speaker, Mr. Babatunde Raji Fashola, will deal justly with the theme. We need to recreate and reclaim the pride of our country, Nigeria, that we endear the younger generation to have a renewed hope in the country. I enjoy on all, while we meet and network, to avail ourselves the opportunity to be part of the plenary session and the showcase session with array of seasoned speakers and discussants as we brainstorm through the hot button issues and emerging trend in Nigerian legal landscape. Before I conclude, may I, on behalf of the Governing Council, convey our immense gratitude to all our members for their tremendous financial support towards hosting this conference. I must personally express my deep appreciation to the members of the Conference Planning Committee and the Local Organizing Committee under the leadership of my learned brother Sil, Kunle Adegoke SN, and Mr. Shegun Fabumi, for their doggedness, dedication, and commitment in putting this event together. To the chairman, executives, and members of NBA Kaja branch, I say a big thank you to you to allow us to use the NBA Bar Center for your AGM. May the Lord always attend all your efforts with success. Amen. Oodua Egbe wa o. Ẹ ṣé mo dúpẹ́. Bí mo ṣe lè kà ní ẹ bá mi gbà bẹ́ẹ̀. Where is Ṣèyí? chairman Ìkẹjà.
ẹ bá wa fún àwọn bàbá wa ní àtẹ́wọ́ lẹ́ẹ̀kan sí. Láì fi àkókò ṣòfò, mo fẹ́ pe amòfin àgbà Kúnlé Adégòkè, Senior Advocate of Nigeria, sí orí ètò yìí kan wá fi ọ̀rọ̀ ìyànjú kan fi wá kó àbọ̀.
Mo kí ọ̀gá mi, aṣíwájú mi, ẹni tí ó ti ń kó wa jẹ̀pẹ́, ẹni tó ti ṣe adarí ọkọ̀ ìlú Èkó fún odidi ọdún 8 gbáko. A rí ìlọsíwájú, a rí ìdàgbàsókè. Eku ó ké bí eku, ẹyẹ ó ké bí ẹyẹ, ọmọ èèyàn wọ́n fọ̀hùn bí èèyàn. Ọ̀gá mi ọ̀gbẹ́ni Babátúndé Rájí Fáṣọlá, agbẹjọ́rò àgbà ní orílẹ̀-èdè Nàìjíríà. Àwọn Yorùbá ló pè bẹ́ẹ̀ yẹn, wọ́n á ní agbẹjọ́rò àgbà ní orílẹ̀-èdè Nàìjíríà. Àwọn òyìnbó wọ́n á ní Senior Advocate of Nigeria. Haúsá wọ́n á ní Babanlóyà Nàìjíríà. Àwọn Ìgbò náà ní nǹkan tí wọ́n máa ń pè é, ṣùgbọ́n áfàmù sí kò fún mi ní ààyè láti sọ ọ́ ní èdè Ìgbò. Wọ́n á kí gbogbo àwọn àgbà tó wà níkàlẹ̀. Ẹ̀gbọ́n mi akọ̀wé gboyè ọ̀mọ̀wé Babátúndé fẹ́ pọ̀ nbí lónìí o. Tọ̀, ó dàbí pé mi náà kúkú pààrọ̀ ọkọ̀ kí n lè bá gábí tiwọn. Babátúndé Ajíbádé, agbẹjọ́rò àgbà làwọn náà jẹ́ ní orílẹ̀-èdè Nàìjíríà. Ẹ̀gbọ́n mi ààrẹ Múyìwá Akínbọ́rọ̀, agbẹjọ́rò àgbà ni àwọn náà. Ààrẹ wa pátápátá nínú ẹgbẹ́ yìí, wọ́n á ní akínkanjú ọmọ abẹ̀wò àkàlà lọ́rùn, Abíọ́lá Ọlágúnjú SAN, mo kí yín kú ìjókòó. Ẹ̀gbọ́n mi Olúṣẹ́gun Fábùnmi SAN, ọ̀rẹ́ mi oníjàngbọ̀n nì tí máa kó mi sí wàhálà láyé ìjọ́hun, ṣùgbọ́n gbà tí ó ti di sínétọ̀ òun náà ti di èèyàn jẹ́ẹ́jẹ́, ṣùgbọ́n jẹ́ẹ́jẹ́ rẹ̀ náà ò débi kọ́mọ́ fàjàngbọ̀n o. Dr. Ajíbọ́lá Bashiru, Distinguished Senator of the Federal Republic of Nigeria and the National Secretary of Ẹgbẹ́ Olóṣùṣù Ọ̀wọ̀. Láti ìgbà náà lèmi ò ti tẹ̀lé mọ́tò tó wà ní ìjókòó. Forúkọ sílẹ̀ fún ìjókòó yìí ní ọjọ́ òní, wọ́n lọ bí 105 tó jẹ́ wípé kódà a ò tí ì rí orúkọ wọn yanjú tán ní ìta. Púpọ̀ nínú wọn ló jẹ́ agbẹjọ́rò àgbà tí ẹlòmíín wà ní ilé ẹjọ́. A sì ní nínú àwọn tí ó yẹ kí ó bá wa sọ̀rọ̀ tó jẹ́ pé fún àjálù kan tàbí òmíì wọn ò ní àǹfààní láti wà níbí lónìí. Ẹ̀gbọ́n wa Jìmí Agbájé, ọmọ wọn ọkùnrin àgbà tó jẹ́ ọmọ 40 ọdún ó lé ẹyọ kan, ó pa ipò dà. Eléyìí fa àìlèwà ń bí ọ̀pọ̀lọpọ̀ wọn, pàápàá jùlọ ọ̀gá wa Kọ́yinsọ́lá Àjàyí SAN, tó yẹ kí àwọn náà wá fún wa ní ìdánilẹ́kọ̀ọ́. Ṣùgbọ́n wọ́n ní àgbà ní ó tó rò ó fì, erin ni ó tó ìwo ọba fọn. Wọ́n gbé ògúnnágbòǹgbò ikọ̀ dìde láti wá ṣe aṣojú wọn bí lónìí. Ọ̀gbẹ́ni Ibrahim Lawal oníjàngbọ̀n ni òun náà ní àwọn àsìkò kan, ṣùgbọ́n náà ti ń di ọmọ jẹ́jẹ́ báyìí. Ọ̀pọ̀lọpọ̀ àwọn yòókù ló jẹ́ wípé wọ́n sì ń bọ̀ wá láìpẹ́ láì jìnnà, wọn ó darapọ̀ mọ́ wa. Mo kí wa káàbọ̀ sí ìpàdé yìí. Òní jẹ́ ọjọ́ pàtàkì fún ìgbìmọ̀ tí ó jókòó yìí, Egbe Amofin Oodua, fún gbogbo ọmọ Oòduà pátápátá, torí wípé ìtẹ̀síwájú Oòduà ọwọ́ àwa agbẹjọ́rò náà ni ó wà. Tá a bá ṣe tó bá dá, a rí yí padà. Tá a bá ṣe tí ò bá dá, a tún rere ń bẹ. A ti sọ̀rọ̀ lẹ́ẹ̀kan wípé ọ̀pọ̀lọpọ̀ nínú àwọn tí ó tún orílẹ̀-èdè Nàìjíríà ṣe látorí bàbá wa Olóyè Ọbáfẹ́mi Awólọ́wọ̀, Senior Advocate of Nigeria, ló jẹ́ wípé amòfin ni wọ́n. Nígbà tí wọn kò bàjẹ́ títí látorí gbogbo àwọn bàbá wa Olóyè Rotimi Williams SAN, káàkiri bẹ́ẹ̀ tó fi dórí àwọn tí ó tún dakọ̀ ẹgbẹ́ wa lónìí, bàbá wa Olóyè Wọlé Ọlánìpẹ̀kun SAN, bàbá Awómọ̀ọ́lọ́ SAN, Ọlọ́run kí ó lọ́ra ẹ̀mí gbogbo wọn fún wa. Ìjókòó wa lónìí, a ó máa tẹ̀síwájú nínú àwọn ìjíròrò kan tó ti ń lọ látẹ̀yìn wá, léyìí tó jẹ́ wípé ọ̀gá wa wọ́n kọ́kọ́ máa yànnàná ọ̀rọ̀ fún wa. Ìwọ̀nba nǹkan tó ń bá wa sọ, ọ̀rọ̀ ọlọ́gbọ́n ni ó jẹ́. Ẹ dákun ẹ jẹ́ kí a mú lò. Bí ẹlòmíì bá wò pé ó kéré, kó dákun kó bá wa gbà bẹ́ẹ̀. Ẹni tó bá sì mọ̀ pé ó pọ̀, kó dákun kó bá wa gbà bẹ́ẹ̀. Mímúlò rẹ̀ ó ní kókó. Ẹni tí ó tọ̀ sílé, òun náà gbìyànjú àti rọ̀jò. Ìwọ̀n tí ipa rẹ̀ ká ló ṣe mọ́ o. Ẹ bá wa gba gbogbo nǹkan tí a bá ṣe níbí báyìí lónìí, gẹ́gẹ́ bí a bá ṣe ṣe, Ọlọ́run á sì bá wa fi àlùbáríkà sí. Mo kí wa káàbọ̀ sí ìpàdé yìí o. Ìgbẹ̀yìn rẹ̀ yóò dùn, yóò lóyin mọ́mọ́ fún gbogbo wa. Ẹ ṣé mo dúpẹ́.
Ẹ bá wa fún wọn ní àtẹ́wọ́lẹ̀ kan sí. Mo fẹ́ fi ẹ ṣeun. Mo fẹ́ fi àkókò yìí pé àwọn bàbá wa gómìnà àná Babátúndé Rájí Fáṣọlá, mi ò tó yín pè lórúkọ o. Mo fi àkókò yìí gbé yín wá sí orí àgbéga ìsà kí ẹ wá bá wa ṣe ohun tí a gbé yín wá bí fún. Ẹ jọ̀ọ́ ẹ bá wa dìde kẹ́ bá wa fún wọn látẹ́wọ́ o. Àwọn bàbá wa ti dé láti aago 9. Ẹ ṣeun sà.
Ẹ ṣé, ẹ jókòó. Bí ẹ jẹ́ n kọ́kọ́ kí wa pé ẹ káàárọ̀, ṣé dáadáa ni gbogbo wa jí. Ara lè o. Bí atọ́kùn tó ṣe sọ pé àwọn gbé mi wá bí, èmi mo gbéra mi wá bí o. Ẹ pè mí wá ni o, ṣùgbọ́n èmi mo gbéra mi débí. Mo kí alága ẹgbẹ́ amòfin àgbà Ọlágúnjú, mo kí gbogbo àwọn amòfin àgbà tí wọ́n wà ní ìkàlẹ̀, àwọn amòfin àgbà tí wọ́n ń bọ̀ náà, Ọlọ́run á jẹ́ kí wọ́n di amòfin àgbà tó wà nínú ìjókòó. Gbogbo ọmọ Oòduà àti àwọn àlejò wa tó wà níkàlẹ̀, mo kí gbogbo wa pé Oòduà gbè wá o. Mi ò gbọ́ yín o. Ṣé rí bí mo ṣe jókòó síbẹ̀, amòfin àgbà Adégòkè bi mí pé ọ̀rọ̀ tí a fẹ́ bára wa sọ láàárọ̀ yìí pé ṣé Yorùbá ni máa fi sọ, mo ní bẹ́ẹ̀ ni. Nítorí ìgbà tí mò ń ṣiṣẹ́ lórí ẹ̀rọ ayárabíàṣá, Yorùbá ni mo fi ń tẹ̀. Ṣùgbọ́n nígbà tí máa gbé jáde ńsìn, ó ti bọ́ sí Gẹ̀ẹ́sì. Bóyá olóyè Fásí Yusuf mọ̀ ń pa ẹ̀, àbí Babátúndé Ajíbádé náà mọ bó ṣe papòdà. Ó dẹ̀ lè jẹ́ pé mo máa lọ bá Sẹ́nítọ̀ Ajíbọ́lá Bàṣírù toró ti ń sọ ń bì pé wọ́n ń sọ òun lórúkọ tóun ò jẹ́, wípé òun dẹ̀ máa fìwé pè wọ́n lẹ́jọ́, kúkú bá mi pe ẹ̀rọ ayárabíàṣá yẹn náà lẹ́jọ́. Báwo ni ó ṣe pa ìwé mi dà? Ah, kí lorúkọ yẹn ní Yorùbá? Originating summons. Ẹ bá wa túmọ̀ ẹ̀. Ẹ ṣé gan, inú mi dùn láti wà ń bí. Ọ̀pọ̀lọpọ̀ àwọn olùkọ́ mi, ẹ̀gbọ́n àti àbúrò tí a ní àǹfààní láti ríra ní ìgbà tó ti pẹ́ díẹ̀ ni mo ti fojú kàn àti ń jíròrò kó tiẹ̀ tó di pé a wọnú ìjókòó yìí. But distinguished ladies and gentlemen, let me start by taking what I think is a preemptive strike at the topic of the keynote address as formulated by the Egbe. The topic was economic recovery for Nigeria, prospects and challenges. But I think that in launching what I call a preemptive strike, I must say that I mean no disrespect at all to my very esteemed hosts. On the contrary, it is my wish to set records straight and hopefully offer some enrichment to our conversation in the belief that somebody is listening. And I think as my learned friend just remarked, there are younger lawyers in the gathering for who it is important to contextualize this conversation in the hope that it will help them make informed choices. So, what is the record I wish to set straight? It is first by taking us back to sometime in March 2014 in the conversation about our economic situation. The then Honorable Minister of Finance was copiously reported as saying that Nigeria was heading towards a recession in March 2014. And I believe that she should know what she was saying, not only as Honorable Minister of Finance at the time, but also because she also doubled as the minister coordinating the economy. Needless to say, in 2016, the recession that she predicted happened. Of course, government had changed. And the response of the subsequent government to that recession was to develop what it called an economic recovery and growth plan. I believe that Senator Bashir will remember this. It was probably part of the approving and concurring authority then as a senator of the Republic. That plan was to run from 2017 to 2020. The aim of the plan was to restore growth. It meant to invest in people, and it also sought to build a globally competitive economy. Please remember that. Restore growth, invest in people, and build a globally competitive economy. The key strategies towards achieving those aims was first to stabilize the macroeconomic environment, to achieve agriculture and food security, to ensure energy sufficiency, improve transportation infrastructure, and drive industrialization through small and medium enterprises. So, we had been in recession. We had set a recovery and growth program. And if we all followed events from there, except for what I describe as a black swan event of the COVID-19 pandemic that ensued in 2019, during which virtually all the economies of the world, including that of Nigeria, fell into a recession from which she subsequently recovered, you will see that the annual GDP results, which is the gross domestic product result, indicate that the economy of Nigeria has been growing averagely at between 2 to 3% yearly. If you go back in the last few years, that's what you will see. 2 point something percent, 3.1%, 2.8%, thereabouts. So in my view, it seems most respectfully, and I say this very respectfully, inapposite to have a conversation about recovery, which is what the Egbe formulated, given the context I have said. So, as my learned friends will say, I seek to have the subject amended by a motion based on the facts in the affidavit that I have presented, and therefore retitled, quote, economic growth as distinct from recovery. Economic growth for Nigeria, prospects and challenges, end of quote. I move in terms of the motion. Thank you so very much for acceding to that request. So as far as prospects for economic growth are concerned, I think that the horizon is extremely promising. And the case I just intend to present here is that economic growth will be delivered by two broad spheres of infrastructure, the soft and the hard infrastructure. And that's what I will speak on in the next few minutes and take my seat. But I just preface that by pointing out that apart from the fact that I take the view that the horizon is promising, the tools to achieve expansive and inclusive growth, because growth can be expansive and not inclusive. As we had in the period around the 2007, 2010, and all of that, you go back to the report. I do not say so. It was the verdict of the Nigerian people that is not an inclusive growth. Economy was growing about 7% then, but there were still complaints that it wasn't including people. So what we need really is inclusive and expansive so that everybody is impacted in a positive way. And so I think that the tools to achieve that in terms of manpower in quality and quantity already exists. We have it. Then I go to the point where I say that growth will be impacted apart from manpower. We have the manpower. The driver of growth will be hard and soft infrastructure. And it is important because everything is there. So we might ask, why are we not then feeling the growth? Why is it not expansive? I think our understanding is important. To understand how infrastructure, hard and soft, impacts growth. And when it is happening, we should be able to see it. Because sometimes I think that if we don't define what the objective is, even when we get there, we may not know that we have arrived there. And this is important. So let me deal with the hard infrastructure. We all know what that is. Roads, bridges, seaports, airports, new refineries. All of this is happening in our country. We now have a new refinery built by the private sector, supported by government. We have a new seaport in Lekki. We have new airports, 5 major international airports expanding and growing. These are important. We now have rail working Not yet where we want it to be, but it's already there. There are parts of the country now where you can travel by rail. So those steps are being taken, and we must pay attention because they are happening in our country. Those are the things that impact growth in other parts of the world. As we do them, let us be conscious that we are on the way. Let us be conscious that it's already happening. Broadband infrastructure. So yesterday I was talking to some young people and I told them what an email service looked like in 2000. My law firm, I think at the time, was one of the first law firms, one of the many first law firms to subscribe to an email service. But what did it look like at the time? At that time, some people were still branding the telex machine, but we had moved to a facsimile machine, and we had then migrated to an email. But in order to operate that email at that time in the year 2000 in Lagos, we had to subscribe to an email service by a company on Louis Street. My firm was on Igbo Road. So we had to go and register with another firm. So the emails will be delivered there. Then they will print it for us and send it to us in a file. And we were paying. That was Lagos, Nigeria, 2000. So broadband has come since then. So I don't know when last any one of you wrote a check. And we are moving transactions, moving money. Lagos State, in my time, I think we were the first state to embrace the cashless transaction with the then governor of Central Bank, Sanusi Lamido, against opposition. But I remember when we debated it in council on that day, I said, for me, the most important reason why we must embrace it was the safety and security of lives and property. The less cash people kept at home, the less predisposed they will be to being attacked in their homes. But that's another story. But why I'm saying this is that broadband and all of these are part of that hard infrastructure that makes us able to do so many things today. And they're already here. They're not alien anymore. They are happening. As we pass by across our states, within our states, we see people digging, we see people constructing, we see cement being applied, we see earth moving. Those are the ingredients of growth. It's already happening. But what is our response to them? What does it even mean to us? Does it mean anything to us? So I will try and highlight this by saying that the countries that build, buy, or produce more infrastructure essentially create more growth. Very simple. They create more productivity. Inevitably, they create more wealth. So I will talk to a few case studies of what has happened here and try to highlight whether we really understood them as investment in growth. So let us talk about the Lagos-Ibadan Expressway. I think we all are familiar with that road. If we have not driven it, we have heard about it for all sorts of reasons. It's no longer in our national conversation. You know why? The matter has been resolved. So we don't talk about what has been done anymore. It's been done. Every day at one time, it was the biggest single item on our national development agenda. Nobody talks about it anymore. We move to the next one. Thankfully so. But it was more than a road. It was a job center. It was an avenue for economic exchange, for employment. And let me share some interesting numbers. There were two contractors. Julius Berger on the Lagos end to Shagamu, which was 44 kilometers, and Reynolds Construction Company, which was on the Shagamu to Ibadan end. So on just one half, the Lagos half, 44 kilometers, I don't know if we knew that there were 29 subcontractors apart from the main contractor. So the only person we knew was Julius Berger. But there were 29 different companies subcontracting to that project. So those were 29 different businesses employing people and families whose livelihood depended on that job being done. That was growth, that was employment, that was inclusion. And I will give you some numbers. Then there were 161 suppliers, apart from the subcontractors, supplying various things throughout the period that construction was going on. And then there were 75 permanent jobs at a quarry. How many people have been to a quarry here before? So there's a lot of money there, but we don't know. There's a lot of money. That's mining. But those of us who live in the sophisticated cities, we don't even know. And the quarry people don't tell us there's money here and there's jobs here. So, over this period, the contractor paid out 39.8 billion naira. Let me repeat that figure, 39.8 billion naira to those suppliers. It paid 10.6 billion naira to his own employees. So that you will see all of those suppliers were those small businesses, O&O Enterprises, Ajibade and Sons Limited, this one, Adegoke and so suppliers, and so on. This, merchant that. Those are the heart and soul of every economy in the world. Small businesses, family businesses. Our law firms are small businesses. Accounting firms are small businesses. Pharmaceutical stores are small businesses. Hospitals are small businesses. They put food on the table. And it is the opportunities that infrastructure provides for them that determines the level of expansiveness and the inclusiveness. And I thought I should make that point. The other project that I will talk about and move on quickly was the second Niger Bridge. Again, well, it's now being talked about for less than noble reasons. Somebody is trying to steal some parts out of it. But it was the single biggest item, again, at the time. Nobody is talking about it again because to cross a 2-kilometer river that used to take about 18 hours is now a journey of less than an hour. Problem has been resolved. But in doing so, 20,000 jobs were created around that project. The employment spanned not just engineering and skilled labor, there was a lot of unskilled labor and support services. The project involved the procurement, supply, and utilization of 26,900,000 liters of diesel. 26,900,000 liters of diesel. So the company that was constructing the bridge doesn't manufacture diesel. So I see some heads are nodding there and imagine if I got that contract to supply 26 million liters. But not even one company can do it. So they are distributed. But this is the process of wealth creation. Then they are trucked and so on. It consumed 80,000 tons of cement, 80,000 tons. And it consumes 660,000 tons of aggregates. So those who do quarry business will know what aggregates are in construction. And I will just quickly share with you the implications of that. The diesel alone cost 30.9 billion. The cement was 4.080 billion. The aggregates was 2.376 billion. These were the quantities of money that were moving between businesses. Contracts, supply, delivery. And I just then talk about the 1,262 building contractors that were working in the housing sector of a ministry that I supervise. 1,262 building contractors. Those are the companies who won bids. So imagine and extrapolate their staff and their subcontractors and their suppliers. And of course, the road construction side that I've alluded to, we recorded gross about 383,431 people that were directly employed. And they installed things like road signs. Installing a road sign employed about 4 to 7 people, one road sign. Those gantry signs you see on the highway. We had them install 254,690 of those signs. So just imagine 4 to 7 times 250-something thousand people. And they installed over 2 million linear meters of road marking. So road marking is a business on its own. That's not the business of the road construction company, the subcontractors who employ people. And if you've driven past them, you see them moving cones, moving paint, and there's a lot that can be done. So this is how, in a nutshell, we see the impact of infrastructure. But do we connect only with the delivered road? Or how many of us really know what's going on beneath? That's the message I want us to ponder. But to move aggregates, to move bitumen, to move reinforcement requires haulage, trucks. There is an association called Road Transport Employers Association of Nigeria. They are the truck owners. In the 8 years that I worked with them, they were very happy people. You know why? They were in charge of delivering 1,704,300 truck trips. 1.7 million truck trips. So if you are a truck owner in this hall, you know what it means. Haulage business used to range from about 50 to 200,000 naira per trip. But it was in the aid of what? Delivery of infrastructure. So I just say that there are two types of infrastructure we must now add to the hard one. We've done the roads, the ports, and all of that. I think what we should focus on is infrastructure that supports tourism and infrastructure that supports talent and deployment, because that's where the world is heading now. You will see that there's a lot of soft power now. Athletes, sportsmen, musicians, artists are having a booming voice in global political and economic affairs. And we can't afford not to play. So we've built the seaport, we've built the airport, we built the roads, and we're continuing. But we must now consciously develop infrastructure to support arts, talent, entertainment. And by this I mean stadia, arenas for concerts. We have all of the great artists in the world now. But how many of their shows are being performed here? And all the rail and the road that we build must now link to that last mile, to sports centers, to performance arenas. So this for me is a strong driver for growth. And to just make the point that sports and entertainment are no longer hobbies. They are professions now. And if we support them consciously with how we deploy infrastructure, it supports my argument that the horizon for expansive and inclusive growth is so positive. So I want to drop a gauntlet for the Egbe. Now, I think there is a role that we can play. As sports is developing, as entertainment is developing, is the Egbe consciously making efforts to support the teaching especially for the younger ones, of the law that enables the development of this area. What changes have come on in our tourism law? What changes have come up in our law curriculum about sports and entertainment law and the protection of talent in terms of copyright law and practice? I think this is a place where we can begin to play a role. That must change. Are these subjects being taught in our schools? How many universities are offering sports law and entertainment law? So that is my poser and my invitation. How many business law curriculum includes sports and entertainment? Because I'm sure that our parents who did not want us to play football 40 years ago will be happy to have one Ademola Lukman in the family now, or more. And this is the change. But has the law responded to that? And have we as practitioners taken the step? I do hope that maybe at the next general meeting, the Egbe will be having a conversation around these issues as the next great leap towards which our economy must aspire. When the laws are reformed, how do members of the Egbe and their colleagues who are not members, and by this I mean their lordships, but who all belong to the Bar Association, implement the laws? Will we continue those regular, long-winded and long-winding court trials, or will we wholesomely embrace arbitration as a business-friendly dispute resolution mechanism? So I'm now on the second leg of the argument. First leg is the hard infrastructure. For me, the dispute resolution mechanism, law and order, is the soft infrastructure that will drive growth. And this is important because it impacts how easy or not easy it is to do business. Law and order. And that will define how well the economy will grow. And it has a lot to do with the conduct of some of us who may or may not be here. As I say, the efficacy of the justice system is not only a measure of the quality of governance, it has consequences for the overall well-being of the economy and our quality of life, more than we care to think. I know that we are not all culpable, but I contend that the untenable conduct of one member of the Egbe portends great danger to our national economy and confers guilt on all of us by association, unless we have a remedy that promptly enables us to remove, to sanction, or disqualify such a member. And we are at the point where, as they say in every nation, where is the elite consensus? This is the elite. When will we be able to say, look, you cannot be a member anymore, you must leave us? And that is a very, very important factor for growth. So we can have all the talk. Government is doing its part. What are we doing? Let me give you two cases that shows how our conduct slows down development, adversely affects our quality of life. The first, you might remember that there was recently the commissioning of the Aba geometric power plant by engineer Bat Naji. But do you know that that case was held up in court for years? There was a court dispute, they were fighting, and so development couldn't happen. No bank was going to finance anymore because one of us had advised his client, let's go to court. And they were ready to keep the matter in court. So until I became minister in 2015. And the matter came to my attention in a meeting with the vice president, and I said, sir, just leave this to me. I will brief your office. We will try and negotiate a settlement between the parties. We eventually succeeded. But imagine the number of years that had been lost. And so the project that was commissioned this year might probably have been commissioned many years earlier if not gone to dispute had been efficiently resolved. There's a second one, the 700 megawatt Zungeru hydropower plant, recently commissioned too. Now, let me give you the background facts so that you will understand it. Government has gone to apply for a China export-import development loan to build a 700 megawatt hydropower. And so we, Nigeria, we went to China. Countries have this export and import loan. Nigeria has their own too. So they gave us a loan. There was one of our colleagues, whether he was an Egbe member or another group member, but he's a member of the MBA. He had issues with his fees. I don't know how he got involved. But his clients were local people. And we all understand that the Chinese government is foreign, of course. But in trying to get his fees from his local partners, who he sued, he now went to court and got an injunction to stop the China Exim Bank from disbursing the entire loan amount, the project fee, which was many times monumentally over and above how much he must have been claiming. Now, that was the state of affairs when I took office. The project had been stalled for 3 years. So it was my responsibility to get him out of court, resolve those issues, so that you will see that being Minister of Power was more than just electric issues. Administrative, legal, and so many other things. Needless to say, the project finished. So, and I say here that the Nigerian judicial system is replete with not a few of this kind of instances. So if there's any one of us who is involved in any of these cases today, I think you should begin to have a rethink. How can I achieve settlement and justice and national development? Because we are more than just fee collecting agents. We are agents of development. And we must rethink our roles in the cases that we argue and we get involved in. So what can the Egbe and what will the Egbe do to the colleagues and judicial officers involved in these kind of things? What will we do? So think about it. What can we do and what will we do? But beyond individual and official rules by members and non-members of the Egbe who are lawyers, there are institutional and policy issues. And this, I believe, is the last issue. And it is about this idea of separation of powers. And the notion that the judicial arm, the executive arm, and the legislative arm are three parallel lines that must never talk to one another. Nothing can be further from the truth. In fact, their separation is best exemplified by their interdependence. And so, when does the executive, for example, and how does the executive notify the judiciary of its policy objectives in respect to certain things? So that in coming to adjudicate on those things, the judiciary is mindful that this is government policy and I'm part of government. Because they must work together. And so this is really a very important conversation that I think that we must have. Where does this separation of powers end and where does it forge? And I think it would be best if the Egbe decides to engage this matter, not just to theorize, but to bring people who have had very practical experience in government as chief judges, attorneys general, speakers of the various houses of assembly, governors, and presidents, to come and share experiences about this thing. We have the faculty now. We've done election in 1999, 2003, 2007, 2011, 15, 19, and 23. So at the minimum, we have 7 faculties, 6 faculties of experience to draw from across the entire country. So why is this important? Again, 2 practical examples. So when I took office as Minister for Power, we had just passed a tariff increase. That tariff was a consequence of law. It wasn't as if people just woke up one day and said, tariff. The law said so. I didn't pass that law. It was passed before I became minister. And the whole country was up in arms. I remember I came on national TV to appeal for understanding. But some people thought otherwise. And what did they do? They went to a federal high court and obtained an injunction to stop the implementation of the tariff. Now, one thing I did then was to ask my staff, my legislative assistants, please check for me, is there anywhere in the world where a court has stopped a regulator from imposing tariff? I couldn't find, except Nigeria. There was one case that I think it was a South American or Asian this thing. But what happened was that I think the case went up to the Supreme Court said, no, the trial court was wrong. You don't interfere. But we did. And I'm not going to go into any more details. But I went through the agreements, and I saw that there were arbitral clauses there. So I went to the then Chief Justice of Nigeria, and I said, sir, you want electricity? He said, yes. One thing you can do for us, please, a practice direction to say that all agreements relating to power that have arbitral clauses, no court should entertain them again. And gladly, he did so. Issued the practice direction. Then, very close to us here, because we're talking development, there is the Ikeja shopping mall now, very close to the governor's office. But this is the story of the mall that was never told, and I will tell it today. So after the Lekki Mall was built, we saw that there were so many people going to Lekki. Traffic management. So we called the developers of the Lekki Mall, Mr. Tayo Amushon and the Actis Group. Said, look, Come and do Ikeja Mall. He said, they don't have money in Ikeja. I said, no. Most of the people in Lekki Mall, I had done a study. Where were you from? Found people from Alimosho in Lekki Mall. And we gave them the report. They said, really? I said, and there's money on the mainland. Needless to say, they agreed. My predecessor, the president, had acquired the land where this mall is. It used to be a sheriff's warehouse, belonged to the judiciary. We had acquired it and we were in the throes of negotiating a replacement land, which I later implemented. So land was properly acquired. For all intents and purposes, the land belonged to the judiciary. So investors moved in, built the mall, and on opening day, on the day they were to open, 2 years after construction, many years after the land was acquired, somebody was in the High Court of Lagos State trying to get an injunction ex parte to stop the mall from opening. And this is important. So to the credit of the Lagos judiciary, then led by the Honorable Justice Ayo Phillips, she said, no, there will be no injunction here. We will order accelerated hearing. Come and prove your case. That's how that mall opened. It might have suffered the Aba geometric fate. But the nebulous rights that they said they had to the mall, they never went back to trial. All they wanted to do was to stop. But they had one of us behind them. Hopefully not an Egbe member, but clearly a member of the NBA. So, this, for me, is the heart of the matter in the soft infrastructure side. How do we enforce law and order? What value does arbitral awards have amongst us? After we have finished arbitration, are we not the first to file writs to set it aside because we are not satisfied with the result? But every time we do so, know that you are killing business. Know that you are closing the door to employment to the next generation. And so on and so forth. Now, for those who get injunctions and all of that, there's really nothing wrong with injunctions. There's really nothing wrong. But there are set principles on which injunctions should even be considered and the more so granted. If we really read the law and follow those principles, some self-respecting lawyers will say, no, we shouldn't apply for this. It's not necessary. First, irreparable injury. Ask yourself, ask your client, is this injury really irreparable? That is the first hurdle. Then secondly, in real terms, something that damages cannot compensate. And that if damages could compensate it, this defendant cannot pay it. If you really think through it, trials for injunction should not take 5 minutes, really and truly. All of those cases we said, we're just wasting everybody's time. At the heart of the matter is, come, Mr. Ajibade can pay the damages. And between lawyers, they should be able to say, okay, don't give the injunction, we will post a bank bond. Let's move on. Let's hear the case to show that we are not men of straw. I once litigated a matter to the Court of Appeal in Port Harcourt, I think, Port Harcourt Division. It was about a car, a chattel. The principle is clear. You cannot grant an injunction when a chattel is the subject, unless it is a unique chattel. Projo 504, replaceable. But the court granted injunction. So, and the damages that injunctions do really are. But there's nothing wrong with them. Everything is wrong with us. And so I asked my last poser, how many lawyers and judges here have been involved? You know, when injunctions are granted, you now give an indemnity in case it turns out to have been wrongly granted. And we all agree it has been wrongly granted on many occasions. How many trials have there been to enforce that indemnity? How many? I was involved in one, but there was no authority to guide. Ladies and gentlemen, the prospects for economic growth depend on our collective professionalism, and it needs us to help overcome those challenges that stand in the way. As an Egbe of legal practitioners, a lot exists that we can do, including but not limited to: one, enabling law reform, which I have spoken about. Reforming training curriculum of how to incorporate new areas of economic output such as sports and entertainment and tourism. And of course, promoting an efficient dispute resolution process that aids the ease of doing business and removal of legal hurdles to ease construction and delivery of hard infrastructure. These are my thoughts on the prospects and challenges for economic growth with the motion now amended. And I say that the possibilities are enormous, but that we must act deliberately and in collaboration. Thank you very much.
Ẹ bá wa pàtẹ́wọ́ fún àwọn bàbá wa lẹ́ẹ̀kan sí o. Ẹ ṣeun sà, a máa rí yín bá sà. Nígbà tí mo gbé àwọn bàbá wa gómìnà àná dìde, wọ́n ní àwa kọ́ la gbé àwọn wá síbí, pé a pe àwọn wá síbí ni. Gómìnà, ẹ má bínú sà. Ìgbà tí àwa kọ́ ẹ̀kọ́ Yorùbá títí wa, àwọn akẹgbẹ́ yín, àwọn ẹ̀gbọ́n mi Kúnlé Adégòkè, wọ́n ti kó ìwé kúrò ńlẹ̀. Èyí tó kù ni àwárí kà ní èdè Yorùbá. Mo fi tọ̀wọ̀tọ̀wọ̀, mo fi kí àwọn bàbá wa tí wọ́n ṣẹ̀ṣẹ̀ wọlé dé. Mr. Fẹ́mi Fálànà, Senior Advocate of Nigeria, ẹ jọ̀ọ́ ẹ bá wa pàtẹ́wọ́ fún wọn. Ẹ bá wa kí wọn kú àbọ̀ sí orí ètò wa yìí. Láì fi àkókò ṣòfò, mo fẹ́ pe akọ̀wé ẹgbẹ́ àwa amòfin, Mr. Adesina Adegbite, kí wọ́n wá sí apá ibi tí mo wà yìí láti wá fún wa ní ọ̀rọ̀ ṣókí láti ọ̀dọ̀ ààrẹ àwa ẹgbẹ́ amòfin Nàìjíríà. Ẹ bá wa pàtẹ́wọ́ fún wọn.
Mo kí gbogbo àwọn àgbààgbà ẹgbẹ́, gbogbo àwa ọmọ ẹgbẹ́, àwọn ọ̀rẹ́ ẹgbẹ́ tán wá láti òkè ọya àti òkè òkun. Inú mi dùn láti wà níbí. ẹ gbọ́ bí ọ̀rẹ́ mi chairman Ìkẹjà ṣe sọ. Wọ́n ní kí àwọn tó jẹ́ olórí ẹgbẹ́ amòfin ní Nàìjíríà, who is the president of the bar, kó wá fi ọ̀rọ̀ bá wa lò. Àmọ́ ṣe mọ̀ pé mi kọ́ ni olórí, akọ̀wé lèmi. Olórí dẹ̀ nìyí, òkè ọya ló ti wá, kò gbọ́ Yorùbá. So since ó yẹ pé mo fẹ́ sọ̀rọ̀ ní on behalf of olórí tó bá wà níbí kò ní sọ Yorùbá because kò gbọ́ èdè Yorùbá. So ẹ ní láti foríjì mi pé mo ní láti sọ ọ̀rọ̀ olórí ní èdè Gẹ̀ẹ́sì. So being here this morning at this point in time is to actually deliver a goodwill on behalf of the NBA president. And by the grace of God, as the General Secretary of Nigerian Bar Association, who you all has donated to represent you as the General Secretary of the only body of lawyers in Nigeria, the umbrella body of all lawyers in Nigeria. It is important that I let you know that the Nigerian Bar Association feels very proud of the good things that are happening at this point in time in the Egbe Amofin Oodua. I thought we should clap for ourselves. We know that for a long time, we never had a very organized system that we have in place right now in the leadership of Egbe Amofin. But to the glory of God and a very strong, determined effort of the leaders of Egbe, we were able to put in place what we have now as the executive, the governing council that are piloting the affairs of the Egbe Amofin. And they are doing so well. The Nigerian Bar Association is highly proud of this leadership. Nigerian Bar Association is highly proud of Egbe Amofin. And I am personally very proud that I'm a member of Egbe Amofin. Because if you have an Egbe that is supposed to be a subgroup under the Nigerian Bar Association that is in disarray, that is in disharmony, that is disorganized, certainly it will also affect negatively the Nigerian Bar Association as a body. And that is why we will always support all these subnational organizations, associations, particularly the Egbe Amofin, the Eastern Bar Forum, and the Arewa Lawyers Forum, who have been doing the association very proud with all they are doing at various regional levels. This is the second Egbe Amofin National Conference. And I'm happy that it is under my tenure as General Secretary of Nigerian Bar Association that the very first conference of this Egbe took place in Ibadan last year. And the second one is taking place in Lagos this year. I believe strongly that the third one will be greater than this. I understand that over 500 people registered for this conference. And I learned that somebody spoke to me, a senior advocate spoke to me last night, that the NBA need to come and learn from Egbe how to do cocktail. I was in Abuja, and that they wish I was here to come and see what was happening. And I felt so proud, felt so happy that I could be advised to come and learn from Egbe on how to do cocktail. So that means that the cocktail was wonderful. It means the cocktail was colorful and was very fantastic. Can we please clap for ourselves for that wonderful show? And I'm happy and I'm proud that Egbe is going places. The Nigerian Bar Association will continue to support Egbe and support every other organizations and associations that affiliate with the national body and of course does not contest. I'm happy that the leader of Egbe said here that Egbe does not contest with the Nigerian Bar Association. Egbe is actually a body within the Nigerian Bar Association that exists to support and ensure that promote the interests of members, particularly those of the members of the Nigerian Bar Association who are members of Egbe Amofin. That is how it should be. And that is what I believe should be done in all of these other forums and associations that are affiliates of Nigerian Bar Association. We will continue to encourage that we remain united as Egbe Amofin, that we remain strong in our determination to achieve that viral, strong, and strategic forum that will give leadership to its members, both within and of course in the affairs of the Nigerian Bar Association at large. I thank you all for coming, and on behalf of the President of the Nigerian Bar Association, let me especially appreciate our keynote speaker for the wonderful presentation, for the insightful presentation, and for the great, analysis of what he underwent and what actually took place in those 8 years of his experience as Minister of Power and, of course, even of Works. Thank you so much, sir, for your service, first to Lagos State for 8 years and another 8 years to Nigeria. I believe Nigeria still needs you more later. Thank you so much for coming.
Ẹ bá wa pàtẹ́wọ́ fún àwọn akọ̀wé wa. Àwọn akọ̀wé wa wọ́n ti pẹ́ ní Àbújá, wọn ò gbọ́ èdè wa mọ́. Ọlọ́run ó dáríjì wọn o. Mo fi àkókò yìí kí àwọn bàbá wa Fẹ́mi Fálànà, Senior Advocate of Nigeria, káàbọ̀ sí orí ètò wa ilé ẹ̀kan sí ẹjọ́, ẹ bá wa pàtẹ́wọ́ fún wọn. Mo fẹ́ fi wákàtí àtẹ̀wọ̀ yìí pé Ààrẹ Ọlágúnjú kí wọ́n wá bá wa ṣe òyìnbó presentation ti sápá mi lórí o. Kí wọ́n bá wa fi ìmoore hàn, ẹ̀mí ìmoore hàn.
Kí n tó fi ẹ̀mí ìmoore hàn, ẹ̀yin àgbàlagbà Yorùbá ní pé tọmọ ẹni bá lóore orí a máa yá ni. Màá fẹ́ pe àwọn àgbàlagbà tó wà níbí náà káwọn náà máa bọ̀. Ọ̀gbẹ́ni ẹ̀gbọ́n wa Fẹ́mi Fálànà, ẹ máa bọ̀. Àwọn ẹ̀gbọ́n mi tó ń jókòó tira wọn tí wọ́n rẹ́rìn sí mi, Túndé Ajíbádé àti Olúmíwà Akínbóró, ẹ̀yin náà máa bọ̀. Bàbá wa olóyè àgbà Fásí Yusuf, ẹ̀yin náà bọ̀ sá. Igbákejì mi nínú ẹgbẹ́ amòfin pàtàkì Olúwatóyìn Fáṣọ̀run, ẹ máa bọ̀. Adétúnjí Ọ̀ṣọ́, akọ̀wé, ìwọ náà dà, tí ó wà ń bẹ̀ yẹn. Adétúnjí Ọ̀ṣọ́, ó gba kọ́nà wa ní ọ̀nà lélẹ̀ ọ̀nà wà bẹ́ẹ̀ yẹn. ẹ ṣe ìwọ́dà nígbà tí ẹ̀gbọ́n wa ń ṣe àlàyé lẹ́ẹ̀kan lórí iṣẹ́ ta ní kí wọ́n ṣe wọ́n ṣe motion kan ex parte náà ṣe pé ká yí ọ̀rọ̀ yẹn padà mo fẹ́ wò pé kí ló tún fa ex parte order tí wọ́n grant wọ́n ti ẹ̀ dúró ká grant ẹ̀ náà fi approve ẹ̀ ṣùgbọ́n nígbà tí wọ́n ń ṣàlàyé fún wa ẹ rí i pé wọ́n sọ àléébù tó wà lára àwọn ẹgbẹ́ amòfin ilẹ̀ Nàìjíríà lórí bá a ṣe máa ń ṣe bá a ṣe máa ń kó bá ọrọ̀ ajé wa inú wa dẹ̀ dùn pé ẹ̀gbọ́n wa yìí wọ́n ṣe nǹkan tó tọ́ sí nǹkan tá a gbélé wọn lọ́wọ́ níṣẹ́ mò ń wò pé ìwọ Ọlọ́run ọpọlọ arákùnrin ti wá pẹ́ tó bá ìwọ Ọlọ́run ẹ̀gbọ́n wa Ọlọ́run á tún máa bùkún yín sà ọpọlọ yín ò ní jọba sà ẹ pẹ́ fún wa ẹ rántí pé ká tó bọ́ sí ìpàdé àjọsọ̀rọ̀ pọ̀rọ̀ Nàìjíríà èmi àtúmọ̀ra jù báyìí lọ sà ẹ kó àjẹpẹ́ o páàtì ẹ̀ pè yín pé dá wa lóhùn a dúpẹ́ lọ́wọ́ yín àwọn gbogbo ẹgbẹ́ pátápátá wọ́n dúpẹ́ lọ́wọ́ yín a lówó láti fún yín àti ẹ̀ ní ẹ rí i pé gbogbo wa táwa ń bí gómìnà gbogbo wa táwa ń bí àti ìṣe gómìnà rí lẹ́yìn ká lọ kóòtù ká dé so a lówó láti fún yín a ní kankan láti fún yín ju pé nǹkan ráńpẹ́ yìí lórúkọ ẹgbẹ́ lórúkọ àgbààgbà ẹgbẹ́ wọ́n ní kí n fún yín wọ́n ní kí n kí yín ẹ ṣe ẹ dúpẹ́ sà. ẹ ṣe gan ni.
ẹ jọ̀ọ́ owó tí mo fẹ́ fún ọ̀gá torí àwọn olè mi ò ní lè fún wọn bí a máa lọ fún wọn níbi tó yẹ.
ẹ ṣe ẹ jọ̀ọ́ ẹ bá mi fún àwọn bàbá wa látẹ̀wọ́ lẹ́ẹ̀kan sí. mo fẹ́ fi àkókò ìkí ọ̀rẹ́ wa Mr. Chukwuka Ekwazon, Senior Advocate of Nigeria. wọ́n ló ti pẹ́ tán ti wà ń bí ẹ káàbọ̀. ẹ̀gbọ́n mi Distinguished Senator of the Federal Republic of Nigeria, Mr. Dr. Ajibola Bashir, for a goodwill message.
Ọlọ́run yọ Ṣèyí ó kọ́kọ́ pè mí ní Mr. mi ò bá ti dìde torí dókítà tí mo gbà ni kì í ṣe titolóyè. Mo kí ọ̀gá wa gómìnà ní ìpínlẹ̀ Èkó nígbà kan rí àti mínísítà fún ìjọba orílẹ̀-èdè Nàìjíríà Babátúndé Rájí Fáṣọlá amòfin àgbà orílẹ̀-èdè. Mo kí ọ̀gá wa nínú iṣẹ́ òfin àti iṣẹ́ ajàgbàgbára tí èèyàn bá ti bá èwe jẹ wọ́n ẹ fi oyè sí orúkọ wọn àtọmọdé àtàgbà wọn ní Fẹ́mi Fálànà àtẹnitọ́sẹ̀ bí mi ò gbọ́ kán sọ pé ṣì Fẹ́mi àbí kán pe Fẹ́mi bí o. Mo kí alága ẹgbẹ́ wa ẹgbẹ́ amòfin olóyè làwọn àwọn òun ṣe alájàgbàgbara olóyè Abíọ́lá Ọlágúnjú. Mo kí igbákejì wọn náà amòfin àgbà làwọn náà ìyáàfin Báṣọ̀run. Mo kí ẹni tó jẹ́ alága ìgbìmọ̀ tẹ̀kótó tó ṣe ètò ìgbékalẹ̀ àpéjọ ro títí òní. Ẹ̀gbọ́n ló jẹ́ fún mi, àmọ́ mo ti ń wo àwọn amòfin tí mo fẹ́ jẹ́ kí wọ́n bá mi gbé lọ sílé ẹjọ́ lórí ìfẹ̀sùnkanni tí èèyàn ò ṣe. Àmọ́ mo ṣe ń wolẹ̀ báyìí ó dàbí pé kọ́lọ̀ máa yẹ kéèyàn fi ẹjọ́ ìkà sun ìkà lókù báyìí kó wọ́n lọ di wípé ẹjọ́ òwò. Ọ̀gbẹ́ni Kúnlé Adégòkè amòfin àgbà àti igbákejì wọn tí wọ́n jẹ́ ẹ̀gbọ́n wa Fábùnmi amòfin àgbà. Mo wá kí òkòlù amòfin àgbà tó wà ń kalẹ̀. Tí èèyàn bá wọnú gbọ̀ngàn tá a jókòó sí, òfin tó wà ń bí ní ọpọlọ ẹnìkọ̀ọ̀kan tá a bá fẹ́ máa kó jáde, tá a bá tó a kọjá Badagry, a dé Kútọ́nù, a dé Togo. Tí a bá ní lórúkọ wa yóò pẹ́, àmọ́ a kí gbogbo wa. Inú mi dùn láti darapọ̀ mọ́ wa níbi àpérò ẹgbẹ́ amòfin ilẹ̀ Yorùbá. Mo sì fẹ́ sọ wípé mo jẹ àǹfààní nípa ìdánilẹ́kọ̀ọ́ pàtàkì tí gómìnà wa ṣe. Oríṣiríṣi ọ̀nà ni a fi ń wo nǹkan, ọ̀nà ìgbà tí wọ́n fi gbé ọ̀rọ̀ kalẹ̀. Èmi gan gbọ́dọ̀ jẹ́wọ́ wípé mi ò fojú wò pé bó ṣe yẹ kéèyàn fi ojú wo ọ̀nà náà nìyẹn. Àmọ́ mo dúpẹ́ wípé amòfin Ọlágúnjú ti sọ wípé agbára wo ò ká láti san owó iṣẹ́ fún wọn. Ọlọ́run á san yín ní ẹ̀san dáadáa. Ọ̀rọ̀ orílẹ̀-èdè wa ó ṣe pàtàkì kí a mọ̀ wípé àwa tí a jẹ́ amòfin a lè jẹ́ kó gún, a sì lè má jẹ́ kí ó gún. Ó ṣe ní láàánú tó bá yẹ pé ọ̀rọ̀ nípa títara la jẹ́ kí ó ṣe pàtàkì ju ọ̀rọ̀ ìdàgbàsókè lọ. Omi á fẹ́rẹ̀ bọ́ lójú èèyàn tí wọ́n bá rí wípé àwọn iṣẹ́ ìdàgbàsókè tí a mú iṣẹ́ wọ orílẹ̀-èdè, tí a mú ìdàgbàsókè, ó jẹ́ wípé a kò dé bá wọn nítorí wípé àwọn kan ń lo ọgbọ́n àlùmọ̀kọ́rọ́ yìí àti òfin tí ò sí ń bẹ̀. Eléyìí tí mo fẹ́ rọ̀ wá ni wípé wọ́n sọ kíní kan lédè òyìnbó, wọ́n pè ní elite consensus, pé àwa tá a tiẹ̀ jẹ́ alákọ̀wé tá a jọ̀gá, ẹ jẹ́ ká rò wípé ìdàgbàsókè orílẹ̀-èdè ẹ jẹ́ kó jọ wá lógún. Bóyá a jẹ́ amòfin ni o, bóyá a jẹ́ olóṣèlú ni o, bóyá a jẹ́ olùdásẹ́sílẹ̀ ni o, bóyá a jẹ́ olùtajà ni o, tí orílẹ̀-èdè ò gbà dàgbàsókè, a tàbára lé, a tàbá ara oko. Ó di wípé oníkálukú ló ti ní ọmọ ogun títí ẹ̀. Oníkálukú à ń gbàdúrà wípé Ọlọ́run má jẹ́ kí a ṣẹ̀wọ̀n. Ilé tá à ń kọ́ fúnra wa ń sìn, ó fẹ́ jẹ́ wípé ẹ̀wọ̀n gan dáa ju ilé tá à ń ká lọ. Àwọn ọmọ tí à ń bí, tí à ń rò wípé à ń rán lọ sí ilé ìwé ńláńlá lókè òkun àti níbí, ọmọ mẹ̀kúnnù tí ò bá rẹ́kọ̀ọ́, tí ò ní àǹfààní, k'Ọlọ́run kó ṣàánú wa, kó má jẹ́ pé àwọn ni ó jẹ́ kí ọmọ tí a bí kó má lọ dá wọn ní ègbodò. So eléyìí tí wọ́n ṣe kókó tí mo rí mú tí mo fẹ́ fi bá a sọ̀rọ̀ wípé ẹ jẹ́ ká rò ó dáadáa wípé ìdàgbàsókè kò ń ṣe wípé ká kó owó gọbọi sí àpò wa, àmọ́ wípé kí ìdàgbàsókè kó wà fún mùtúmùwà àtọmọdé àtàgbà kí ìlú kó lè rọrùn fún wa. Inú mi dùn láti darapọ̀ mọ́ àpérò yìí. Mo sì nígbàgbọ́ wípé gẹ́gẹ́ bá a sì bẹ̀rẹ̀ sí ní gbọ́ ẹ̀kọ́ ní ọ̀rọ̀ tá a kọ́kọ́ gbọ́, nígbà tá a máa kúrò níbí, ọ̀pọ̀ ọgbọ́n, òye àti ìmọ̀ á jẹ́ àlékún fún gbogbo wa. Ẹ ṣé gan, mo dúpẹ́.
Ẹ ṣé gan ni. Ẹ jọ̀ọ́ a kí àwọn bàbá wa, Senator of the Federal Republic of Nigeria, Adeniyi Adegbonmire, ẹ bá wa pàtẹ́wọ́ fún wọn, Senior Advocate of Nigeria. Mo fẹ́ kí arábìnrin wa náà Èrèlú Oyinkan Bádéjọ Òkúsànyà, mo rí wọn tí wọ́n wọlé mi mọ̀ bí wọ́n ṣì wà nílé. Ẹ káàbọ̀ sórí ètò wa yìí. Mo fẹ́ kí ẹ̀gbọ́n wa Ọ̀gbẹ́ni Adébáyọ̀ Harun tí wọ́n wá bí lẹ́ni láti wá represent Attorney General wa ní ìlú Èkó ń bí. Ọ̀gbẹ́ni Adébáyọ̀ Harun, ẹ jọ̀ọ́ ṣe wà nulẹ̀ ń bí. Ẹ ta kété sọ́dọ̀ wa ní àyín. A kí gbogbo àwọn National Executive Committee NBA Nigerian Bar Association tí wọ́n wà ní inú ilé pẹ̀lú wa níbí. Mr. Harun, ẹ jọ̀ọ́ ẹ máa bọ̀ kí wá bá wa ṣe àṣekágbá ọ̀rọ̀ ìyànjú ní òwúrọ̀ yìí. Ẹ ṣeun.
Wọ́n ti fún mi ní ìmọ̀ràn pé Yorùbá ní kí n fi sọ̀rọ̀. Mo dúró ní ọ̀sán yìí láti kí gbogbo ilé. Mo fẹ́ kí gómìnà Èkó tẹ́lẹ̀tẹ́lẹ̀ rí, Mr. Babatunde Raji Fashola, tó jẹ́ ọ̀gá fún àwa. Mo fi tọ̀wọ̀tọ̀wọ̀ fi kí gbogbo àwọn àgbà ẹgbẹ́ tó wà níjókòó. Mo dúró lórí àga tí wọ́n ti fi sílẹ̀. Mo dẹ̀ kí gbogbo wa pé a kú àbọ̀ sí ìlú Èkó. Ẹ jẹ́ kí wọ́n kọ́ tọrọ àforíjì wípé Honorable Attorney General ò lè wá síbí lẹ́nìí. Iṣẹ́ tí a gbélé wọn lọ́wọ́ ló fà á tó yẹ pé wọn ò lè fi yọjú sí wa. But wọ́n ní kí jíṣẹ́ fún gbogbo ilé wípé ohun tí a ń ṣe lẹ́nìí, ohun tí àwọn náà fi ara mọ́ ni. And ní ìpínlẹ̀ Èkó a ti ń ṣe takuntakun sí àti rí pé administration of justice ó sún síwájú ju bí a ṣe bá lọ. Tí a bá rántí láìpẹ́ yìí, a ṣe àpérò lórí bí a ṣe máa lo administration of justice láti jẹ́ kí ọ̀pọ̀lọpọ̀ nǹkan kó improve. Èyí tí a ń ṣe lẹ́yìn náà, àánú àtúnkọ́ ẹ̀kọ́ díẹ̀ ń bẹ. A dẹ̀ wò pé níta bá mú kúrò níbí lẹ́nìí, á pẹ̀lú tí àánú tún máa lò láti make sure pé a tẹ̀síwájú. Mo fẹ́ kí àwọn tó kù lẹ́yìn lórí pépà tí ọ̀gá wa deliver. Èmi náà jẹ́ èèyàn kan tó gbọ́ díẹ̀ nínú ẹ̀, and èmi ò wà surprise pé irú ẹ̀ jáde láti ẹnu wọn. Torí nígbà tó jẹ́ gómìnà Èkó, táàsì tó máa ń fà wá ní pé ohun tó bá fẹ́ ṣe o gbọ́dọ̀ ṣe kí káwọn èèyàn mọ̀ pé o ṣe. A dúpẹ́ púpọ̀ lọ́wọ́ yín sà. Ọlọ́run ajá tún máa rí yín bá. In conclusion, ẹ má bínú pé a tún fi òyìnbó díẹ̀ sí i. Lákòótán, kí gbogbo wa ń pé a kú àbọ̀ sí ìlú Èkó. Ìlú Èkó ó jẹ́ ìlú tí èèyàn ti máa ń kọ́ ọgbọ́n. Àdẹ̀wò pé tẹ bá kó bílẹ̀ ní, tẹ bá ti kọ́ nínú ọgbọ́n mú lọ, á tún wúlò fẹ́yìn náà bí tẹ bá ti ń bọ̀. A dúpẹ́ púpọ̀ púpọ̀.
Ẹ ṣeun. Lẹ́ẹ̀kan sí mo kí gbogbo wa pé a káàbọ̀ sí ìlú Èkó, pàápàá jùlọ sí agbègbè Ìkẹjà. Torí tó o bá wá sẹ́kọ̀ọ́ tó o bá tí ì dé Ìkẹjà, o ò tí ì dé ìlú Èkó. Ẹ káàbọ̀. Ayẹyẹ yìí a máa kásẹ̀ ńlẹ̀. A lọ fún ìdánudúró fún bíi 15 minutes. Ìṣẹ́jú márùndínlógún. Ìṣẹ́jú mẹ́ẹ̀ẹ́dógún. A lọ fún ìdánudúró fún bí ìṣẹ́jú mẹ́ẹ̀ẹ́dógún láti mú ètò ayẹyẹ ìbẹ̀rẹ̀ ètò yìí wá sí òpin. Mo kí wa kí àbọ̀ lẹ́ẹ̀kan sí. Ẹ ṣé, a dúpẹ́.
Ní báyìí a ó ṣe àwẹ̀jẹwẹ̀mu ráńpẹ́ léyìí tí a ó fi para wa lẹ́nu dà kó tó di wípé a ó bẹ̀rẹ̀ sí ní máa bá ètò ìdánilẹ́kọ̀ọ́ lọ ní rẹpẹtẹ. Ọ̀gá yóò wù wá kẹ́ ẹ bá wa kópa nínú jíjẹ mímu yìí o. A ní ògì, a ní mọ́ínmọ́ín, ní àwọn oúnjẹ. Ẹ jẹ́ kí ìyá olóúnjẹ wa kó wa.
Ká san gbogbo ilé, a ní oúnjẹ òwúrọ̀, a ní ọ̀lẹ̀ àti ògì, a ní tapioca àti àkàrà, a ní ọ̀jọ̀jọ̀ àtẹ̀kọ, a ní búrẹ́dì àti ata dídì ìbílẹ̀, a ní púpọ̀ nínú àwọn oúnjẹ ìbílẹ̀. A dẹ̀ máa fẹ́ kẹ́ wá bá wa taste.
Ẹ ṣeun o.
All right.
Má jẹ́ mọ̀yà láyé o. Má jẹ́ mọ̀ṣì láyé o. Má bá fọ̀nà hàn mí o. Ẹ̀dá mi yé o jàre. Kémi máa mọ̀yà bàbá o. bàbá fọ̀nà hàn mí o ẹ̀dá mi o bàbá kémi máa mọ̀ṣì láyé mi bàbá fọ̀nà hàn mí o ẹ̀dá mi o bàbá bàbá o bàbá o gbà mí lọ́wọ́ ọ̀tá o ẹ̀dá mi o jàre kémi má ṣìnà láyé o. Orí mi o dákun fọ̀nà hàn mí o ẹ̀dá mi yóò jàre bàbá fọ̀nà hàn mí o. Orí mi mo lọ́rọ̀ láti bá ẹ sọ. Ẹ̀dá mi mo lọ́rọ̀ láti bá ẹ sọ. Mo bá tètè la. Kẹ́gbẹ́ ọlọ́lá máa pè é rán níṣẹ́. Orí mi mo lọ́rọ̀ láti bá ẹ sọ. Orí mi mo lọ́rọ̀ láti bá ẹ sọ. Ẹ̀dá mi mo lọ́rọ̀ láti bá ẹ sọ. Orí jẹ́ kí n lówó, orí jẹ́ kí n bímọ. Orí jẹ́ kí n lówó, orí jẹ́ kí n bímọ. Orí jẹ́ kí n lálàáfíà o. Oògùn ọrọ̀ àlàáfíà ní bàbá. tá a bá ń bẹ léwe ó yẹ ká ṣe bí èwe. nígbà tá a bá ń bẹ léwe ó yẹ ká ṣe bí èwe. àmọ́ ká tẹpá mọ́ṣẹ́ ká ṣiṣẹ́ owó ká sì tún hùwà rere. iṣẹ́ orin kíkọ pẹ̀lú ìlú lílu ìyẹn ni iṣẹ́ tiwa. iṣẹ́ orin kíkọ pẹ̀lú ìlú lílu ìyẹn ni iṣẹ́ tiwa. alùlù títí agbére d'Amẹ́ríkà Amẹ́ríkà ìlú ọba. alùlù títí agbére d'Amẹ́ríkà Amẹ́ríkà ìlú ọba. ní ìlú Amẹ́ríkà adé Philadelphia New York City Washington DC pẹ̀lú Chicago gbogbo ẹ̀ ààrẹ tẹ̀pá ní. Amẹ́ríkà adé Philadelphia New York City Washington DC pẹ̀lú Chicago gbogbo ẹ̀ ààrẹ tẹ̀pá ní. gbogbo ènìyàn pátápátá tí wọ́n ṣàpọ́nlé wa tí wọ́n yẹ wá sí tán ṣe ìtọ́jú wa ní ìlú Amẹ́ríkà. Abíọ́lá mi o bí ọlọ́run mọ̀rọ̀ Ògúndòkun ìwó nílé nílé Odídarẹ́ Odílérò ní tèmi àtàtà. Ọlátúnjí mi o Látúnjí African Art Center ọlọ́lá èèyàn pàtàkì ni Sulaimon mi o ọmọ Ahmed mi Tóyìn Òbé o Àkúrẹ́ nílé mo ṣe ọmọ Lágẹ̀ṣin pẹ̀lú ọmọ Lágẹ̀ṣin o ọdún nílérò ní tèmi pẹ̀lú Kazeem mi o ọmọ Òdúwọlé gbogbo yín lẹ ṣeun Yínká Johnson àtẹni tó kù lẹ́yìn jẹ́ ò lè dárúkọ pẹ̀lú New York City mélèé gbàgbéra lọ́lá ẹni pàtàkì ẹni ọlọ́lá ẹni pàtàkì ni Jọkẹ́ mi o màmá rà báyọ̀ mímí Jọkẹ́ mi o màmá rà báyọ̀ mí ọmọ olówó tàǹbù ọmọ olówó tàǹbù.
Ó yẹ kájọ ṣàṣàrò ló dára káfínú inú káfíkún lókun kí Nàìjíríà ó lè tẹ̀síwájú. Ogun ọ̀tẹ̀ yìí ti tó kágbàgbé ìjà ẹlẹ́yàmẹ̀yà Haúsá Ìgbò pẹ̀lú Yorùbá ṣe láṣàjọjì ìjà òmìnira ni a tún bára wájà èdìrẹ ogun èṣù yìí gbé kájọ gbé. Ó yẹ kájọ gbé kémi gbé. Ó yẹ kájọ gbé Yésù kémi gbé. Nàìjíríà yìí ti gbogbo wa kó máa gbọ́dọ̀ bàjẹ́ ló ṣe lógo. Olúwa ló gbé mi ló yàn mí wá. Gbogbo àwọn àyànfẹ́ ló ṣe lógo. Olúwa ló gbé mi ló yàn mí wá. Gbogbo àwọn àyànfẹ́ ló ṣe lógo. Kìtàkìtà rán o. Kìrìkìrì rán o. Kìtàkìtà rán o. Kìrìkìrì rán o. Orí ló pọ́n lákọni, orí ló pọ́n lákọni. Ẹ̀dá mi bí tèmi kò mí, má jẹ́ sí wọn wáyé. Orí mi má jẹ́ sí wọn wálé ráyé lásán lásán. Ẹ̀dá mi má jẹ́ ṣàkó bàtà fún ẹgbẹ́ mi. Torí kìtàkìtà rán o. Kìrìkìrì rán o. Kìtàkìtà rán la. Kìrìkìrì rán o. Orí ló pọ́n lákọni, orí ló pọ́n lákọni. Ẹ̀dá mi pín tèmi kò mí, má jẹ́ sí wọn wáyé. Èmi ti gbóhùn Olúwa tó wí pé. Wá wá arákùnrin o, ìyẹn nínú ọgbà àjàrà Olúwa rẹ̀ kò sì máa kọrin. Wá wá arákùnrin o, dìde nínú ọgbà àjàrà Olúwa rẹ̀ kò sì máa kọrin. Ayé lè máa ṣátá. Ábà. Ṣe búburú tàbí mo ṣe rere, ẹ̀rí ọkàn mi máa lò fẹ́lẹ́ yìí hàn. Ẹ̀rí ọkàn mi jọ̀wọ́ dá mi láre. Mo lẹ́nìkan tí wò mí tèmi kò rí o. Oníkan lólùfẹ́ wo ìlera yé mi o. Àti lọ àti bọ̀ lọ́wọ́ ẹ̀ ló máa wà. Bí mo ṣe búburú tàbí mo ṣe rere, ẹ̀rí ọkàn mi máa lò fẹ́lẹ́ yìí hàn mí o. Ẹ̀rí ọkàn mi jọ̀wọ́. ṣe búburú tàbí mo ṣe rere, ẹ̀rí ọkàn mi máa lò fẹ́ lẹ́yìn hàn. Ẹ̀rí ọkàn mi jọ̀wọ́ dá mi láre. Mo lọ́rẹ̀ẹ́ kan tí wò mí tèmi kò rí. Mo lọ́rẹ̀ẹ́ kan tí wò mí tèmi kò rí. Bí mo ṣe mú mi, bẹ́ẹ̀ ló mú mi. Bí mo ṣe rìn, bẹ́ẹ̀ ló rìn. Bí mo ṣe jẹun, bẹ́ẹ̀ ló jẹun. Bí mo ṣe sọ̀rọ̀, bẹ́ẹ̀ ló sọ̀rọ̀. Òjìji ayé wa, òjìji ayé wa lólùbẹ̀ òun tá a ṣe. Òjìji ayé wa, òjìji ayé wa lólùbẹ̀ òun tá a ṣe. Òjìji ayé wa, òjìji ayé wa lólùbẹ̀ òun tá a ṣe. Ìwọ́n tó jáwé sẹ́nu lójú odi, ó tún dágun lára láìsàn. Ó ń ṣe lákáláká lójú arọ, òkùnkùn pọ̀ mọ́ kẹ̀lẹ́bẹ̀. Ó ní ká fojú wa mú nǹkan yangan, òjijì wò ó. Bàbá ka mímọ́ wọn nínú oníṣẹ́ rere. Bàbá ka mímọ́ wọn nínú oníṣẹ́ rere. Má jẹ́ kú kí n tó kú, má jẹ́ fara gbàrúwẹ̀. Má jẹ́ kú kí n tó kú, má jẹ́ fara gbàrúwẹ̀. Má jẹ́ bá bàbá kà mí mọ́ wọn nínú oníṣẹ́ rere. Bàbá kà mí mọ́ wọn nínú oníṣẹ́ rere. Má jẹ́ kú kí n tó kú, má jẹ́ fara gbàrúwẹ̀. Má jẹ́ kú kí n tó kú, má jẹ́ fara gbàrúwẹ̀. Má jẹ́ bá wọn dòdò láì pọ́n mi lè má lè ṣe mí láṣẹ pé. Má jẹ́ kí rẹ̀ ṣe kó dènà àdúrà mi. Ṣe mí láṣẹ pé, ṣe mí láṣẹ pé. Bàbá mo ké pé ẹ ò dá mi lóhùn, ṣe mí láṣẹ pé. Ṣe mí láṣẹ pé, ṣe mí láṣẹ pé. Bàbá mo ké pé ẹ ò dá mi lóhùn, ṣe mí láṣẹ pé. Ohun tó le kó ń bọ̀ wá dẹ̀rùn, àṣà ti gbẹ́kẹ̀ lÓlúwa ọba. Ṣe mí láṣẹ pé, ṣe mí láṣẹ pé. Bàbá mo ké pé ẹ ò dá mi lóhùn, ṣe mí láṣẹ pé. Bá òkú rí ṣèrò tán, ẹni bá kú ló parí ohun gbogbo láyé. Ṣe mí láṣẹ pé, ṣe mí láṣẹ pé. Bàbá mo ké pé ẹ ò dá mi lóhùn, ṣe mí láṣẹ pé. Òwúrọ̀ la wà, ọba kó ṣọ́ wa dalẹ̀. Ṣe mí láṣẹ pé, ṣe mí láṣẹ pé. Bàbá mo ké pé ẹ ò dá mi lóhùn, ṣe mí láṣẹ pé. Ṣe mí láṣẹ pé, ṣe mí láṣẹ pé. Bàbá mo ké pé ẹ ò dá mi lóhùn, ṣe mí láṣẹ pé. Bàbá kà mí mọ́ wọn nínú oníṣẹ́ rere. Bàbá kà mí mọ́ wọn nínú oníṣẹ́ rere. Má jẹ́ kú kí n tó kú, má jẹ́ fara gbàrúwẹ̀. Má jẹ́ kú kí n tó kú, má jẹ́ fara gbàrúwẹ̀. Má jẹ́ bá wọn dòdò láì pọ́n mi lè ọ̀rẹ́. Ṣe mí láṣẹ pé. Bàbá mo ké pé ó rè mọ́rẹ́. Ṣe mí láṣẹ pé, ṣe mí láṣẹ pé. Bàbá mo ké pé ẹ ò dá mi lóhùn, ṣe mí láṣẹ pé. Ṣe mí láṣẹ pé, ṣe mí láṣẹ pé. Bàbá mo ké pé ẹ ò dá mi lóhùn, ṣe mí láṣẹ pé. Elédùmarè ló dọwọ́ ẹ. Ṣe mí láṣẹ pé, ṣe mí láṣẹ pé. Bàbá mo ké pé ẹ ò dá mi lóhùn, ṣe mí láṣẹ pé. Èmi rò lọ́ba méjì bí ó ṣe wọ̀rọ̀ Oòduà. Ṣe mí láṣẹ pé, ṣe mí láṣẹ pé. Bàbá merciful God. Ọba tó ṣoore fún mi ṣoore fún ẹ tó ṣoore lójoojúmọ́. Ọba kan wọ́n ti kà lẹ́yìn. Adúró pọ̀ìpọ̀ì lẹ́yìn aṣòótọ́. Kò jẹ́ ronú ibi rárá. The merciful God.
Ẹ jọ̀wọ́ ẹ bá wa wọlé kẹ́ jókòó. Ẹ jọ̀wọ́ ẹ bá wa wọlé kẹ́ fìkàlẹ̀ sí o. A fẹ́ máa bá ètò náà lọ ní pẹrẹu. Àwọn arábìnrin wa tí wọ́n ṣe ètò oúnjẹ tí a jẹ wọ́n ní ká béèrè pé báwo ni oúnjẹ náà. Ẹ ṣé ọ̀gá mi. Ẹ jọ̀ọ́ à ń bẹ gbogbo àwọn èèyàn wa tó wà lẹ́yìn inú yàrá yìí kí wọ́n bá wa súnmọ́ wájú ní àyín. Please. Distinguished ladies and gentlemen, we're enjoining you to please come forward. Come have your seats. We're about to go on with the next session. And I'll be handing over this mic to my friend, Mr. Bidemi Ademola Bello. Thank you very much. Please, can we please have our seats? Thank you.
Mo kí wa káàbọ̀ sí àpéjọ òní, ẹ̀yin bàbá wa, ẹ̀yin olùdarí wa, aṣíwájú wa, ẹ̀gbọ́n wa, ẹ̀yin ìyá wa àti àbúrò wa. Inú mi dùn láti kéde ìbẹ̀rẹ̀ ìjíròrò kìíní nínú abala ìjíròrò tí a fẹ́ bẹ̀rẹ̀ ní àpéjọ yìí. Orúkọ tèmi ni Bídèmí Adémọ́lá Bello. Èmi ni màá máa pe àwọn tí yóò jíròrò sí orí ìpele láti jíròrò pẹ̀lú wa. Ẹ jọ̀wọ́ ẹ gbà mí láàyè láti gun àkàbà tí àwọn tí ó tẹ̀lé mi tán ti fi lélẹ̀ torí àkókò wa. Mi ò fẹ́ máa dárúkọ gbogbo àwọn ẹni ńláńlá àti àwọn lọ́ọ̀yà ńláńlá tán wà ní agbègbè wa, tán wà láàrin wa lénìí. Àwọn agbẹjọ́rò àgbà tó wà láàrin wa. Ẹ ṣeun. Mi ìbá fẹ́ máa tẹ̀síwájú ní èdè Yorùbá, ṣùgbọ́n nítorí àwọn àlejò wa tán wá láti òkè òkun, tán wá láti àwọn apá yòókù nínú orílẹ̀-èdè wa yìí, màá fẹ́ tẹ̀síwájú ní èdè Gẹ̀ẹ́sì. Nítorí náà mo bẹ̀bẹ̀, mo tọrọ gáfárà kí ẹ gbà mí láàyè láti tẹ̀síwájú ní èdè Gẹ̀ẹ́sì. Once again, thank you very much for giving me the opportunity to introduce this distinguished discussion, which is going to be handled by a distinguished panel selected by the organizers. The topic for our discussion in the first discussion panel is restructuring of Nigeria as a tool for economic recovery, the imperatives of history. Now, the synopsis of this discussion can be found at page 22 of the brochure, and permit me to please run through it. Nigeria, as one of Africa's largest economy, faces significant economic challenges, including a heavy reliance on oil export, corruption, and inadequate infrastructure. To address these issues, proponents argue that restructuring the country's political, economic, and administrative system is crucial for economic recovery. Key aspects of restructuring include decentralization, that is, devolving power from federal government to state and local government to promote regional autonomy and development. 2, fiscal federalism, reforming the revenue allocation system to ensure equitable distribution of resources and encourage state-level economic development. 3, constitutional reforms, that is, amending the constitution to address issues like resource control, state creation, and power rotation. 4, economic diversification, promoting non-oil sectors like agriculture, manufacturing, and services to reduce dependence on oil export. 5, institutional reforms, strengthening institutions like the judiciary, electoral commission, and anti-corruption agencies to ensure good governance and accountability. Last but not the least, regional integration, which is enhancing economic cooperation and trade among regions to stimulate growth and development. Successful restructuring can lead to improved economic efficiency and competitiveness, increase regional development and reduce inequality, enhance good governance and reduce corruption, diversified economy and reduce dependency on oil exports, increase investor confidence and foreign investment. However, challenges like political will, resistance from vested interests, and potential social and political instability must be addressed. For extensive restructuring and sustainable economic recovery in Nigeria. That is the synopsis of this discussion. As earlier mentioned, we have a distinguished panel to handle this topic. And the lead person, that is, the lead presenter is none other than very well-renowned Femi Falana, SAN, who is well known for human rights activists, always trying to show empathy for people who are oppressed. Is well known for opposing oppression from successful military authorities and even in some democratic regimes. Welcome once again with a round of applause, Mr. Femi Falana, SAN, as the lead presenter. The second presenter, the second person in this panel is none other than the distinguished Are Muyiwa Akimboro, SAN, one of the forebearers of the Abuja branch. Mr. Akimboro, SAN, has a well-tracked history of serving in different administrative and legal capacities at the NBA. He is a Chartered Institute of Arbitrator of the United Kingdom, a fellow member. He attended Harvard Law School and graduated in 2014. He's been practicing as a legal practitioner in the Nigerian bar from 1990. Permit me once again to welcome Mr. Are Muyiwa Akimboro, SAN, to the panel. Now, this panel will be moderated, and I would like to invite the person of Mr. Adeshino Adegbite, who is actually serving in several capacities. He's been serving in the legal, the Ikeja branch. He served also the Egbe for several years, and is currently serving as one of the executive members of the Nigerian Bar Association. Once again, permit me to welcome with a loud round of applause Mr. Adeshino Adegbite to the panel. Now we have the topic set. We also have the members of the panel ready. We would urge everyone to please pay attention and take points, because there will be question and answer session thereafter. I have the singular honor and privilege to hand over the microphone to the moderator of the session, Mr. Adegbite, to introduce the session formally. Thank you.
Thank you very much, my brother Bidemi Ademola Bello. As Bidemi rightly informed us, this is the first plenary session, and of course, the topic of this session is restructuring of Nigeria as a tool of economic recovery, the imperatives of history. I am happy and highly honored to be the one moderating this session, especially because I have as the speakers two of my very illustrious big brothers and leaders in the profession. I am aware that we're supposed to have Pastor Tuli Bakare also on this session, but he's unavoidably absent at this point in time. I'm not aware he has sent any representative for now. Probably if the person comes in, he will join us. But I understand that the pastor is presently unavailably absent. So we will quickly move into the business of the day. I welcome my leader, my Oga, my Egbon, of course my mentor. Somebody said that they don't put chief before his name. They don't put Are or Egbe Amofin or Balogun. He's simply known as Femi Falana. We also have another name, we call him Enife. Anyway, Enife and in Ikeja, you know, is also known as Authority Falana. So please do justice to the paper.
Thank you. Mr. Moderator of the session, if I knew honestly that this program will start at this point, or my presentation, I would have been in court this morning in the Lagos High Court with my colleague, Dr. Kemi Pinero, and also I actually rejected a brief in which he was also on the other side because of this presentation. Wow. So if I knew that it was going to make the two cases, I would also have wanted to be in court this morning. But on a very serious note, I'm delighted to be in your midst. Inú mi dùn púpọ̀ láti wà láàrin yín lónìí. Fún alága ẹgbẹ́ wa àti àwọn ọmọ ẹgbẹ́, mo kí yín lọ́pọ̀lọpọ̀. Báyìí la máa rí o, àní rí báyìí. But you are going to pardon me because there are non-Yoruba speakers here. And I have some very important points to make that I would like us to engage in cross-fertilization of ideas at the end of my presentation. For that reason, some other time, I would like you to test my knowledge of the Yoruba language. But let me tell you this. The late Chief Gani Fawemi once called on me in my house. I think we're using land phones then. So my young daughter picked it up and said, "Who is speaking, please?" And Chief, in his usual voice, said, "Is that not Femi's house? Somebody speaking Yoruba to me, English to me in Femi's house." And I quickly picked the phone. I said, "My Chief, the Small girl did not know you were the one on the other side. He said, please don't allow your children to speak English in your home. And I said, we have actually prohibited the speaking of English in my home, sir. So very good. Now, I saw many of our people today finding it extremely difficult to express themselves in the Yoruba language. It's not your fault. Many of us now think it is a sign of civilization for your children to speak English. So anybody who come, please greet your uncle. One of my kids asked me one day, how many uncles do I have? I have to greet everybody else. I said, we're trying to mix English with Yoruba language. But if we can go back and prohibit the speaking of English in our homes, it's going to help all of us. Otherwise, the Yoruba language will become extinct. We must learn from. It's our rule of law. And that regime recruited lawyers from some African countries like Ghana and the Caribbean. One of the lawyers that joined the service from abroad, Nigerianized, and later rose to become the Chief Justice of Nigeria. I'm talking of Dan Alexander. He was recruited by Awolowo in a hunting exercise. Many other judicial officers from the West were granted permission to transfer their service to their own states, and some of them later became chief judges. Akinola Aguda Ondo, Craig Ogun State, and so on and so forth. Even though the region currently houses the largest concentration of lawyers in Nigeria, a substantial number among them are not of Yoruba extraction. Some of them are here. The members of the 7 branches of the MBA in Lagos, I think we have 7 now, 5 from Surulere and Etiosa, are drawn from all parts of the. In fact, some of the branches are led by non-Yoruba lawyers. Unlike in the past, when judges were appointed in the region on the basis of merit, it is now a question of state of origin, sons and daughters of the soil. Following the crisis that engulfed the NBA in 1992 in Port Harcourt, the leaders of the legal profession decided rather backwardly that the leaders at the offices, national offices of the association, be zoned along ethnic or regional lines. The Egbe Amofin Oodua Yoruba was founded as part of the Milocom politics of the NBA. Thus, the Egbe Amofin only exists to nominate and support candidates of all Yoruba ethnic group to contest elections in the NBA. Because of the limited agenda of the Egbe, many Yoruba lawyers have distanced themselves from its activities. I just learned this morning that only about 500 lawyers registered for this program. Speaking for myself, I lost interest in the affairs of the Egbe when I found to my utter dismay that its members were only prepared. We're not prepared to defend democracy, human rights, social justice, and of course, the Constitution. I was therefore very, very reluctant to accept this invitation. But for the harassment meted to me, the constant harassment of my friend, Kunle Adegoke SN, I will have politely declined the invitation. However, I changed my mind when I was informed by Adegoke that the Egbe has since found it necessary to address a number of challenges facing the nation and the legal profession. And I think that is why we are discussing economy of Nigeria today. It is hoped that the Egbe Amofin will be reorganized to admit members of the legal profession who hail from other parts of the country but practice law in Yoruba land. Similar clubs of lawyers like Otu Okuwe and Arewa Lawyers Forum should be reorganized in like manner in accordance with Section 43 of the Constitution, which guarantees the right of all Nigerians to settle in any part of the country. The demand is also in consonance with Section 41 of the Constitution and Article 2 of the African Charter on Human and People's Rights, which have prohibited discrimination on the basis of a particular community, ethnic group, or place of origin. Amalgamation of Nigeria. From November 1884 to February 1885, a gang of European merchants held a conference in Berlin where they partitioned the continent of Africa among themselves. Since Britain was allocated the territory that later became known as Nigeria, its army of expedition invaded and attacked the various communities. The colonial army conquered the entire territory in the 1880s because it had superior weapons. Even though the various kingdoms were at different levels of development, the British government amalgamated them and restructured them. Restructure is not a new phenomenon. It started under the colonial regime. They were restructured for the purpose of serving the interests of imperialism. On January 1, 1914, Lord Frederick Lugard, the governor of the Northern Protectorate and the colony, and Protectorate of Southern Nigeria, signed a consolidating document, thereby creating the colony and Protectorate of Nigeria. Of course, you've heard stories about the amalgamation, but there's a myth around the amalgamation document. And some lawyers have said, of some historians, that by the amalgamation document, Nigeria was to exist as a country for only 100 years. And so some people in 2014 were saying we should break up Nigeria because it had expired. I submit with profound respect that nobody has such a document because it does not exist. Colonial regimes do not say we are going to live in 100 years' time. They want to exploit that territory forever if they are allowed. And so there is no document that says the British will be here for 100 years. They are still here, if you must know, and we discuss the economy. They are still in charge of our economy, even though they disappear physically. Thus, when by 1954, I'm sure you are aware, McFarlane Constitution, where the regimes of Awolowo, Zik, and Ahmadu Bello in the western, eastern, and northern Nigeria. Today, what will interest you? And this is very important when you are talking of colonial history. On account of the belief in democratic socialism by the Awolowo regime, free education was made compulsory for primary school children, and also welfare programs were also institutionalized. In fact, how it was, who started, it was that regime that codified minimum wage in the history of Nigeria for the first time. It was also that regime that established a welfare pilgrims board. Not a welfare pilgrims board that will give money or that will give Hajj subsidy. No, it's illegal. My chair. My showroom. In the Holy Quran, the condition for going to Mecca is if you are able physically and if you are able pocket-wise. Nowhere is it stated in the Holy Quran that the government shall sponsor you to Mecca. In the Christian Bible, from Genesis to Revelation, there is no provision for going to Jerusalem. In fact, if not for the war in Gaza, Nigerians will have taken their own subsidy this year to go to Jerusalem. Again, unknown to many of us, the Israelis of today are not Christians. Only 1.9% of Israelis believe in Jesus Christ. So they are always flabbergasted when they see Nigerians trooping that they want to know where Jesus Christ was born, in Bethlehem, or where he has miracles in Jordan, which is now a Muslim country, you know. So I think we need to also read our Bible very well and know that how to reorganize ourselves as lawyers to challenge the sponsorship of pilgrimages in Nigeria. Because by virtue of Section 10 of the Constitution, the state of Nigeria shall not adopt any religion as an official religion, as a state religion. So the government is breaching the Constitution. Now in the First Republic, I'm sure you know the crisis that culminated in the Civil War, the electoral malpractice in the West that dovetailed into a violence, and the pogrom in the North, the killing of the Igbos in the North. So the military came, and for almost 3 decades, all manners of military dictators, including some who were not quite very okay mentally, all of them carried out all manners of experiments with your faith and mine. They will allow election, annul it, and call for another one. But they did a few things, the military dictators, which is to calibrate Nigeria in its own image. And one of the things they did is to corner the resources of Nigeria. They weakened the region. They weakened the states from 4 regions to 12 to 19 to 36 and 774 local. So today, no state, no region can challenge the over-concentration of powers in Abuja. But what has happened over the years? By the time they were living in 1999, they imposed on the country a constitution, a decree, Constitution Promulgation Decree number 24 of 1999. We lawyers and judges have baptized that document. We have christened it the Constitution of Nigeria. It's not the Constitution of Nigeria. It's a decree enacted and signed by General Abdulsalami Abubakar. But our judges, our courts, and our senior lawyers have now said this is the ground norm of the Republic of Nigeria. I call it federal, but I call it the Unitary Republic of Nigeria. The revenue allocation formula is signed by those guys. 52% for the federal government. It used to be 56. 24 for state government and 20 for local government have remained intact since 1999. It has been difficult to persuade any president in Abuja to change the formula, as if that is not enough. There are some agencies of the federal government that also deduct what they call collection cost. Honorable, my senator is there, yes. Collection cost. Customs deduct 7% of what it collects. FRS 4% of what it collects. Directorate of Petroleum now, Upstream Commission, also deduct its own. And about 60 other agencies of the government, including IMANSA, MP, all of them, collect money. They also deduct what they like. So it's the remainder that will now go to the federation account for sharing at the end of the month. As if this is not enough. In the case of AG Bauchi and AG of the federation, the plaintiff went to court since 1999. The proceeds from agencies that make money for government, like the NIMASA, they even collect dollars. MPA, all of you, Central Bank, where are the proceeds? The Supreme Court is centralist court. Centralist. A pro-federal government court said You have not come properly. We have no jurisdiction. Go to the Federal High Court. Now, still on the Federation account, the most serious violation of the account on the economy of Nigeria is the breach of Section 43 of the Constitution. That section provides that the entire property in the control of all minerals, mineral oils and natural gas, in, under, or upon any land in Nigeria, or in, under, or upon the territorial water, shall be vested in the government of the federation, not in the federal government. Because the government of the federation means the three tiers. But the federal government alone has cornered the oil and other mineral resources. And what do they do? There is an illegal ministry called Ministry of Petroleum Resources. There's another one called Ministry of Solid Minerals Development. Controlled by the federal government, no. Since these resources are jointly owned, anybody set up by law to manage them must be jointly owned by the three tiers of government. As if not, it's not enough. The president of Nigeria, since the era of Babangida, will just give out oil blocks and licenses for solid minerals to selected people. You know, you say somebody is the richest woman in Africa, very good. If they give you a block, and without contributing a dime, you just go across, go to the other countries and hawk the license. You become the richest woman. Another man, a retired general, was given an oil block by Abacha. This is public knowledge. He sold his interest and came back home. After putting enough money in the bank for himself, his family, and generations yet unborn, he came out publicly to insult our collective intelligence. That I have $500 million left. I don't know what to do with it. You don't know who I'm talking about? See why? A pensioner say he doesn't know what to do with $500 million after banking about $2 billion. So the point I'm making, I have argued there, it is illegal to take my land, to take the resources of my land, and then give oil blocks to your friend. If you no longer need the oil blocks, you give to the owners of the land. And that is what the land use decree is about, and that is what Section 43 is about. Now, our country is said to be broke. Please, take it from me. Senator, Nigeria is not broke. We are made broke by the government and the policies of the government. One, and I'm just going to give you a few examples where we can raise over $100 billion in 6 months, and people are wasting our lives. The government has said that fuel subsidy is gone. Today, it's now been admitted that in the last 1 year, 5.4 trillion has been spent on importing fuel subsidy. You are not aware yet? You can Google, you get it. It's reported this morning. 5.4 trillion. 2. And why are we importing fuel? Because they collapse our refineries. But the refineries will come on board very soon. Dangote refinery will come. We are also partners of the Dangote refinery. Nigeria is said to have own 20% because when Dangote had problem, Nigeria took a loan of $2.7 billion and gave to Dangote. But beyond that, the land, very expansive area, not a dime was paid for it. They call it free economic zone. You take my land, you give it to somebody else. They have not paid compensation, we're in court. 2, all the machinery were imported, duty free. The entire machines were imported under MFLA official rate. So when they say 20%, we are still going to sit down when that refinery takes off. What is our actual share in that refinery? There is another one. They call it LNG, Nigeria Liquefied Natural Gas. Nigeria has 49%. Nigeria, not the federal government. Because it was established in 1989 when we didn't have the three accounts. It was from the federation account that money was taken. We invested in it. Today we have 49%. In the last 20 years, the $34 billion paid as dividends destined for the federation account have been criminally diverted by the NNPC. I wrote a letter to the Honorable Minister of Finance and Coordinator of the Economy. Please, can you get this money? Since you say you have problem with foreign exchange. I've not got a reply to my letter, and we may be going to the court very soon. The oil companies, for about 18 years, a law was not implemented. The Deep Offshore Inland Production Contracts Act. I started a campaign in 2015. Amend this law. We have lost about $60 billion by the non-implementation of the law. I need to say this. In the Second Republic, Borno, Ogun, and Bendel, Edo and Edo State now, and Delta, were the three leading states using the court to promote restructuring. Under the current political dispensation, Abia, Lagos, and Rivers have used the courts to promote restructuring by litigation. This one, when Rivers, Akwa Ibom, and Bayelsa knew about the campaign, they went to the Supreme Court. Please, give Nigeria its due for the past 18 years. In a judgment delivered in October 2018, the Supreme Court ordered the federal government go and recover the royalties of 18 years. Following that judgment, the federal government hired a team of auditors, audit firms, and they came up with a figure of $62 billion. The immediate past Attorney General, Abubakar Malami, said, wrote to 6 oil companies, Shell, ExxonMobil, Total, and the rest of. Please, can you pay the sum of $62 billion that you failed to pay? And they set out the details. While the companies were running around, another minister also passed now, Tim Silva, former governor of Bayelsa State, said, and I quote him, Nigeria knows it cannot recover $62 billion from all majors, despite ongoing cases against the company for money the government believes it is owed. Nobody can bring out that kind of money. I mean, we can't get $62 billion. We can maybe get something from them, but not $62 billion. The companies are not saying we cannot pay, but the government is justifying that it cannot recover the money. So up to today, the money has not been recovered. You might have heard about stolen fuel. It's only in Nigeria. Nigeria is the only oil-producing country where there is oil theft. No other country. Because what does government exist for? It is to deal with criminals. A few years ago, I think 2014, Nemasa hired a team of lawyers led by Professor Ajogu. And they came up with a report that in 3 years, 2011 to 2014, oil stolen from Nigeria to one port and discharged in one port in America. Only one port, Philadelphia port. The value was, the total volume, 60.2 million barrels of oil. No figure here, but we got the figure there. valued at $12.7 billion. Another port in America, Texas. Again, this was by the House of Rep. We have the report. The one stolen there is about $17 billion. So we are talking of about $29 billion. The companies are known. The shipping companies are known. But the government does not have the political will to collect the money. So if the Egbe Amofin, Nigerian lawyers are interested in ending the interminable suffering of our people, we can collect all these funds. In some of them, all that the United States government has asked us to do is to persuade your government to do a letter to the State Department. If we get that letter, to cheat one person, an individual.
FF, sir.
Yeah, I'm rounding up.
I've been told that you have 5 more minutes.
Yes, yes, I've seen it.
All right, sir.
I've seen your note. Now, to cheat a country, to defraud a country, is double penalty. So, Senator, we can work on this to end the suffering of our people. Let me just round up with this area. Under the Constitution, Section 153, there is a body known as National Economic Council. That is the only body empowered by the Constitution to advise the president on the economy. Today, and who are the members? The vice president as the chairman, all the 36 state governors, the governor of the central bank, and the finance minister. That body is the only one allowed. But the body has abdicated its responsibility. Today, only the IMF and the World Bank advise Nigeria on the economy. And those are the two bodies that have pleaded with the president. Remove fuel subsidy, remove electricity subsidy, remove all subsidies, and impose a rash of increases on the Nigerian people. The last one, sir, the way out. Under Section 19, subsection E of the Constitution, a duty is imposed on the federal government to promote a new international economic order. The only new international economic order in the world today is a body called BRICS. Brazil, Russia, India, South Africa. But what has happened? Nigeria is not a member. Egypt has joined. Saudi Arabia has joined. UAE has joined. Ethiopia and others have joined. Even Cameroon and others have applied. And the Minister of Foreign Affairs recently said, we are going to join, but not time. Please, the Nigerian lawyers, Egbe Amofin, must persuade the government today to join. Two issues have arisen. What is the purpose of this body? It is to deal with the dollars. Now, we want to trade among ourselves, say, in our currencies. So why do we need dollars, chasing dollars around? In 2018, the government of Nigeria and China signed an agreement. Whatever you are buying there, pay dollars. Whatever we are doing here, yuan. The government is currently talking to India. We also imported goods worth about $15 billion. Can we also have this currency swap with you? So if you are having currency swap with the two largest members, two members of BRICS that have the largest population in the world, China and India, why are you afraid to go to that body? Because of the West. We are worshiping the dollars. The US says we should not go there. So I do hope that Nigerian lawyers will join the campaign to get our country out of the stronghold of the dollar so that we can trade among countries that have respect for us, that have respect for our currency. If the last time I was in Cotonou, we took some dollars down with my lawyers. We wanted to have a week holiday. We spent naira. So if we can spend naira in Cotonou, we should spend naira in Ghana and spend naira in other places where they spend their own money here. So I want to thank you for this opportunity and to plead with the Egbe to look at his constitution and broaden it, because right now we're in an age of globalization. We are breaking down barriers, ethnic, religious, and the rest of it. Thank you very much.
Thank you very much, my dear Egbe leader and mentor, Authority Falana, for that wonderful presentation. He's the lead presenter, and we've heard from him. He has done justice to the topic by going down memory lane. He went into, started with the pre-colonial era, talking about even how we came about what we call Nigeria today, the amalgamation, courtesy of Lord Lugard, and of course spoke about the inclusiveness, of leadership as, exhibited by our leader, and of course the foremost Yoruba leader of blessed memory, Chief Obafemi Awolowo. He spoke about the need for us to avoid discriminatory tendencies. He tried as much as possible to also encourage that we should abolish the idea of, sponsorship of citizens to pilgrimage, because Nigeria is supposed to be a secular state and should not be seen to identify with any religion. He spoke about the need for our people to actually demand for a people constitution, as we have now what he termed a decree, but not a constitution made by the people. He particularly mentioned the fact that what we operate around is a unitary system of government, but not federalism, as we claim we are operating. And of course, he also gave advice to Egbe Amofin on the need to rethink the affairs and, of course, the constitution of the Egbe Amofin. Of course, we know that there are certain things that at this point in time may be dangerous to implement. I know that maybe subsequently in the future we will get there, but as it is now, certain things may be a step that will cause chaos because of the tendencies that we all exhibit as a people. It is when we understand who we are and admit that we are all brothers and sisters, and there is no that competition among us, that we can see ourselves as equals and also be ready to, integrate properly and lead by example. I believe our leader deserves another round of applause. We go to another of my born, who, by the grace of God, I'm sitting on the chair that he sat 14 years ago. And I know that the leader of Egbe Amofin presently is also the past General Secretary of Nigerian Bar Association. So he's a leader, not just of myself, but even the leader to the chairman of Egbe Amofin. So I call on my Egbe, Olumiwa Akimboro, Senior Advocate of Nigeria, past General Secretary of Nigerian Bar Association, to also, discuss the keynote address, of course, the lead presentation. And I would like you, sir, to, as much as possible, to make recommendations on how we will restructure Nigeria in a way that will head towards economic recovery. Thank you very much, sir.
Ẹ ṣé gan ni olóòtú, ẹ káàsán gbogbo lé, gbogbo ẹ̀yin bàbá wa, ẹ̀yin ẹ̀gbọ́n wa, pàápàá jùlọ ọ̀gá wa Fẹ́mi Fálànà. Ìgbà tí wọ́n sọ pé màá wá sọ̀rọ̀ lẹ́yìn tẹ́ sọ̀rọ̀, èmi ò mọ̀ pé wọ́n dẹ tàkúté sílẹ̀ fún mi ni, ṣùgbọ́n torí pé lẹ́yìn ìgbà tí ìrókò bá sọ̀rọ̀, ẹ wá lọ pé àwọn igi kéékèèké kan, ẹnì kan wá máa ṣàyẹ̀wò lórí ẹ̀, ìyẹn dàbí pé bíi tàkúté ni. Ṣùgbọ́n kò sí bí ó ṣe máa tán nínú oṣù ká má fi ra ọmọ lára. Ẹ̀gbọ́n wa ti sọ gbogbo ọ̀rọ̀ náà tán, àwọn ti mú ibi tó lé ń bẹ̀, wọ́n ti sọ gbogbo ibi tó lé. Èmi gẹ́gẹ́ bí ààyè mi, ibi tó rọ̀ lèmi á ti mú, torí pé èmi àmọ́ májèmájèmá sọ, àmọ́ ìwà wọn, àmọ́ bí wọ́n ṣe ìlànà wọn, àwọn máa ń jàjà. Èmi tèmi, èmi ò mọ̀ jájà, ẹ̀mí lè jókòó kájọ sọ̀rọ̀ ká jíròrò ṣùgbọ́n àwọn wọ́n jíròrò wọ́n dẹ̀ mọ bó ṣe lè tún fi agbára gbà náà so èmi tèmi ẹ má rò pé tómi ò bá lébi tiwọn ẹ jọ kò ṣe pé bí tèmi ṣe rí nìyẹn ní lẹ́sọ̀lẹ́sọ̀ ní àlùlọ àgídìgbò lọ́rọ̀ tèmi. à ń sọ̀rọ̀ restructuring tí èmi mọ̀ pé ó jẹ́ àtúntò oríṣiríṣi ọ̀nà ni ó ti yé gbogbo wa tí ẹlòmíì bá jókòó tó bá pa Hausa tán bá látúntò nǹkan tó bá máa gbọ́ yàtọ̀ sí nǹkan tí ọmọ Ìgbò lè gbọ́ ó dẹ̀ yàtọ̀ sí nǹkan tí ọmọ Yorùbá lè gbọ́ àwọn olóṣèlú a gbọ́ pé a dúpẹ́ pé àwọn kọ̀ọ̀kan nu wọn wà níbi tó dẹ̀ wú mi wọ́n fẹ́ gbọ́ tó máa sọ ṣùgbọ́n tó máa sọ ni pé àtúntò tí wọ́n náà tó yàtọ̀ sí tí ẹ̀yin tó lè rò pé àtúntò lọ́dọ̀ ti yín ṣé pé àwọn olóṣèlú wọn mọ bá ṣe ń dọ́gbọ́n wọn náà fẹ́ tò wá wọn wá tún wa tò ara àtúntò náà ni ṣùgbọ́n nǹkan kan tí mo mọ̀ pé láàrin gbogbo ọba ìjókòó síbí nísìnyí báyìí tí àtúntò yìí tó jẹ́ sí gbogbo wa kò ń ṣe nǹkan kan náà pẹ̀lú afẹ́ da Nàìjíríà rú àti mo mọ̀ pé gbogbo wa ọ̀rọ̀ wa yíra wa lórí ìyẹn pé kò ṣe pé kí Nàìjíríà má jẹ́ mọ́ kọ́ là ń pè ní àtúntò nǹkan tá à ń sọ ni pé tí ọmọdé bá ṣubú á wò wájú tágbàlagbà bá ṣubú á wẹ̀yìn wò tẹ́ bá dẹ̀ ń sọ àdá sókè nígbà ẹ̀gbà ibi pẹlẹbẹ náà ló máa fi lélẹ̀ ìgbà tí tá bá gbà pé etí mo sọ yìí ó jẹ́ tòótọ́ a máa mọ̀ wípé ṣé tá bá wẹ̀yìn wò gbogbo bá ti ṣe ń ṣe lọ ṣó ń pé wa ṣáà ṣe bí ó ṣe yẹ ká ṣe apá kan nìyẹn pé tá bá ṣe bó ṣe yẹ ká ṣe apá kejì ni pé nígbà tá a ṣe bó ṣe yẹ ká ṣe ọ̀ bó ṣe ní ká ṣe ṣé èrè tá à ń gbà níbẹ̀ ó jẹ́ nǹkan tó dùn mọ́ wa nínú ní gbogbo ibi iṣẹ́ tí ó wà láyé yìí gbogbo ibi tí àwọn èèyàn bá ti jókòó tí wọ́n ti ń ronú tí wọ́n rẹ̀ ti ń darí ìlọsíwájú náà ti máa ń ṣe àtúntò tí o bá ṣe nǹkan bó ṣe yẹ kó ṣe bó ṣe sọ pé ẹ ṣe lélẹ́yìí tí èsì tó bá jáde ń bẹ̀ kò bá bá nǹkan tí ìfẹ́ àwọn ènìyàn lọ àbí kò bí ìgbà dàgbàsókè wá tó bẹ́ẹ̀ ṣe fẹ́ ó bá ń tó àsìgbà yín náà pé ó tó àsìkò láti jókòó láti tún tò so àtúntò àti ìyapa ọ̀ká bára wa jà ìkó ṣe kankan náà. now nǹkan tó yẹ ká bí lọ́wọ́ ni pé ṣé Nàìjíríà lé nìyí bá a ṣe rí yìí ṣé bá a ṣe fẹ́ ni mo dẹ̀ mọ̀ pé nínú gbogbo táwa bí sì kò sí ẹnì kankan tó lè sọ pé nǹkan lọ bóun ṣe fẹ́ so gẹ́gẹ́lẹ́ kò sí anybody tó sọ pé ní àsìkò yìí kò tó ká tún ọ̀rọ̀ ra wò ká wò bí a ṣe lè tuntò tó fi lè dára ìdí èyí ni pé ní a máa fi bì lọ́la pé ṣé a ní ìdí restructuring mo mọ̀ pé èsì tá a máa fúnra wọn ni pé yes lásìkò yìí ó tó àsìkò tá a máa ní restructuring kí wàá ní restructuring tá a ń fẹ́ ètò tó ta fẹ́ àtúntò tó lè jẹ́ kí ìlú wa dára sí i tó lè jẹ́ kí ọrọ̀ ajé wa lọ sókè kó lè jẹ́ pé láàrin àwọn ìgbìmọ̀ àwọn orílẹ̀-èdè káwọn náà lè rí apá yọ ká lè lórí yọ kí ipò tí a wà láti ọjọ́ wa táwọn bàbá wa fi sílẹ̀ fún wa tí ó ti ń yẹ̀gẹ̀rẹ̀ ká lè rú gbà padà. tá à ń bá lọ báyìí nísìnyí tí à ń ṣe gbogbo àmúlùmọ́lá tá à ń ṣe yìí nǹkan kan péré tó ṣe fún wa ni pé Nàìjíríà báyìí sí bájẹ́ bá lọ akàn gbogbo wa jẹ́ bí ẹni tó ń ṣiṣẹ́ kan náà papọ̀ tí àwa jẹ́ ẹni kankan tó mọ ibì kankan ní àṣeyọjú tá a bá ní àtúntò àwọn tó ní agbára láti ṣe iṣẹ́ ọ̀gbìn àwọn tó ní agbára tó pé iṣẹ́ ọ̀gbìn làwọn mú ni wọ́n ti ní agbára jù wá lọ wọ́n á kọjú mọ́ àwọn tó ní ọgbọ́n bí àwọn ọmọ Ìgbò àwọn ọ̀rẹ́ mi tó wà ń bí tí wọ́n bóyá ń tó nǹkan papọ̀ tí ò ṣe ti àmọ̀dàrú o tó pé ti gidi wọ́n máa tó papọ̀ tá a bá ṣe báyẹn tá a bá ṣàtúntò tó ní kálukú tí wọ́n fi agbára wọn ṣe iṣẹ́ ní ọ̀nà ọ̀dọ̀ tiwọn a máa rí i pé ìlú wa á lọ síwájú. Example kan tí àbí àfiwé kan ìgbà tí mo débí lẹ́nìí tí mo jókòó sínú reception mo rí i pé hòtẹ́ẹ̀lì tá a wà ń bẹ̀ yìí ó ti pé ọgọ́rin ọdún ó ti pé 80 years this hotel tá a wà ń bẹ̀ yìí lágbára Ọlọ́run mo ti rìn káàkiri díẹ̀ ní orílẹ̀-èdè yìí àwọn ìlú mi wà láwọn orí ìpínlẹ̀ wọn tó pé ní ọdún tá a wà yìí wọn ò tí ì ní hòtẹ́ẹ̀lì tí àwọn sọ pé ó ti gbóyè o táwọn sọ pé ó ti darúgbó yìí o wọn ò ní irú ẹ̀ nílùú wọn. ẹ jẹ́ wo hòtẹ́ẹ̀lì yìí láti ọdún tí wọ́n ti kọ́ ọgọ́rin ọdún sẹ́yìn. Okay, I've been advised to say that part in English. This hotel that we are in, and that okay, wọ́n ní pé kí n máa ṣe ní àmúpapọ̀ kí n máa dààmú pọ̀ gbọ́nra wọn. This hotel that we are in now, when I got here this morning, I was surprised to see that this hotel was built 82 years ago. Actually, 82 years ago. I have had the grace to have traveled a little bit around the country, and I know that there are some state capitals where you cannot. This hotel, by our standard here, is old. Ordinarily, it's ordinarily it will be difficult to persuade an average person that hasn't got that generational history and connection to come and lodge here. But this is a place for some people, the old people, that they will always do their functions here, they will always lodge here, but not the younger generation. But the truth is, comparatively, if you go around Nigeria, how many states capital can even boast of something this old now to accommodate people? So we need to look at a lot of things that we bring healthy competition tó máa jẹ́ ká lè máa wo ara wa ní àwòkọ́ṣe. Irú tí oníkàtúkù bá lọ irú bá ṣe ń ṣe ìṣònàwó wa ń sì máa dọ́pẹ́ láti òkè wá sílẹ̀, which bí àwọn ọ̀gá wa ṣe sọ nǹkan tá à ń run federalism là ń run because constitution wa sọ pé federalism ni, ṣùgbọ́n nǹkan tá à ń run tí a bá túmọ̀ ẹ̀ tẹ́ bá tú wò kò ṣe federalism because dọ́pẹ́ federalism ni oníkálukú wọn máa ṣe ètò ìṣúná ọrọ̀ ajé wọn, nǹkan tó bá kù bẹ́ẹ̀ wọ́n ní gẹ́gẹ́ bí òfin wọ́n á wá san ìṣàkọọ́lẹ̀ fún àwọn ìjọba lókè. Ṣùgbọ́n nísìnyí gbogbo ètò ìṣúná gbogbo wa pátápátá ìjọba lókè ló ṣe, wọ́n á fi nǹkan tó bá wù wọ́n fi ránṣẹ́ sí wa. So I need constitutional federalism, but realistically we are not running a federal state. Tí another area tí mo tún fẹ́ ká tún wò ẹ wo ọ̀rọ̀ àlàáfíà àwọn ènìyàn, security issues. Tí bá ṣe ń bá lọ ní kò sí ọlọ́pàá ti àwọn orílẹ̀-èdè ní Àbújá ni àṣẹ àwọn ọlọ́pàá wà, ṣùgbọ́n ọ̀daràn tó ń dáràn ní Ìjẹ̀bú-Igbó ọ̀gá tó wà l'Ábújá ò mọ̀ o, àwọn ọdẹ Ìjẹ̀bú-Igbó ló mọ̀, wọ́n ní ọdẹ ìsìn ló mọ̀ èkúté ìsìn pa, ọdẹ Ìjẹ̀bú-Igbó ló mọ̀ olè Ìjẹ̀bú-Igbó. Kí ló dé tí a fi lè fúnra wa ní ààyè kó ní kálukú ní àwọn tó máa ṣọ́lù wọn? Ìgbà tí wàhálà àwọn agbénipa àwọn ebi ò fẹ́ pé orúkọ kan àwọn tó pè ní darandaran because àwọn náà ń dẹran, Ìgbò náà ń dẹran, Yorùbá ń dẹran, Ẹgbàlájọ ń dẹran, táwọn darandaran ń gbìyàn pa. Àwọn ará wa níbí wọ́n dá Àmọ̀tẹ́kùn sílẹ̀. Ó dára kò dára, a mọ̀ pé ó rẹ ọwọ́ wàhálà yẹn sílẹ̀ díẹ̀. That should be an example. That should be a food for thought for us to know that it is time to devolve some powers to the federating unit. Security should not be centered at the federal level. It has to come down to the state. Gbogbo ilé ìtabátà ń sọ yìí, kò sí nǹkan tó ń fàjà ń bẹ̀. Tí èmi àti ọmọ ìyá mi tí a bá jọ ń ṣe tabaláyé ọmọ ìyá gẹ́gẹ́ bí a ṣe jẹ́ pẹ̀lú orílẹ̀-èdè kan náà. Tí Ìgbò bá ń ṣe ohun tó dáa, tá a bá rí, àwa náà tá a jẹ́ ọmọ ìyá wọn ní Yorùbá, a máa kọ́ àwòkọ́ṣe wọn ni. So there will be healthy competition. Oníkálukú wọ́n ní bí ọwọ́ epo bá ṣe tó ló ṣe máa ń fi nu ojú. Epo oníkálukú á fi ọwọ́ ẹ̀ nu ojú bó ṣe tó. Epo ẹni tọ́wọ́ ẹ̀ bá kéré á lọ kọ́ iṣẹ́ lọ́dọ̀ àwọn eku tí àwọn tó léku tọ́wọ́ wọn tóbi. So there will be healthy competition. Àdèmọ́ máa lé ara wa ní eré àlàáfíà. We be chasing ourselves. Everybody will want to do a catch up. Ẹ wo Èkó nísìnyí. Èkó Center for Excellence. Ní gbogbo everybody ló ń wá láti wá kọ́ àwòkọ́ṣe lẹ́kọ̀ọ́. Èkó gbogbo pé o fẹ́ kó sí tó lè wà Nàìjíríà lẹ́nìí tó bá fẹ́ gbádùn ààrẹ wà wá sẹ́kọ̀ọ́ ni. Àwa náà tó pé Àbújá la jókòó sí, a mọ̀ pé yọ̀dọ̀ wá fẹ́ gbádùn ààrẹ wà wá sẹ́kọ̀ọ́, wà wá sọ́dọ̀ my brother Dr. àwọn méjì Ìjọba Jíbádé wọ́n mọ̀ bóyá ń tọ́jú èèyàn lábúlé àdọ́tọ̀ àwọn náà ọ̀gá ọ̀pẹ̀ ẹ̀rọ àwọn náà mọ̀ bóyá ń tọ́jú èèyàn. Ẹ wo bàtà wọn, ẹ bá pé kò ní ayé wà. Ẹ máa wo ìbọ̀sẹ̀ tó wọ̀, ta ló wọ ìbọ̀sẹ̀ olóròǹbó láàrin gbogbo wa. Èkó láyé wà. Tí a bá wo àwòkọ́ṣe yìí, tí a dẹ̀jẹ̀ kó wà healthy, tí ò ṣe pé tá a wo ìta ronú ara wa tó pé a ti mú ọkàn wa kúrò rí restructuring àbí àtúntò yìí, ó láti jẹ́ pé kó ní àkùlọ tiwọn ni. Tí a focus lórí ìlọsíwájú, a máa rí pé Nàìjíríà á dára sí i. Ẹ ṣé o, ẹ̀yin bàbá mi àti ìyá mi. Ẹ má bínú pé mi ò lè sọ púpọ̀. Ọ̀rọ̀ kékeré wọ́n tó wá dé nú àgbàlagbà àdòdì ti gbogbo àgbàlagbà. So ẹ jẹ́ ká ronú sí ọ̀nà àrùn wa lọ́wọ́.
Thank you very much, sir. You agree with me that he has proven that his true Omo. Sorry, another round of applause for Ariel Akimboro, please. You agree with me that he has proven to be Omoluabi Oodua, because he delivered a paper in Yoruba. It is very rare for anyone to present a paper in Yoruba, and I think it deserves another round of applause. It is not in doubt that every one of us must contribute our quota in ensuring that we have this restructuring that we all desire and our country deserve, and for the betterment of all of us. We must play our role in, contributing towards conversations around the restructuring and encouraging those who are very gifted with activism, like my Egbe FF, who will continue to mount the rostrum at every point in time to remind government that the primary objective of government is for the security and, of course, well-being of every citizen. If Nigeria must become great as we desire, then our economic security must be ensured and be protected. And that is why we must continue to remind government that we are watching. We know they have been telling us that all this that we are experiencing at this point in time is for a more prosperous country later. But Nigerians are getting very weary, very tired, and becoming very impatient for this dividend of the restructuring to happen. We cannot continue to suffer in silence. We will continue to remind them that they must listen to us and implement policies that will be to the betterment of all of us. I had initial information that we should have the questions later, but the chairman of the planning committee has just told me that we should just take about 2 contributions from the audience. Then probably the general questions will come later after the entire session. So can we have contributions from our distinguished audience, please? Can you pass the mic? Dr. Kemi Piero and Dr. Ayo Jibade, they are experts in corporate governance and, of course, the economic justice. So I believe they have 1 or 2 things they want to add. Yawip. So the chairman of the planning committee, we do the questions after the other session. So at this point in time, let me join every member to appreciate our distinguished speakers, from the lead speaker to the discussants, for those wonderful presentations. And at this time, I will call you to please step forward for a group photograph. Thank you.
Thank you very much, distinguished panel. We're very grateful. Permit me to switch to Yoruba. Gẹ́gẹ́ bí ẹ̀yin àgbàlagbà ṣe sọ, ọ̀rọ̀ sunukun, ojú sunukun náà la fi máa wò. Thank you very much. We will now invite the panel for quick photographs. We would invite the chairman of the Egbe Amofin. We also invite Dr. Ajibade SAN to the podium for pictures. Dr. Kemi Piero SAN also can please come forward for pictures. We also want to invite Senator Ajibola Bashiru. Senator Ajibola Bashiru to come forward for pictures and also presentation of the award.
Mrs. Ali Ejo, SAN.
ẹgbẹ́ amòfin Oòduà a fi àmì ẹ̀yẹ yìí fún wọ́n tún ti borúkọ jẹ́ o Mr. Fẹ́mi Fálànà Senior Advocate of Nigeria fún mímọ rírì ọ̀rọ̀ tí wọ́n bá wa sọ àti ìrìnàjò tí wọ́n ṣe ní òní. Ẹ ṣé gan. Ní orúkọ ẹgbẹ́ amòfin Oòduà a fi àmì ẹ̀yẹ yìí fún ààrẹ Múyìwá Akínbọ́rọ̀ Senior Advocate of Nigeria ní mímọ rírì ọ̀rọ̀ tí wọ́n bá wa sọ gẹ́gẹ́ bí olùsọ̀rọ̀ nínú àpérò yìí. Ẹ ṣé gan. Ní orúkọ ẹgbẹ́ amòfin Oòduà a fi àmì ẹ̀yẹ yìí fún Mr. Adesina Adegbite ní ìdúpẹ́ àti mímọ rírì takuntakun tí wọ́n ṣe gẹ́gẹ́ bí olùsọ̀rọ̀ ní àpérò yìí.
Gbogbo àwa èèyàn tí a wá sí ibi ìjókòó ètè ní àwọn ọ̀jọ̀gbọ́n, àwọn onímọ̀, àwọn journalist, gbogbo wọn tó wà níbí, mo kí everybody a kú ètò náà. Ọlọ́run á jẹ́ ká ṣe àṣeyọrí níbẹ̀. Orúkọ tèmi ni Ali Jubril Abiodun. Mo wà níbí láti ṣe ètò èní and ẹ jọ̀ọ́ mo fẹ́ kí gbogbo wa ká tẹ́tí fún another session. Ẹ jọ̀ọ́ mo fẹ́ ká tẹ́tí torí a ní àsìkò púpọ̀. I want you to permit me to run through the synopsis of the plenary. Effective and efficient dispensation of justice as a test of margin of national development. Effective and efficient dispensation of justice is a crucial indicator of a nation's development margin. A well-functioning justice system is essential for economic growth, social stability, and human rights protection. A nation's development margin is directly impacted by the following aspects of justice dispensation. 1. Access to justice. Equal access to justice for all citizens, regardless of social status or economic position. Representation by counsel in all courts and tribunals. 2. Fairness and impartiality. Ensuring that justice is served without bias or prejudice. 3. Speed and efficiency. Timely resolution of cases to prevent delays and backlog. 4. Accountability. Holding those in power accountable for their actions. 5. Rule of law. Upholding the principle of rule of law, where all citizens are subject to the law. A nation's development margin is expanded when justice is dispensed effectively and efficiently, leading to 1. Increased investor confidence and economic growth. Improved social stability and security. Protection of human rights and the rule of law. Enhanced public trust and confidence in institutions. Reduce corruption and impunity. In contrast, a flawed justice can hinder a nation's development margin, perpetuating inequality, instability, and economic stagnation. Therefore, a nation's stability to dispense justice effectively and efficiently is a critical test of its development margin. The discussants of this session are Mr. Dr. Kemi Pinero, SAN, OFR, is the founding and managing partner, Kemi Pinero legal practitioner. He's a chartered arbitrator. A seasoned discussant is Mr. Professor Ayo Asenua. Professor Ayo Asenua is a professor of law at the Prestige University of Lagos. Oh, I'm sorry. I'm just told now that Professor Asenua is unavoidably absent and is ably represented by Professor Akim Bello of University of Lagos. We are happy to have you in our midst. The last is our able Dr. Babasude Ajibade. Dr. Ajibade is the founding managing partner of SPA Ajibade & Co. He's a chartered arbitrator of United Kingdom. Dr. Ajibade is a perfect description of let your achievements speak for you kind of person. You are welcome, sir. May I invite the moderator, my senior colleague, the National Assistant Publicity Secretary, Mr. Charles Ajiboye. You are welcome.
Yeah. Thank you very much, and good afternoon, everybody. I know some people struggled with understanding Yoruba, and Odogu was actually smiling and nodding at some point. Don't ask me who Odogu is. He was nodding and smiling like this during the first section. And I won't tell you who Odogu is. And then I thought he was listening and understanding until we asked him a question, and he said that we knew it was not in the hall. So we'll try as much as possible to play more within the a language that we all understand, and we hope that will help us to have a lot of participation in this session. It is, for me, a great privilege and honor to moderate this session with my mentors and role models, people that I have always been so excited to listen to. The lead presenter for today, Dr. Kemi Pinero OFRSAN, is indeed the definition of somebody being erudite. And I know that he will not be able to do justice to that topic in the 20 minutes that has been assigned to him. But I hope that he will be able to whet our appetite, get us in the mood, and then stimulate our thinking process towards the topic. And then we're going to go straight to having him make the lead presentation on the topic for this plenary session, efficient and effective dispensation of justice as a test of margin of national development. Ladies and gentlemen, please make welcome Dr. Kemi Pinheiro, OFRSAN.
Distinguished gentlemen, the Ààrẹ of the Egbe, may I seek your permission to acknowledge the presence of the #1 representative of the federal government of Nigeria here, Senator Niyi Adigbomire SAN. Everything we say against the federal government, we should lay it at his doorstep today. I'm very thrilled to be here. I also welcome my distinguished discussants. I feel very intimidated. I felt very intimidated when I saw Professor Ayo Asenua Ebri represented here, and I saw Dr. Ajibade. My initial reaction was, why don't I be the discussant instead of the presenter? But as usual, the chairman of the local organizing committee, Leonard Silk Adekoke, encouraged me. Thank you, distinguished ladies and gentlemen. I will be speaking in English language. You might ask me why. Not because I'm not fluent in Yoruba, but the invitation to this program was written in English language. And by virtue of Section 150 of the Evidence Act, it presumed that those who invited me wanted to come and speak in English language. And so I have adopted the language that they use to speak with me. In any event, I see three very eminent presidential contestants seated here. And I know that they were just all lost when Mr. Are Akimbora was speaking, SAN was speaking. So for their sake, I will speak in English. I am thrilled and honored to be here. The task at hand is epitomized by the popular saying, the judiciary is the common hope of is the last hope of the common. This highlights the immense value placed on justice delivery. Kofi Annan, Secretary General, had this to say: there is no development without justice. A country which attracts a fair and efficient legal system cannot attract. A country which lacks a fair and efficient legal system cannot attract investment. It cannot promote economic growth or reduce poverty. Justice is the foundation upon which a prosperous, equitable, and egalitarian society must be built. End of quote. Distinguished colleagues, the intricate relationship between national development and the national justice system is an undeniable truth. My focus in this paper is to demonstrate how other developed countries with the same common law heritage have utilized justice delivery to foster their national development and economic growth. When we talk about justice delivery, we're talking about a justice system that operates efficiently, fairly, and transparently to uphold the rule of law, protect individual rights, and ensure societal order. There are some key components that are required. One is accessibility. Without equal access to every person, irrespective of their background or ethnicity, a justice system cannot be described as effective if it denies accessibility. Accessibility is the cornerstone of the law. Second component, there must be timely disposal of cases. The third is there must be, from a very dispassionate point of view, fairness. There must be transparency, and of course, there must be accountability. A functional judicial system, social order, and prevents the country or the system from running to being anarchical. And as Thomas Hobbes had described it, the state of nature that is short, nasty, and brutish. In Nigeria, the justice delivery and national development can be said to have taken its root from the principle that was derived from the colonial era, which is that of common law. And of course, the Magna Carta of 1215. And the hallmark of common law is the doctrine of precedence and stare decisis, which ensures consistency and predictability in actions. I have quoted in my paper Posner, where he said that the common law system with emphasis on precedent and stare decisis provides a clear and predictable framework for resolving disputes. Legal certainty is also essential for business to plan, invest, and grow. What is the connection between justice delivery and economic growth? Justice delivery is a fundamental aspect of every society that aspires to achieve any form of meaningful national development. A well-functioning judicial system or justice system is indispensable to business activities and to society as a whole. I have quoted from Lorisa and Guerrera, Department of Law in the University in Peru, that one of the factors that encourages investment, particularly foreign investment in developing countries, is the absence of an effective and reliable dispute resolution mechanism. Guerrera made a test case of what happened in Italy. He said that Italian economic growth has been and is definitely hampered by the length as well as by the civil and criminal justice processes, which reduces legal certainty and confidence and increases the risk of economic activities and therefore reduces the propensity to invest. Let us now examine what other countries have been doing right. I must confess, for me personally, the example I always have resort to is the Singaporean example. Not only because Singapore was said to be a third world country, but it also epitomizes what is called purposeful leadership and growth. Singapore gained its independence in 1965, even after Nigeria. The first thing Lee Kuan Yew, the very popular former leader of Singapore, did was to demonstrate appreciable understanding of the role of the judiciary and the justice sector in fostering economic growth. He updated the courts and their procedures. They amended their rules of practice. They ensured the appointment of persons of impeccable record as judges and judicial commissioners. They leverage on information technology. In his book, Third World to First World, Lee Kuan Yew stated that by 1999, the reputation of Singaporean courts brought judges from developing as well as developed worlds to study Singapore's judicial reorganization. In fact, it was such a very popular fact that a lot of English judges, a lot of common law judges, prefer to take domicile in Singapore. In fact, not only did Singapore attract from developed countries, Hong Kong, their neighbor, had more citizens becoming judicial officers in Singapore than even in Hong Kong. Singapore also has the same three-strata we have, three-strata judicial system. They have the state courts, they have the Court of Appeal, and they have the Supreme Court. But they went ahead to set up what is called the Family Justice Courts. They then created what is called the Integrated Electronic Litigation System and the Community Justice and Tribunal Systems. In Singapore today, over 85% of criminal cases, 85% of criminal cases are resolved within 6 months. High court cases involving criminal cases are resolved within maximum of 12 months. There is no contest as to appearance of the accused person, of the defendant. There is no objection as to the proof of evidence not disclosing a any charge. There is no objection to plea being taken. Compared to the civil courts, approximately 90% of their civil cases are disposed within 18 months. Supreme Court, civil cases generally are resolved within maximum of 24 months. In fact, there was a study by the UNDP. It was discovered that almost 75% of cases in Singapore that commenced from the trial, High Court, are finished in the Supreme Court within 1 year. 80% of family-related disputes are settled within 6 months. I also went ahead in my paper to discuss what the United States have been doing. And then let me now focus on what we have in Nigeria and what we need to do. Dispute resolution in Nigeria is majorly characterized by 4 stages. In Bilante alone, Bilante case, which I cited, a case that commenced in 1992, continued in 2011, when the Supreme Court delivered its judgment almost 20 years later. In Edicon and UBA, a judgment in the lower court was delivered in 1997. The final judgment in the Supreme Court was delivered in 2017. It is obvious that our courts and our stakeholders have failed to enact measures, sufficient measures, and implement those measures geared towards decongesting the dockets of the courts, thereby reducing the time span of cases. Even where they do, I must acknowledge, and they do, the effect of those measures have been at best salutary. Let me give you some statistics. In the Court of Appeal alone, in 2023, 39,000 cases were filed. And out of these 39,000 cases, how many were disposed of? Less than 35%. In the Federal High Court, there was an exponential increase between 2020 to 2022 of cases from 144,000 to over, from 128,000 to over 144,000. How many of these cases have been disposed of within the 2 years? Less than 10%. I have presented a chart at page 11 of my paper, and I've demonstrated that there are structural problems that afflict our justice sector, and that itself impedes our ability to achieve the economic growth that we aspire to. Adjunct to this is the unfortunate menace of delay, the sometimes dilatory tactics of lawyers. I have given examples of 1 or 2 cases where even when parties resort to arbitration, the arbitration proceedings have become bogged down in the difficult process of having to recognize the awards. In fact, now, you are better off going direct to court than starting an arbitral proceeding. It's either that when you get your award, in most of the instances, the courts will refuse to recognize it, or the courts will set it aside. I did a statistics. In the UK, for alternative dispute resolution awards, like the arbitral awards, the possibility of having your award set aside is 1%. It's 1%. Because the English courts have adopted a judicial policy to always recognize all awards. Yes. I have also used statistics to demonstrate that even where there are fresh new cases, because the number of judges are fundamentally inadequate, it is impossible for us to be saying we are serious about enhancing the justice sector for the purpose of national development. In the Federal High Court, how can we reasonably expect that 145,000 cases filed will be determined by only 94 judges? That is an average of 541 cases per judge. It's not possible. What are the solutions? I have proffered in 3 pages of my paper some of the solutions that I, in my own view, we need to immediately implement. The first is we must declare a state of emergency in the judicial sector. I must also commend and acknowledge the fact that I read the announcement, was it yesterday or the day before yesterday, that there has been a 300% increase in the emoluments of judicial officers. Senator Egbe, we thank you for that. And I know that such a very far-reaching policy could not have seen the light of the day but for your position as the Senate chairman on the judiciary. So we thank you for that. We need robust and holistic amendments to be carried out to the rules of procedure of various courts to extricate provisions that facilitate delay in court proceedings. An analysis was taken by the contest at the Supreme Court with respect to interlocutory appeals. And it was determined that 82% of cases that went on interlocutory appeal to the Supreme Court or Court of Appeal were jurisdictional. And where they are not jurisdictional, they are technical. We need to infuse more credibility into the appointment and elevation of judges. We need to encourage and implement the appointment of senior lawyers as judicial commissioners on an ad hoc basis at different levels to immediately dispose of procedural and non-contentious interlocutory applications. Singapore did it effectively. Ghana did it. There's no reason why Nigeria cannot do it. We need to pass appropriate legislation and amendment to alter the constitution to discourage and discontinue time-wasting interlocutory appeals. We need to expand the numerical strength of judicial officers and overhaul their compensation package. Thank you. That is being done. Massive infrastructure investment in the technology of the court systems. We need to reinvigorate judicial institutes at the federal level and at the states to create judicial institutes to train mid-level and lower-level judicial staff. We must enhance alternative dispute resolution methods that would take part of the pressure from the judicial system. Judges and lawyers alike must be retrained in the use of technology, including modern advancements such as blockchain technology and AI. We need to reskill ourselves. Relevant public awareness programs must be undertaken to encourage access to justice. I ended my paper by referring to the quotation from Louis Brandeis, the former Justice of the United States Supreme Court. And I quote, "Justice is the great interest of man on earth. It is the ligament by which holds civilized society together. Without it, there is neither security of life or liberty." Distinguished audience, I thank you for giving me my time. And I'm hoping that before we finish the questions and answers, the printed copies of my paper that I have told the printer to do about 100 copies or 150 copies will be circulated and distributed. Thank you very much.
Thank you very much, Dr. Kemi Piero, OFRSAN. Thank you very much. Again, somebody once said that if you know something so well and you cannot explain it briefly, perhaps you don't know it at all. I've had the privilege of going through the text of the paper that KP just delivered. Yeah, KP just delivered, and you'll be surprised at the length of that paper and the depth and the details in it. But yet, he was able to just come up here and talk through that paper, and then we have everything that is in it. Thank you very much. I want us to understand the essence of this particular session in a very small and simple, unambiguous way. We're talking about the effective and efficient dispensation of justice, basically as a test for the margin of national development. So we are saying that efficient and effective dispensation of justice can actually be used to measure, to determine, to improve national development. And for those that understand, it was a wise man that said, people can coexist without religion, but they cannot exist without justice. And that explains how intricately connected that the dispensation of justice, effective and efficient dispensation of justice, is to national development. It's on that note I'll be bringing up the discussants that will go after Dr. Kemi Pinheiro, Professor Akim Bello. A round of applause for him, please.
Thank you very much, Mr. Chair. And on behalf of Professor Ayodele Ashenua, we want to express our appreciation for the invitation. She would have loved to be here, but she has other very important assignments. So the views that I'm going to express here are my own personal views, although they are not likely to be different from ours because we do our research and teaching basically in the same area, which is about criminal law and criminal justice. So 5 quick areas of discussion arising from the paper well written and well presented by Dr. Kemi Pinheiro. Number one of the recommendations he made was that we need to also deploy ICT to enable effective and efficient administration of justice. I cannot agree more with that because, I mean, as far as I'm concerned, by now, we shouldn't be going to court for motions, even contested motions. You know, the brief of arguments have been filed. Everything is before the court. All you just need is 5 minutes, you know, to emphasize the areas of your submission, and the court should be able to hold rulings. Why should senior advocate be traveling from Kano, Maiduguri to Abuja to go and argue and appeal? The briefs of argument is already before the court. All they will give you is 5 or 10 minutes. So we need to deploy technology. And these things are not expensive. Until 2019, after COVID, in the university, we had no means of doing online teaching. But since COVID, the university has introduced Zoom. Sometimes I'm in Calabar, sometimes I'm in Abuja, and I'm having my lectures. And the lectures is going on effectively and efficiently. So I think that is an area that we've dwelled so much on without making much progress. We need to begin to see real progress in deploying ICT. Then he also talked about the fact that effective dispensation of justice should be driven by competent judicial officers. You know, that's one of our misfortunes in Nigeria. You cannot have a judge deliver justice effectively and efficiently if he is not competent. In Nigeria today, the selection process is not quality driven. It's either because you are from Ministry of Justice or you have, I'm not saying people from Ministry of Justice are not competent, but the net should be spread wider to ensure that we take quality people to be on the bench, people that are there by virtue of their competence, not because I am related to the former CJN or my brother is a minister or my cousin is a senator. People sitting in our courts. It is only competent judicial officers that can ensure effective and efficient administration of justice. Another area is that, you know, particularly in the area of criminal justice, we need to adopt and incorporate restorative justice. Because there are so many, particularly in the lower courts, many of the minor criminal cases are matters that are amenable to restorative justice, which will deliver to the victim, the community and the offender, real justice. Our normal criminal justice system is punitive and retribution. But restorative justice focuses more on repairing the harm between the offender, the victim, and the community. Thank God in Lagos, there is a gradual incorporation of restorative justice at the lower level. But we need to see more of this so that the dockets of the magistrates' courts and the high courts can be reduced, and they will have more time to, adjudicate on more serious matters. The Speaker also noted the need to amend the rules to remove provisions that cause delays. We've already had a lot of amendments that have removed some of the rules. But the problem sometimes is the judicial officers. I'll just cite one example. I've had to do, I don't normally do much of legal practice, but I do some once in a while, gratis. I've had to file 2 divorce petitions in Ogun State. Because if you file divorce petition in Ogun State, within 1 year, the matter is done because you are looking for effective and efficient justice. Their docket is not as congested as Lagos. The first one, I was able to conclude it within a year. The second one, after the matter was filed, the lady who is my cousin, jackpot. So how am I going to bring her back? How is she going to afford the cost and all that? And fortunately, I found a rule in the matrimonial causes rule that allow evidence in divorce proceedings to be taken by affidavit evidence. Even if it is a contested divorce, the rules allow it to be taken by affidavit evidence. I was so confident. I filed an application and I told my cousin, don't worry, you don't need to come back. The judge doesn't have a choice. He must grant this. I did all the submissions, canvassed all the arguments, went to all other Commonwealth countries having the same rules. Lo and behold, the judge just couldn't comprehend that there is such a rule. So we can have all the reforms, but we need judicial officers who are proactive and ready to embrace change. That is also very critical. And then the last point, we are talking about effective and efficient administration of justice and linking it with national development. Yes, national development, a significant part of it is economic development, economic progress. But that is not all. Within development is also the way a society treats those of us who have run foul of the law. Now the question is, how do we treat people who have run foul of the law? That's a whole ballgame. But I think we should even focus on the aspect of corrections. Yes, the Correctional Services Act has been amended. The National Assembly did a fantastic job to do that. But it goes beyond that. Since the law has been in place now, we have not seen, it's only the form that has changed. The substance has not changed. So I believe that's one area that Egbe Amofin Oodua should look at, advocating for the government to invest in corrections. So that those of us who have run foul of the law and have to be sentenced to prison can go there and be able to come out and be better citizens. Not that they will go and come out and be more competent armed robbers, more competent kidnappers, and so on and so forth. Those are just the brief areas I want to. So once again, I want to thank the presenter for such a wonderful presentation. Thank you.
Thank you very much. The applause is apparently well deserved. And Prof has succeeded in creating more heat in the room. I expected it to be very hot in here, especially when I was sandwiched in between very learned, doubly learned, multiply learned role models. Thank you very much, Professor Akimbelu, once again. Permit me to quickly recognize, before I bring up the next panelist, someone that just came in. Of course, no less a person needs not much introduction, is Deacon Dele Adesina, Senior Advocate of Nigeria and former General Secretary of the Nigerian Bar Association. I was going to say some things, but because Dr. Ajibade SAN is the one that is speaking next, I decided not to say them anymore because he chaired the recently concluded Justice Summit in Abuja. And that Justice Summit was indeed very, very, very extensive, with the Attorney General of the Federation present from the beginning till the end. And the conversations that we had there were indeed robust. I'm hoping that in discussing the paper of Dr. Kemi Pinheiro, it probably will also give us the benefit of a peep into the progress that has been made, will be made, may be made from the very extensive conversations that we had at the Federal Justice Summit. Ladies and gentlemen, please make welcome Dr. Ajibade SAN.
Ẹ kú jókòó. Mi ò fẹ́ disappoint àwọn ẹgbẹ́. So bí o ti ẹ̀ ju gbólóhùn méjì, màá ṣáà sọ Yorùbá yẹn ṣá. So eléyìí tí màá sọ ni mo ti sọ yẹn o. Distinguished ladies and gentlemen, it's a great privilege to have been asked to be a discussant at this session. It's a great privilege to have been asked to speak at all at this conference of the great Egbe Amofin Oodua. I've had the privilege of reading my good Egbon KP's paper, and as Charles, our moderator, has said, he condensed that paper brilliantly. There's a lot in there, and I urge you to please take time to read it when it is circulated. And what strikes me from listening to our keynote speaker, BRF, and reading Dr. Pinero's paper, is that we all seem to be aware of what the problems are. Where we seem to have been struggling is with not even identifying solutions. We know what the problems are. We've even articulated the solutions. Where we have had a challenge is with implementation, is with implementing the solutions. I mean, somebody spoke about, Professor Bello spoke about the use of technology. Dr. Pinero spoke about the importance of improving the judicial appointments process. And I think I'll start from there, because what we did with the Justice Sector Summit, which Charles has spoken about, was basically to build on something that started under the previous administration, not the Mekiao administration, but the Akpata administration. Because we held a Justice Sector Summit in 2022 or 2021. And we had identified then, we had assessed the situation in our justice sector, and we identified that there were 3 critical issues that we needed to deal with if we were going to have any chance at all of solving these problems. And the most important and foundational one was judicial appointments. As has been said, if you don't have the right quality of judicial officers, you can have the best rules, you can have the best laws, but these are the people that have to use these rules to deliver justice. And if they don't have the capacity, if they have been appointed as judicial officers because of their filial, social, or whatever connections, then you will get the disappointments that we get now. And I say this, of course, advisedly. It's not to say that all our judicial officers are not fit for purpose, but I think it's fair to say that a significant percentage of them are not. And we have to address that problem. One of the things that we also identified is that you have a system. This is the same country that back in the day was exporting judicial talent to other parts of the world. Nigerian judges were being appointed as CJs in the Gambia. Nigerian judges were appointed as CJs in Botswana. Nigerian judges were being appointed, were being clamored for at the International Court of Justice. So how did we get here? And the way we got here was we took our eye off the ball. We took our eye off the importance of the role that a judicial officer plays, and most legal practitioners decided that this was not for them. Now, I had a conversation once, and I remember sharing this with my good Aburo Bode Olanikpekun recently, that I had a conversation with his dad, with our great Egbon Chief Wole Olanikpekun. And Chief Olanikpekun was talking about the importance of ensuring that the appointment process to the role of to be a senior advocate had to be kept, really secure, and we need to make sure that the quality of appointments is maintained. And I said to him that, sir, I agree with you that that is important, but we seem to be focusing so much on the process of becoming a senior advocate. As senior advocates, where do we practice? We practice before judges. Now, if we're so focused on how you become a senior advocate, and we're not focused on the quality of the people before whom the senior advocates will appear, how do we have a functional justice system? So how we get that is definitely one of the most important things that we must deal with. If we look at the current justice sector or the appointments process or the judges we have as a bottle of, squash that we used to drink back in the day, you know, it's concentrated and you can't drink it raw, you have to dilute it. So I think we already have a problem. We have a concentrated bottle in our justice sector now in the judiciary. The only way to deal with that is to ensure that appointments going forward are of the right quality so that we can dilute and dilute and dilute it until it is something that we can drink. And I'll speak to what the Justice Sector Summit that I had the privilege of assisting to organize, what we propose in that regard. Now, the second area that we identified was funding. Because truth be told, why would my great brother KP want to become a judge? I mean, he wants to send his children to Cambridge, to Harvard. How is he going to afford that on what judges were earning until recently? Even with the current increase, I'm not sure, given the rate of inflation and the exchange rate, I'm not sure that it will still get, you know, judges to send their children to Harvard, assuming that that is all they're relying on. Right type of investment in the justice sector in order to deliver the kind of justice sector that we want. And the third was then delay. And these are all connected. You don't have the right quality of judicial officer. You're not funding your judiciary properly. And then you expect that things will go through the courts efficiently. It can't happen. We have the delay we have in the system because of poor quality of appointments, because of inadequate funding in the judiciary, and the result is the deadlock or the logjam that we have in our system at the moment. Now, relating that to what Dr. Pinero said in his paper, and he spoke, or you will read, about the experience of Singapore. Apparently, Singapore, I wasn't aware of this, but the situation in Singapore before Lee Kuan Yew was about where we are now. So it took a leader who realized that this is a problem. I have a vision. I know what it takes to make this country the kind of place I want it to be. And one of the most important things I need to do to achieve that is to fix the justice sector. So he did what? He identified a good chief judge and funded it. I understand that in Singapore at the time, one of the things Lee Kuan Yew did was to make public sector service as lucrative. As a matter of fact, people would rather leave the private sector and go into government because government was paying so well. So if you were a minister, if you were to become a judge, you were earning definitely as much, if not more, than you'd have earned in private practice. And by so doing, he was able to attract the right quality, the right talent. Now, that is a leader who understood exactly what he was trying to achieve and decided to do it. Now, the good news is, and I say this touching wood, since we had democracy in 1999, in my personal opinion, this is the first time that we actually have an administration that shares that vision, that shares that understanding of the importance of the justice sector. And I say this because of my experience in the organization of the last Justice Sector Summit. It was observed at that summit, and Charles has mentioned it again, that this was the first time you were having anything of the sort where you would have an attorney general who will be there from beginning till end. Prince Fagbemi was not only instrumental to the organization of that summit, but he showed his commitment to what we were deliberating on and to what we were hoping to achieve by his presence throughout the proceedings. And he has made clear that unlike other events where we come and we talk and we deliver papers and everything sits on a shelf, that he is prepared to follow this through and to try and make sure, to the greatest extent possible. He's not a magician, and of course he has to carry his administration along. He has to carry my brother, Senator Egbe Amofin in the legislature along. He has to carry even the judiciary along. But the intention is clear. There is a realization that we cannot continue doing things the same way and expect to deliver different results. That's what they say, that's the best definition of madness. You keep doing things the same way, you will get the same result. Now, what are the things that we intend to do in the short term? There are a lot of proposals that have been made. I can only summarize and just touch them very briefly. But in terms of judicial appointments, as you may be aware, our constitution at the moment, the only requirement for being appointed a judicial officer is that you are 10 years post-call. It doesn't even say that you've been practicing for 10 years. It says that you have been a lawyer for 10 years. Once you have been a lawyer for 10 years, you can be appointed a judge of the High Court, of the Federal High Court, of the NIC. Once that happens, there is nothing in the Constitution that stipulates what criteria you need to satisfy to be appointed. And that we see as a problem. The guidelines that we have at present that regulate the appointments to the superior courts is a guideline that was designed by the National Judicial Council. And as we are aware, the National Judicial Council follows that guideline, its own guidelines, when it feels like. It is not seen as a binding document. It is not legislation. One of the things we have recommended is that in the ongoing constitutional amendment, there should be an express provision in the Constitution that empowers the National Assembly to pass a law stipulating not only the guidelines, but the procedure that must be followed, inclusive of a post-appointment validation process. Because what we have found is that there seems to be a concerted effort to capture the judiciary and make sure that it is only those who are wanted by a particular group that make it to be appointed as judicial officers. And we think that there must be a constructive effort, a determined effort to break that cycle. When it comes to funding, already we are aware that certain steps have been taken. Again, these are things that show us that there's seriousness on the part of this administration. Steps have already been taken to increase by 300% the remuneration of judicial officers. But I dare say that one of the aspects of the problem is not just about remuneration. One of the greatest challenges we have in the judiciary, in our view, is administration. There is an important and imperative need to separate the administration of the courts from the administration of justice. Judges are trained, by their training, they're trained to adjudicate, not to administer. It shouldn't be the case or the work of a judge to organize whether there's paper, whether there's diesel in the generator, whether the registrar's salary has been paid. All these administrative functions that our courts are saddled with, or that our heads of court are saddled with. Unfortunately, it is the heads of court who have been resisting. They don't want to give up that power. But they must be convinced to yield that power. Now, our recommendation is that the administration of the courts should be separated from the administration of justice, and the administration of the courts should be handed over to people who are trained, who have the training for running complex organizations. A court is a very complex organization. It is not something that you learn on the job. We should appoint people to administer the court who have the experience and the training to run complex organizations. And at the Justice Sector Summit, we had a gentleman, Dr. Sorabji, speak to us. He's an expert in this area from the University College London. And he did a comparative survey of how this is done in the UK, how it's done in the US, in Australia, and Canada. And that is exactly what they do. He said that they have administrators who are specially trained to run the court. And the judges, I mean, the debate at the summit was as to who appoints these administrators. And of course, the judiciary rightly says that if you hand that power over to the executive, it might lead to an incursion into judicial independence. We have no problem with that. But let's set out the criteria for who will be the right person to administer the court, even if that person will be appointed by the judiciary. But the judiciary should appoint them and empower them to perform that role. And as a matter of fact, that will solve some of the challenges we see. Right now, we talk about judicial independence. But you have your judges going cap in hand to the governors or at federal level to the president to be given money. How is that judicial independence? You cannot be independent if you have to go cap in hand. Let us put somebody in between who is an administrator, who is the one that will interface between the judiciary and the executive when the budgeting, the funding, and the administration of the courts is concerned. Third, there is a model that has been established and is working in Delta State. It started with the Commercial Disputes Law Network that put in place an administration of civil justice bill, which was passed into law in Ekiti State to start with, and has now been passed into law in Delta State. This bill, and it's just an example of several legislative interventions that can be put in place to enhance the speed of the administration of justice. But perhaps I'm told I have just 1 minute left. I think the most important point, and I will close with that, is a point that BRF made in his keynote, and that is the attitude of the players in the justice sector, us here. The attitude of the players in the justice sector has the capacity to frustrate even the best intention in the world. And when I talk about that attitude, it is not just the bar, it is both the bar and the bench. Unless we have a change of orientation, unless we decide that we want to change the way we do things and we want to move things forward, all these efforts will go to naught. So we also have to have a rethink. And I'm glad that, well, I don't know how many of them are left. I only see Tobena here. I have Afam and Chuka left. Because I think those of us that are, I see Tobena, but I don't see my other two brothers. I think those who are seeking to lead the bar must take this on as a mandate. We need to continue speaking to ourselves. We need to change the way we think. We need to change the way we operate, because there's no point complaining if you are part of the problem. Thank you very much.
Thank you very much, Dr. Babatunde Ajibade, Senior Advocate of Nigeria. Well, I'm tempted to take questions. I'm tempted to take interventions, and I just want to encourage you to write them down because we are going to come back to that. When I came in from Kano yesterday to the opening cocktail that was had yesterday, there's some kind of energy that jumped into me. The hall was full. And then sitting in the room today and listening to the conversations we have been having is exciting because it is loud that the Omo Oodua are beginning to take the place that I call the leader status in national development. We are beginning to understand that we have a duty to lead and to ensure that our country becomes a better place. And I'm going to close this session very quickly. But before I do that, I want to teach us a 6-line song that I had the privilege of being part of a group about 20 years ago, where we were promoting and pushing some of the values and some of the virtues that we have in Oodua. Pardon my voice, but listen to the lyrics, and hopefully in the second line, the second take, you'll be able to sing along. And it is in Yoruba. It says, Oòduà ilẹ̀ olókìkí ibi tí ń ṣorísun àwọn bàbá wa amọ́láwọ̀ tàbí dúdú ẹbí ńlá kan ní gbogbo wa ilẹ̀ tó láṣà tó tún létò àṣà tó máyé rọgbọ fún wa kò ní bàjẹ́ lórí mi o. Oòduà, Oòduà ilẹ̀ wa. Can we take it one more time and that will be the last one? Oòduà ilẹ̀ olókìkí ibi tí ń ṣorísun àwọn bàbá wa amọ́láwọ̀ tàbí dúdú ẹbí ńlá kan ní gbogbo wa ilẹ̀ tó láṣà tó tún létò àṣà tó máyé rọgbọ fún wa kò ní bàjẹ́ lórí mi o. Oòduà ilẹ̀ wa. Thank you very much. Thank you very much. And I want to thank our panelists for a wonderful time and for all of you for participating so rapidly. We'll have a group photograph now and we'll yield to the next session. Thank you. Please, can we have erudite seniors in the house? Are Akimboro SAN, Dikindele Adeshino SAN, the General Secretary of the Nigerian Bar, Mr. Adeshino Adegbite SAN in the making, and the Chairman of the Egbe Amofin Oodua, Are Olagunju SAN. Distinguished Senator, please you join us. Distinguished Senators in the house. Distinguished Senators in the house, please. Doctor, please come and join us. Yes. Leonard Silk, Mrs. Folashade, and Mrs. Bashar SN. Please join us, please. Ogamure SN, please. Mrs. Babatunde, please. Mrs. Lai Babatunde.
On behalf of the Egbe Amofin Oodua, the chairman Are Laguju organizing committee of this conference, I have the privilege to present to you, Dr. Kemi Pienro, this award, which is an appreciation for your very insightful, very encouraging contribution to as a speaker in this conference. Thank you very much. Yes, this one is written in English language. But Egbe Amofin, in my own invitation, was written in Yoruba. Professor, on behalf of the Egbe Amofin, and on behalf of the leadership led by Are Isiaka Olagunju, the organizing committee led by my brother, Kerad. Kerad is popular. We want to appreciate your coming. Sure, I know your schedule to attend to students. You find it worthy to come and sit with us and give us a very, very insightful presentation which has benefited and exposed us to a lot of things. We thank you. We appreciate your coming. Thank you very much. Dr. Babatunde Ajibade, on behalf of yourself, as an Egbe, as an Egbe, who has come to do his job as a true Omoluabi, true Omegbe, who has been all around serving the Egbe, and one of our best foot that we have always put forward. We just spoke about the Justice Reform Conference. He has worked. Though we are not going to retire you now, we are still going to work. On behalf of the Egbe, we thank you, we appreciate you. We know that everywhere you are, we have the confidence that you are going to represent us well. Thank you very much for this presentation. Thank you very much. Our own Charles Ajiboye. Wọ́n sọ pé onítorí kọ pé kò dùn. Wọ́n á ní pé ká wá fún ẹ, but àwọn àgbààgbà ní àwọn tó wà lókè pé ó dùn, àwọn tó wà lẹ́yìn kò dùn. Ṣùgbọ́n ó kọ bí Ògúndé. Okay. So torí pé kíkọ bí Ògúndé yìí àti orí irùngbọ̀n náà tó jọ ti bàbá Ògúndé nígbà tó wà ní wọn kékeré. Charles, we are very proud of you. We have followed your antecedents at the NBA. We are proud of your representation. You have made us proud in every way, and you have repeated same here. We didn't know that you have the ability to become a music and whatever, but when BRF was speaking in the morning, he spoke about other sort of facilities that we need to develop. So we are going to take interest in your singing ability and see what we can do about it. Thank you very much. Thank you. Congratulations. Okay. Your recording, please. You have a sign. Please sign him up. Sign him up.
Ètò náà ń tẹ̀síwájú. A dúpẹ́ lọ́wọ́ gbogbo àwọn àgbààgbà wa, àwọn ọ̀gá wa nínú iṣẹ́ yìí àti nínú ẹgbẹ́ Amòfin Oòduà. Ẹ rí i pé ọwọ́ ẹ̀rọ ló mú wá torí òjò tó rọ̀ yìí ó fi hàn wá wípé Ọlọ́run ní ọwọ́ sí nǹkan tá à ń ṣe níbí báyìí lónìí. Ní agbára àwọn ọ̀gá mi tí mo fẹ̀yìntì ń bí àti Ọlọ́run, màá máa pe arábìnrin wa Ọláìdé kí wọ́n wá gba ẹ̀rọ gbohùngbohùn yìí lọ́wọ́ mi torí ètò yìí ó sì gùn ṣálálu ṣùgbọ́n a ó gé pé bí àwọ̀ bàbá ìṣọ̀nà. Arábìnrin Ọláìdé. Mo ń fi àkókò ìpè Mr. Lawal Ibrahim sí orí ìjókòó ń bí. Aṣojú ọ̀gá wa Professor Kọ́yìnsọ́lá Ajayi, Senior Advocate of Nigeria. Arábìnrin mi ṣe ti ẹ ti ṣetán. A pè distinguished Senator of the Federal Republic of Nigeria, Adeni Adibomirin, Senior Advocate of Nigeria, please. Please put your hands together. Thank you very much. Mi ò rò wípé àwọn àǹtí wa Mrs. Mrs. Abimbola Akeredolu, Senior Advocate of Nigeria, mi ò rò pé wọ́n wà nínú ilé pẹ̀lú wa ń bí. Ó dà pé òjò yẹn dá wọn dúró díẹ̀. Nítorí náà, a ó máa bá ètò lọ pẹ̀lú àwọn ọ̀gá wa tí wọ́n wà níbí. Arábìnrin Ọláìdé, ó dọwọ́ yín.
Ẹ ṣé púpọ̀. Ẹ káàsán gbogbo ilé, mo kí gbogbo ilé o. Ẹ káàsán. Orúkọ mi ni Ọláìdé Olúwayọ̀mí Ajéwọlé. And I will be the moderator for this session. This session is about welfare of lawyers in a declining economy. Economic challenges confronting challenges confronting lawyers in modern times. Ní òótọ́ a mọ̀ wípé profession wa, legal profession happens to be the most dominant and influential profession in Africa, and it's unrivaled. And it covers policy defense of rights and pursuit of justice. Because of our status, our special skill set and training, lawyers have opportunity and indeed the obligation to attain the nation's political imperative of consolidating democracy and growing the economy. Lawyers in developed countries, generally, we can testify to it that they are well placed, better than lawyers in third world countries. And because of this, they have been admired. In fact, we admire them. And báwo ni ọ̀bọ ṣe ṣorí tí ìnàkí ò ṣe? So we want to see, in this panel, we want to discuss how can we catapult ourselves from where we are to where we want to be. And we cannot overemphasize that welfare of lawyers has a huge role to play. And because of these welfare issues, it has affected a whole lot of things. It has affected delivery of our duties as lawyers. It has also affected or resulted in mental ailments. We might not be able to discuss or openly say this or want to accept it, but it's something that we should all come to terms with, that this has affected us. It has affected our profession. And it has also degenerated into our private affairs, our lives, our businesses, the way we conduct ourselves, the way we carry ourselves. That's the reason why you will see a lawyer out there shouting at an innocent person or shouting at, the police station, instead of us to comport ourselves to, do our duties. So therefore, this session will assist us, today lawyers or today legal practitioners, to stay afloat despite economic challenges amidst ever-evolving laws, policies, technology. Now we have AI. I don't know the Yoruba AI. Who knows? Anybody in the house? Anybody in the house? What's the Yoruba for AI? Artificial intelligence. Ayarabiasha. Please clap for him, everybody. Please clap for him. So, we would also want to see how we can meet our SDGs. We also want to see how we can, satisfy the insatiable demands of our clients and also stay professional and balance our life and our work. With me today, I don't need to do another introduction. The specialists on this panel, they've introduced them. So thank you very much, Senator, and thank you, sir, for joining me. I wouldn't know, do you have a speech for us? Please, you can take the, thank you.
Let me start by standing on the existing protocol so that I will not waste much time. I'm standing here for the presenter, Dr. Kanya Ajayi, Senior Advocate of Nigeria, who is unavoidably absent today. And the reason for his absence had been explained to all and sundry, so I need not go back there. I want to start by saying that the presenter had done a very good job, and he has sent to me his papers, which is titled The Welfare of Lawyers in a Declining Economy, Economic Limitations Confronting Lawyers in Modern Times. He started with a quote from Jeremiah 22, verse 13, that says, "Woe unto him that buildeth his house by righteousness, and his chambers by wrong, that useth his neighbor's service without wages, and giveth him not for his work. Behold, the hire of the laborers who have reaped down your fields, which of you kept back by fraud, creates, and the cries of them which have reaped are enter into the ears of the Lord of Sabaoth." James 5, verse 4. And also in Ibn Majah, one of the tradition of the prophet, it says, the Sunnah says, you should pay the laborer his wages before his sweat dries. That's the Sunnah of the Holy Prophet. There is no gainsaying the fact that globally, the legal profession is universally recognized and revered as one of the noblest professions. The legal profession is the backbone of justice, which is undeniable. And by providing legal representation, advice, and advocacy, the legal profession protects human rights, resolves disputes, and promotes social justice. Moreover, legal profession helps shape public policy, draft legislation, and facilitate economic growth by providing legal frameworks for businesses and transactions. You can't deny the beauty of legal profession, and he has done a fantastic work with that introduction. The contemporary Nigerian lawyer in an economic downturn. The World Bank report on the economic overview of Nigeria reveals that the poverty rate reached an estimated 38.9% in 2023, implying that about 87 million Nigerians live below poverty line. This makes the country with the second largest poor population in the world, following India. And the factors responsible for this are economic instability, corruption, inadequate infrastructure, and a high employment rate. This economic recession had significantly affected or impacted the legal sector, leading to job cuts, inadequate compensation from employers, neglect of welfare packages, and a surge in unemployment rates. A further reality check reveals that despite the Council of Legal Education's awareness of the declining economy, it enrolls a considerable number of students each year into the law school. Also, faculties of law take in students beyond stipulated quota. That's why we have had experiences of a lot of law students who have not been able to gain admission to law schools because most of their faculties had exceeded the quotas given to them. And even at that, those who wrote in 2024, a total of 4,412 students out of 5,300 who wrote the bar final exams were called to the Nigerian bar. The admission process into the Nigerian law school now mirrors, can be compared to the town planning strategies who continue of numerous states in the country. They authorize the construction of as many buildings as they can without proper scrutiny to avoid losing potential revenue. This analogy is fitting considering the yearly increase in student admissions, thereby creating an overcrowded structure where many find it challenging to maintain their well-being. Despite its numerous welfare initiatives, the Bar Association has been continuously accused of being only interested in the revenue it generates from members' annual dues rather than their welfare. As previously stated, the economic downturn had resulted in insufficient remuneration, and the paper was able to crystallize average earnings of young lawyers and average earnings of senior lawyers from Ibadan down to Lagos. And this can be found on page 3 of the paper. And so the paper went on to say that for the purpose of this presentation, the paper had classified legal practitioners into 3 distinct categories: viz, laborers, professionals, and entrepreneurs. It is necessary to fully comprehend this categorization to devise tailored solutions to improve the welfare of lawyers in the country. The laborers. These are lawyers who live on daily wages and minimal appearance fees. They earn daily on cases in court and represent other lawyers holding briefs for paltry sum. They exert tremendous effort but lack strategic thinking. They voice their frustrations about the difficulties of practicing law in Nigeria, yet they overlook the opportunities and resources for a successful legal career. B, the professionals. These are lawyers who employ strategic approaches and are thriving in their careers. Despite the economic downturn, they earn a substantial income that affords them a decent lifestyle. They not only delve into the conventional litigation practice, but also explore alternative practice areas to augment their income. These professionals command a significant level of respect in the legal sector. C, the entrepreneurs. These are professionals who earn significantly more than what is needed for a comfortable lifestyle. Their success can be attributed to their creativity and willingness to take calculated risk to enhance their legal careers. They are not just lawyers, but investors with a suitable risk appetite. They have a deep understanding of the principle of income generation. They possess sufficient business acumen to manage their legal business. And this gives them a competitive advantage over others. They are better described as legal entrepreneurs. Given the global financial crisis, increase in technological advances and globalization, the concept of legal entrepreneurship is getting increasingly popular. Legal entrepreneurship is a forward-thinking approach that combines legal expertise with entrepreneurial spirits. As earlier stated, the declining economy in the country poses a significant challenge for the legal sector, and the sector needs to evolve in response to this economic shift. To address this challenge, the paper went on to consider the following strategies to combat or enhance the overall welfare of lawyers. First, adequate remuneration of legal practitioners. Senior lawyers in Nigeria are obliged to ensure lawyers in employment are adequately remunerated. Paragraph 22D of the guidelines for the conferment of the rank of Senior Advocate of Nigeria and related matters 2022 is instructive on its requirement for applicant for the rank of Senior Advocate of Nigeria to pay the counsel in their chambers the level of remuneration relative to the remuneration policy established by the Nigerian Bar Association from time to time. However, what we have seen in reality is that most of those senior lawyers and senior advocates do not follow these guidelines. They have observed it in breach, and it's so unfortunate that we find ourselves in that kind of a situation. So the paper went on to advise those senior lawyers to please, follow those, rules and regulations towards ensuring the welfare of their, lawyers that they employ in their chambers. 2, discipline and sanction. Senior lawyers are often seen by the young lawyers as role models who are worthy of inspiration, especially the highly regarded individuals who are senior advocates of Nigeria. However, this high regard by young lawyers for these supposed senior lawyers is thrown to the wind when they are being maltreated and underpaid. Despite the provisions of the guideline that made senior lawyers to adequately remunerate lawyers in Nigeria, Rule 48 of the Rules of Professional Conduct for Legal Practitioner, 2023, RPC, which provides that a lawyer is entitled to be paid adequate remuneration for his service to the client and the legal practitioner remuneration for business legal services, 2023, made by the Legal Practitioners Remuneration Committee as a solution to address and regulate the remuneration of lawyers in Nigeria, maintain and respect for the profession. Most senior lawyers have shamelessly flouted the provisions of the law. Order 81 and 2 of the order provide that the fees chargeable for any business or service conducted by a legal practitioner are as prescribed in this case set out in the schedule to the order, and they are not subject to negotiation except as prescribed in this order. Hence, a legal practitioner who contravenes these provisions of the sub-order 1 of this order is liable for unprofessional conduct and shall, without prejudice to the provision of this order, be liable to such punishment as may be prescribed by the Legal Practitioner Disciplinary Committee. From this, senior lawyers and senior advocates should be custodians of the values of the profession and set good precedents for upholding the values and tenets of the profession. As a result, where a lawyer or senior advocate of Nigeria is found wanting in implementing the provision of this order, such persons should be disciplined and sanctioned by the Nigerian Bar Association and the Legal Practitioner Disciplinary Committee, LPDC. The sanction could be in form of admonition, warning, presumption of participating in the activities of the NBA, withholding letters of good standing, and so on. Also, the third one is legal entrepreneurship. Legal entrepreneurship is an optimal path for legal professionals to personally enhance their well-being, especially in this era of technological advancement. Many authors have concluded that entrepreneurial lawyers will be highly valued in the globalized market of the 21st century. And it entails acquiring competencies like strategic planning, leadership attributes, and inventive problem solving. Embracing an entrepreneurial spirit implies formulating novel legal methodology to adapt to the evolving demands, and so on and so forth. Investment in artificial intelligence like AI, they have dealt a lot about it, and we know what AI does. It reduces the amount of time, that one will spend in doing research and also correcting, mistakes in a lot of things that we have done. So we should do a lot of things. AI is important in the area of conduct of legal research, handling of e-discovery, document review, and proofreading. Case outcome forecasting, increase efficiency in legal work, and so on and so forth. And also, part of the solution is merger of smaller firms. Those errors are gone where you have room and parlor legal practice, the drift is towards mega law firms, and we must strive to merge as many law firms as possible to have a bigger law firm in order to enhance productivity, to even enhance efficiency, and will also make us be able to pay more for the lawyers that we have employed in our chambers. So it is very, very important. Rating and ranking of law firms too should be part of solutions to all these problems. Sponsorship of continuing legal education by the Nigerian Bar Association and other non-government organizations. The NBA should not be tired of sponsoring its members for continuous legal education, which will make them or afford them the opportunity to also improve their efficiency, build capacity, and make them resourceful in their trade. Investment in personal professional growth by lawyers too. Lawyers themselves must invest in their professional growth. Gone are the days when some lawyers who practice do not even have any book. They don't have law reports. They don't read law reports. And there is no way fortune can smile on that kind of a lawyer. So a lawyer must also be able to invest in his own personal development so as to attract good offices, for employment. Investment in business opportunities too. Lawyers must not be regimented. You must not, make yourself only a legal practitioner. You must also invest in business opportunity to also ensure that you are able to navigate the current financial difficulty. The paper concludes by saying, in the future, only lawyers who can devise enduring competitive benefits for clients across diverse cultures and jurisdictions will rank among the most successful and sought-after legal practitioners globally. Therefore, the law schools must educate lawyers to be aptly equipped to meet the competitive requirements of their environment. The importance of teaching law students beyond the stereotypical concept and procedure was properly addressed by Gilmore almost 100 years ago, 1921, and it remains obtainable now. Our law teaching is too much a teaching of, that's fixed conception, with inadequate consideration of whether the reason behind the conception still exists as applicable to modern conditions of social and economic life. The law school in these countries have consistently avoided confronting their issues. As with many institutions passed down through generations, they have been hesitant to question the initial rationale behind their strategies and curriculums, or to investigate if the once valid reasons still hold their relevance today. Furthermore, lawyers must strive and invest substantially in their personal growth. This is the key towards safeguarding their welfare in this declining economy. Importantly, various groups within the legal sectors, along with high-ranking practitioners, must prioritize the protection of the well-being of all legal practitioners, with a special emphasis on the younger lawyers. Now more than ever, the moment is ripe, and the circumstances are favorable for individuals and groups within the legal profession, whether law students, junior legal practitioners who are still finding their footing, or senior legal practitioners who have years of experience under their belt, to embrace and implement the strategies that have been previously discussed. Legal associations, with their collective influence and reach, also have a significant role to play in this process. The importance of these strategies cannot be overstated. They are not just beneficial, but crucial for shaping a future that is desirable for those in the legal profession. In these envisioned futures, lawyers, regardless of their level of experience or area of expertise, will be able to maintain their dignity and, most importantly, ensure their welfare. They will be able to do so in the face of an economic crisis, which can often pose challenges to the legal profession. These strategies will ensure that the legal community is well equipped to navigate any economic uncertainties that may arise, thereby securing a stable and dignified future for all its members. This is the future we must strive for, and the time to start working toward this is now. Thank you very much.
Thank you very much, Mr. Lawal Ibrahim. We thank you so much for the speech. I will start by saying this, that one of the things Egbe Amofin Oodua has been able to do over the years is to ensure that every lawyer have that sense of belonging. And this didn't just start with Egbe Amofin, it started with NBA, Nigerian Bar Association, whereby I can authoritatively say that the whole essence of Nigeria Bar Association and Egbe Amofin is to cater to the welfare of its members. And Egbe did not forget this. Egbe made this conference, made it happen. The planning committee of this conference made it happen by providing career opportunity upskill for anyone, for members, for junior lawyers that would be ready, to catapult himself or herself to the next stage. And I think the Egbe actually deserves an applaud. Please, can we give them a round of applause, please? Thank you very much. And moving on, the Bible says that, and I like the fact that you started with the Bible verse and also a surah from the Quran, from the Holy Quran. Thank you very much. It shows that what we are talking about is not just based on what we are thinking. It is humanity. We are talking about humanity. We are talking the art of God. Now, the Bible says that, and I will say it in Yoruba to drive it home. Tí ìpìnlẹ̀ bá dá tó bá bàjẹ́, kí ni olódodo máa ṣe? Our foundation is our welfare. If I cannot look after a fellow lawyer like me, and a fellow lawyer like me cannot look after my own welfare, then what are we calling ourselves Ọmọ Ẹgbẹ́ for? Why are we a member, or why are we members of Nigerian Bar Association? Why are we members of Egbe Amofin Oodua? A máa ń sọ pé kí Oodua kó gbé wa, kí ilé àwọn bàbá wa kó gbé wa. It starts with us. Now, my question would go to you, distinguished Senator, sir. And I will start by asking that, how can legal profession promote a culture of collaboration and teamwork to reduce unhealthy competition and stress? So we know that we have all these mushroom, he said something, he said parlor practice, room and parlor practice, because it doesn't make any logical sense. And that is what, to start with. There is a remuneration order, because room and parlor practice wants to thrive. They'll be like, what a law firm would actually charge for maybe 500 million naira to say, you will go and shortchange yourself and charge 1 million naira. At the end of the day, you'll now be struggling to deliver on the work and also to make sure that at least the client has something and you have something in your pocket. What do you have to say about that, Leonard Steele and distinguished senator?
Thank you very much. Let me start by saying that it's my pleasure to be here. And I must commend Egbe Amofin, as led by Olagbuju. Because I remember a few years ago, we were in Ibadan, and this was some of the things I raised to say, what is the essence and importance of Egbe? Other than at that time, elections. That why would you attract people to join you when there is no benefit? So I commend the leaders of Egbe today for having what I would call a paradigm shift. Secondly is that these days I get to be called only to political gatherings. So it's my honor to be called to a gathering of lawyers. Unlike in the last 1 year, where every time I'm called to come and talk politics. But having said that, I think that one of the greatest challenges facing lawyers, is that
business. I think that's the first thing. That legal practice, you must understand economy. Better. You can, the first thing you need to do is understand the economy as a lawyer. And I tell you why I say so. You talk about a declining economy. In a declining economy, people make money. Don't misunderstand that. People make money. And I'll give a simple example. So in a declining economy, you have creditors chasing debtors, and you have debtors looking for protection. On both sides, you have the need for lawyers. Now, what I've seen about most lawyers is that we don't follow economic trends. We don't follow current affairs. We don't read the economy. What we are used to is to say, oh, AMCON is now giving work. We rush there. NDIC tomorrow, we rush there. Let me tell you a personal experience. You know, I practiced actively for 35 years until last year when I decided to go into public service. And I remember years ago when Alukwalebode was formed in 1993. And I went to a very senior lawyer. And he asked me what we do in Alukwalebode. So he said, do we do mortgages? I said, no. He said, do you do upstamping? I said, no. Do you do land matters? I said, no. Do you do chieftaincy matters? I said, no. He said, then what do you guys do? So I said, what we do mainly is commercial litigation, commercial practice, etc., etc. And he said to me that you guys are not practicing law. And I said, sir, the point is that you don't understand that law has moved away from where you are coming from. So by the time Alukwalebode started a proper commercial legal practice in Lagos, there were not so many of us who were doing it. But we saw the future. That look, in another 10 years, where there would be the ability to make money would be commercial practice. So by the time a lot of people joined the bandwagon, and you had, and I give an example. At that time, you had people like Chris Ogunbanjo, SP Ajibade, who were actually a minority in old firms that were actually doing commercial legal practice. And what is the point I'm making? Is that when you talk about welfare, you talk about the ability of a lawyer to afford the things that are necessary, basic for not only his work, but also his livelihood, his living, etc., etc. You cannot run practice in the traditional way any longer. And the danger, as I say it, is that a sizable number of young lawyers are not doing the right things to actually make their practices successful. And I give another simple example. How many of us invest in practice? So a man makes maybe his first brief, he makes first big brief, he makes 20 million. The first thing that occurs to him is Ejeki Lora Le. Yes, Ejeki Lora Tokumbo. Now, in an Alukwalebode setting, we will say, what are the things that we need to improve the practice to make 100 million naira? So we are understanding the economy, that the economy is going to move. So for me, I think the first thing lawyers need to do, current affairs, news. Now, how many young lawyers understand that about practice? And I repeat, if they make money, I want to go and buy land. I need to buy a Tokumbo car. So we need to understand that practice is a business. It has to be run like a business. You talk about mushroom law firms. I wouldn't want to call anybody a mushroom firm. What I would say is that the legal practice has grown in such a way that a one-man proprietorship is not the best way these days. And it simply is that people are looking for expertise. You can be a first-class graduate. I always tell my lawyers a very simple thing. Somebody will come to a Dr. Ajibade or to Mrs. Akeredolu SCN or to Dikindele Adesina SCN or to Kunle Adegoke SCN, not because they are the most brilliant lawyers, but the person is paid for expertise. That's the reality of it. So if I sat down and I said, come and pay me 100 million, a first-class graduate from the first law school would ask for 5 million and they would say, oh, in school. That's the reality of life. Because other than his certificate, he has nothing to offer. He needs to understand that. But he needs to make the best use. So what should he do? He should say to himself,
let me look for people of like minds, 2 or 3 friends. Let's come together. We'll be able to network better. Maybe one is a great litigator, I'm a great solicitor, the other guy is a good marketer. So you say to him, the marketer, go and market. The solicitor, let's look for solicitors work. The litigator, that is how big law firms are built. There is no magic, it's not rocket science. That is how big law firms are built. So if you sit down somewhere, you may be a great litigator, but you don't know how to market. You don't socialize. Somebody will give work to B&I because he's Asu's friend. Somebody will give work to Alukaibode because Niyi is my friend. Not necessarily because Niyi is the best lawyer. So my advice is that we need to understand that legal practice is a business. Thank you.
Thank you very much, distinguished Senator. Amomo ipe ari koko dimu nínú ọ̀rọ̀ tí wọ́n sọ. Expertise can never be overemphasized, and we cannot push it aside. I will quickly go to my mommy, my mother, my role model, as a matter of fact. And I would like to ask you, Leonard Silk, that it's very related to the first question. How can law firms prioritize lawyers' well-being? It's just shifting away a little because, yeah, we have discussed about the mushroom, how to just move away from that myopic, mind to something that, okay, we can do this. Yeah, it's only if we can just put the right pole in the right hole. Now the question is, how can law firms prioritize lawyers' well-being without compromising billable hours and productivity expectations?
Thank you. Please, I want to start by expressing my gratitude to the Egbe. I'm ashamed to say this is my very first time of meeting the Egbe. And being a proud Yoruba daughter, I want to introduce myself. Èmi ni ọmọ yín, Abímbọ́lá ọmọ Adéjùmọ̀. Aya àti ìyáàfin nílé Akérédolú. Wọ́n ní ẹni méjì ní ń bíyàn. Lápá kan èmi ni ọmọ Ajílálẹ̀ Ẹ̀ṣọ́. Ọmọ Ají fọjọ́ gbogbo dáa bí egbin. Ọmọ lówó kan bọ̀yọ̀, wọ́n nítorí kíni ó nítorí ara ẹni. Èmi lọmọ ọ̀kẹ́nìkan dẹ́nìkan sí, bí mi ò kẹ́nìkan kí ni bàbá ẹnìkan fẹ́ ṣe sí i. Èmi lọmọ àgbásáníjà, ṣàkìtì, lọ́ṣọ́ àgbárò ìgbíyọ̀. Èmi lọmọ àgbòrọra jókòó má bàa jẹ́lẹ́tẹ̀. Lápá kan, èmi ni ọmọ awíjọ́ pọ̀nù bí abẹ. Èmi ni ọmọ atẹ́ni wíjọ́ kí wẹ́wẹ́wẹ́ díẹ̀ má bàa gbọ̀n. Èmi lọmọ ajógbẹ̀rú má jógbẹ̀kọ. Nítorí ẹrú ní sinmi, ẹ̀kọ́ kìí sí nìyàn. Lápá kan, èmi lọmọ wọn olóṣòdì tápà. Àyè tó gbá tápà yìí fi kọ́lé ìkùnú nípínlẹ̀ Èkó. Ẹgbẹ́ mo kí yín o. To my brothers from across the Niger, I have seen Chuka. Chuka, I can't interpret, it is Yoruba poetry. But one day, when you learn the Yoruba language, you will see the beauty of Yoruba poetry. I come to answer the question. They say, what can law firms do to prioritize lawyers' well-being without compromising billable hours? If a lawyer is employed in what we call magic circle law firm, and you are up and doing, well known for doing your work, it follows that your interest will naturally be taken care of. Because like Senator Adegbomire's SAN said, law practice is a business, and no good businessman wants to lose a good hand. So, it is, they say, seek first the kingdom of God and its righteousness, and all other things will be added unto you. Seek to be good at what you do. Seek to serve. Give your best to the firm. And naturally, the firm will look after you. If they even hear that maybe you want to leave or someone wants to poach you, they will improve your offer to keep you. That way, the issue of billable hours is taken care of, and your interest is also taken care of. I have known very good lawyers who have said they are leaving a firm, and they have been offered better packages. Some have even been offered partnership. That no, we want you so much, we don't want you to go. We're going to make you a partner, and that person naturally stays. Billable hours are taken care of. So it is. They say ọmọdé bá ṣípá, ọmọ tó bá ṣípá ni ìyá ẹ̀ máa gbé. So any lawyer tó bá ṣípá, ó di dandan kí ilé amòfin tó ń bá ṣiṣẹ́, ó di dandan kó gbé, kò ní fẹ́ kó lọ.
Thank you very much, ma. Thank you. In simple terms, what she's trying to say is make yourself valuable. The more you make yourself valuable, the more you invest in yourself, even your law firm will invest in you. Agbajowo la kuku fi ń sọ̀yà. Àjòjọwọ́ kan báyìí, kò gbẹ́rù dòrí rárá. Thank you very much, Leonard Silk. Thank you. I would like to go to some aspect that I think it's a little bit generic. And sir, I will come back to you. How can lawyers, contribute to the achievement of, the first plenary session was about the Constitution, the second plenary session was about justice system. This is the third plenary session, we're talking about the welfare. And everything they have said rests upon the welfare of lawyers. And I've always been saying this to the members of my branch. I would say that I have this adage I always say to my branch members that I prefer to touch lives than to touch caskets. That if I have the power, I will give everybody good health and life. Unfortunately, I'm only a human. I can't do that. I don't have the power of God. Now, I want to look at the whole country as a whole. How can lawyers contribute to the achievement of SDG 16? And I'll tell you what it is. Peace, justice, and strong institution through our work. How can lawyers contribute simplicity to it? How can we just make it work? Because, in my opening remark, or when I was reading the citation for the panel, I said, yes, I said something that we are looking at our contemporaries that are abroad. We are jealous of it, or maybe, positively jealous of it. We want it to happen. But are we doing the right things to make it happen? So let us quickly discuss this, because I've been told that our time is up. How can lawyers contribute to achieve
peace?
Yes, peace, justice, and strong institutions through our work.
I think the first important role a lawyer must play in the society is to ensure that there is peace. It is not every matter that they take to your chambers that you go to court. You must look at the issues, whether they are resolvable. If there are issues that are resolvable, we must try as much as possible to encourage, mediation. We can do that in our office and ensure that the matter is, particularly matters that borders on families. When they drag issues amongst themselves, we must ensure that we don't allow the family to drift apart. It is our responsibility to call them and speak through to them. It does not matter what you want to earn as fees. We must maintain peace. We must also be candid to our client and ensure when your client has a weak case, you must be able to advise your client. Why don't we seek for alternative resolution? In doing that, I am sure that we will be able to promote peace, and we will also be able to save, judicial time that could have been wasted on frivolities.
Thank you very much. Thank you very much, sir. I would like to ask the last question across board, and I think I would like the distinguished senator to, speak to it first. The question is about inclusivity, like let us have everybody included. And I want to particularly make mention of mental ailment lawyers that have actually kind of experience that at a point in time? Do we sideline? Do we, we just push them aside? The ones that are our friends with special needs. What are the initiatives that we have implemented in our various law firms, and what are the things that you would rather suggest?
Sorry, Ms. Moderator, we are sorry we have to interrupt you. Distinguished guests have, long distances to cover in going back and what have you. We enjoyed the session and we want it to continue. But considering that there's going to be another session immediately after this, and considering the time so much well spent with them, and a number of other things to be done, please, we have to interrupt you. We may have to end this session at this particular stage. We very much thank you. So you may have to, please.
Thank you, Leonard Silk. I think that will be the end of this session. Thank you very much, everyone. Thank you.
mo fi tọ̀wọ̀tọ̀wọ̀ pé àwọn ọ̀gá wa Dikindele Adesina, Senior Advocate of Nigeria, kí wọ́n bá wa fún àwọn àlejò wa ní àmì ẹ̀yẹ yìí.
Please, Alhaji Nuruddin Ogbara, please join us here. Dr. Murtala Abdurrashid, please, you have to join us here for presentation of the gifts. Kindly don't run away because you still have a function to do for us, during the last paper for today.
Well, thank you very much for this privilege. This is for Professor Kanyinsola Ajayi, Senior Advocate of Nigeria, ably represented by my big brother, Ibrahim. And thank you very much for your paper. In appreciation of your insightful and engaging contributions as a speaker at the Egbe Amofin Oodua National Conference 2024, I have the honor to present this on behalf of the Egbe in appreciation of your contribution. Thank you so much and God bless you. Now to my big brother, the distinguished senator. Big brother. He used to interpret the law, but right now he's making the law. And with assembly of people who are still interpreting the same law. And please, before I present this, I want you to note in particular, and if you do not take away anything from this meeting, take this suggestion. The days of Philip and Co., Morris and Co. are over in legal practice. About 10 or 8 years ago, we went for International Bar Association Conference, and I visited a chambers in Chicago. There were 160 people in that chamber, 60 lawyers. And altogether, there were about 160 lawyers, 60 paralegal. The accountant was a chartered accountant. That will tell you what they are doing. And like the senator said, not all of them are litigation lawyers. Some are business advisors. So please, let us look for like minds and explore the possibility of tapping each other's acts. When you put all the resources together, you become unbeatable. Thank you very much for your suggestion, my brother. In appreciation of your insightful and engaging contributions as a speaker
at the Egbe Amofin Oodua National Conference of 2024, we present this to you. Thank you very much and God bless you. Now, to my beautiful sister, I was trying to tell her that she has been hiding this aspect of her from some of us for 20, 30 years. I asked if she was also a professor of Yoruba language in any of the universities. I'm really very impressed because Yoruba has a deep value, a great philosophy. Every single word that you said carries its own meaning to that family. And thank you for being proud of the family, for being proud of yourself as a Yoruba woman, and for being a very, very source of inspiration, even in this profession. On behalf of Egbe Amofin Oodua, we appreciate you for your presentation. Thank you very much, and God bless you. Well, thank you very much. Olaide Oluwayomi Ajewole. In appreciation of your participation, actively moderating. I mean, when you are moderating people like Ibrahim, senior advocate, and somebody who combined the interpretation of the law as an advocate, now to making the law as a senator, is not easy to moderate. And you did very well. Thank you very much on behalf of Egbe Amofin. More grace to you. Thank you. Thank you very much. Thank you.
ẹ ṣeun ẹ bá pàtẹ́wọ́ fún wọn o. ẹ jọ láì gbára wa ní àkókò a máa lọ sí abala tó gbẹ̀yìn. Mo pe Adéọlá Fọlárìn ó lè gbẹ́ níwẹ̀ wọlé. Mo fi tọ̀wọ̀tọ̀wọ̀ pé Mr. Ayọ̀délé Òní, ṣé dókítà ni wọ́n? Dr. Ayọ̀délé Òní. Mi ò rò pé wọ́n wà round. Ẹ bá pàtẹ́wọ́ fún wọn o. Ẹ jọ ẹ bá pàtẹ́wọ́ fún wọn. Kò ní rẹ̀ wá o, ẹ bá pàtẹ́wọ́ fún wọn o. Mo ní àǹfààní láti pe ẹnì kejì Dr. Ọládùnní Ọ̀wọ̀ wá sí orí àga gíga ní àyín. Dr. Ọládùnní Ọ̀wọ̀.
Sir, do you have your bag, your conference bag?
Pápápá ni a ó ṣe abala yìí. Mo rọ arábìnrin wa kí wọ́n má gbà wá ní àkókò púpọ̀. A dúró de àwọn arábìnrin wa kí wọ́n tó dé. A tẹ̀síwájú pẹ̀lú ètò náà. Doctor, you're welcome, sir.
Yeah. No, let me just do the introduction.
Ẹ jọ ẹ bá fi kalẹ̀ sí o. Abala tó kẹ́yìn nínú ètò wa rèé. Ẹ ṣeun.
Please, can we take our seats? Please, let's have our seats. This is the last and final session for today before we go for our Ashale Asha. So, the topic is on investment opportunities and challenges in gas to power, the prospects and the challenges. So I'll not take much of our time. I'll just go straight to business. Our lead speaker, Dr. Ayodele Oni, will take up the podium. Thank you.
Please, respectfully, sirs, please, sirs, the lead speaker is going to deliver a paper on oil and gas. Please, can we all sit down, please? Please, thank you. He's been here since 10 a.m. Please, sirs. Please, can we have our seats? Please, can we have our seats, sirs? It's very important so that the speaker can talk to us. Thank you.
Ẹ káàsán ẹ̀yin bàbá mi, ẹ káàsán ẹ̀yin ẹ̀gbọ́n mi, ẹ káàsán ẹ̀yin sàwáwù mi, ẹ káàsán ẹ̀yin àbúrò mi. My name is Ayodele Oni, and I'd like to stand or maybe sit on existing protocol. What this paper will be doing is bringing to your attention a few business opportunities many of us have taken for granted, particularly those of us that are Yoruba lawyers. Whilst I'm not being tribalistic, but I've done quite a bit of research around oil and gas, and I find out that not many lawyers are involved. Even the low-hanging fruits, not many lawyers are involved. Not many of us from this tribe are involved. For example, I'll give you a simple one. LPG plants, cooking gas plants. You will be shocked that there are people making ₦1 million a day. I'm not talking about big plants. And I speak from personal experience because I have similar investment in those businesses. Easy, low barrier for you to enter. You do your law. I always say that law practice will bring you your gushers every now and then, but not necessarily every day or every month. But I can show you data here. I can show you information sent by operators running some of those businesses. A few lawyers I know, a few people I know have invested in small LPG plants, add-on plants at filling stations. And you see 1 million, 1.5 million, 1.8 million daily income. And that's when you talk about downstream. You know, downstream thrives on economics of scale, on volumes. But you find that it's mostly guys who are unlettered, who are doing those businesses. Those of us who've gone to school do not see it as anything. But at the end of the day, those opportunities exist. Now, that's just to whet your appetite. A few quick points. A few facts, maybe 5 facts. Although people say Nigeria is an oil country, we do have more gas than we do oil. In fact, we're a gas province with some oil. 2, there's a huge gap between gas that is produced and the demand, suggesting that there are opportunities, that gap between demand and supply. Okay, natural gas reserves levels, they are around 209 trillion cubic feet. Only 6,286 million standard cubic feet is produced, with 2,570 exported. So there's huge volumes in terms of opportunity. And with energy transition, everyone is talking about going green. Gas is the transition bus stop before we fully transition. And the truth is that for the next 40, 50, 60, 70 years, we'll continue to have gas. So if we plug in early, there's always a first mover advantage, like the Leonard Silk, and it was in the Daily, so I can say it. The Leonard Silk's partner and one of the co-founders of Aluko Anoyebode is regarded as one of the richest men. But he got in early into telecoms, MTN, I'm sure many of us saw those public papers where they wrote the number of his shares. If you converted it to naira or dollars, you know what that is. And the senator, who is also a learned silk, it's easy to confirm that because it's public record. So the opportunities exist in gas for us to move in before everybody else. That first comer advantage, similar to MTN and telecoms. Now, the gas to power value chain. When you speak to gas to power, you start from producing that gas, feeding the generation plant, or maybe transporting that gas up to the generation plant. You distribute or you transmit and then you distribute. Across that value chain, there are opportunities. There's opportunity in LPG. A lot of the power plants, particularly smaller plants, use CNG, compressed natural gas. Much of this is largely methane, but when you compress for CNG and the power plants run on those, and you'll be shocked that if there are partnerships amongst lawyers, you can, and non-lawyers alike, you can invest directly or indirectly in these businesses. And at times the money looks like shesho, but it's not true. The energy sector is huge and the revenues can be crazy. And I can give you small maths. Imagine Mrs. Alakija. Agbami does about 600,000 barrels per day. Multiply that by the how much a barrel of oil is. Say 80, 70, always fluctuates. $70 per barrel times 600,000 barrels. Your guess is as good as mine, why she's one of the richest people. Also, if you look at downstream, thrives on efficiency, thrives on volumes. So those opportunities exist. I looked at CNG, I looked at the CNG ecosystem, and I found out that there aren't really those of us here involved. I looked downstream, I looked at LPG. Directly or indirectly, I found out there aren't many of us involved. And if you see the numbers, they're quite staggering, So gas to power, you move from producing that gas to feeding power plants. And you can even integrate. You can own a power plant or co-own a power plant and also have the gas that feeds that power plant. And you can then have your own independent electricity distribution networks. And it's interesting that we're beginning to see true federalism. With the Electricity Act, for example, states can now take over those segments of the energy industry in various states. And there's always, Nigeria does have a competitive advantage in terms of volumes. It's like when they say in Yoruba land, so we have huge gas volumes, and what we experienced a few minutes ago shouldn't have happened, where we have a light out. We should never have that in this country, because 80% of power generated in Nigeria is gas-fired. But gas does not move from the ground up. Infrastructural problem, commercial issues, and historical neglect in successive governments. We can't blame this government, it's relatively new, but successive governments have failed to develop our energy sector. But we all have roles we can play if we invest, because those opportunities are huge. I'll give you a scenario. In the estate where I lived, I almost started crying yesterday when I went to the estate office. They had increased electricity from 201 naira per kilowatt hour to 460 naira per kilowatt hour. People screamed when they said Bande was going to be 225. I pay 460 naira per kilowatt hour for electricity. Because a gentleman invested, built a power plant, because power is very poor. I live around Elegushi, for those who know. And that Kunsela Road and some of the environs, electricity is very poor. So some guy invested, built a power plant, and everybody, almost every estate connected. And the guy is smiling to the bank. 460 naira per kilowatt hour. Is either you have no, because you can't even bring in generators to many of those estates. But if we don't look closely, we do not see these opportunities when you speak to gas and power. Because I always tell people, law can be boring. So we try to make it interesting. This is more like a business class and an opportunity to open our eyes to those things we take for granted. When you see some guy in a filling station selling cooking gas, he's probably making 1.2 million, 2 million naira every day. That's, of course, that's gross. Of course, you will take out cost, but that's still substantial. Daily. But you laugh at him that, oh, guy, he's not speaking Queen's English. So those opportunities do exist. Now, speaking to the competitive advantage Nigeria does have, I'd said that we're a gas province. Nigerian gas is one of the cheapest, and generally, because the world is moving, opportunities also exist. See the Russia-Ukraine war. Europe was looking at Nigeria as one of its alternatives to Russia, but we're not prepared. Preparation that meets opportunity leads to success. Qatar is one of the leading countries in the world, and they pulled out of OPEC recently to face gas and LNG. And if you went to Qatar, you'd be shocked at the quality of roads, quality of infrastructure. I was in Qatar last week for meetings, and I was wowed. Save that during summer it's extremely hot, and you probably don't want to go out until 4 or 5 p.m. So if they can do what they've done with gas, not oil, generally speaking, more around gas, then we can do much more as a country, we can do much more as individuals. Considering the removal of fuel subsidy, data research has shown that depending on whether it's LPG, CNG, whether it's propane, butane, or natural gas liquids, depending on which of the gas compounds or you rely on, you save up to 30% or more than you would have spent on liquid fuel. That's another area where there are opportunities. That's why you see government pushing the CNG agenda and the gas penetration agenda. And the earlier we as individuals get involved and invest, the better for us. How do gas to power projects work? Several things. Whether to power your fertilizer plant, see Dangote's refinery. He still needs gas. Why? He has a power plant that's gas fired. So wherever you are, whatever business you do, whatever you do, this electricity we're using gas largely. It's probably coming from Egbe or somewhere else. You know, so over 80% of our gas plants are gas fired. You have open cycle turbines, you have combined cycle turbine power plants. And investment opportunities, like I'd mentioned, there's gas production, there's pipeline infrastructure, there's transmission and distribution both of gas and power. There's public-private partnerships. With the federal government fighting for local governments to have autonomy, there'll be those opportunities to partner with local governments to develop energy infrastructure and gas in particular. I hope we do pick up one or two opportunities from this conversation. And also, you would have realized that even businesses that rely on solar, they have gas, because at night your solar is off unless you want to invest so much in battery storage, and that usually wouldn't last. So more often than not, you'd have a combination or a hybrid of renewables and gas. So that tells us gas is going to be here for a long time. And if you see anyone doing energy intensive production, they rely on gas, not renewables, not solar. So gas still is crucial. And for sustainability of the environment, everyone is moving to gas. What are the challenges we see with gas in Nigeria? Shortage in gas supply. Not because we do not have that gas in the ground, but because historically we've neglected infrastructure, we've neglected the commercial arrangement, and we've neglected good gas policies until Obasanjo, who kickstarted the gas sector. I've mentioned market dynamics and pricing. Financing challenge. Africa needs to, and Nigeria in particular, needs to be more self-reliant when it comes to financing, because you will find out that international policy is always self-serving. US's policy only seems to suit you when it suits them more. They don't really care about us. So we need to begin to think about our own policies to drive an African agenda. With the free trade arrangement within Africa, there are opportunities. We need to look more within for financing and less internationally. Inadequate infrastructure has also been a problem, like I'd mentioned. I think that be all around this conversation. So there are opportunities, there are challenges, but a businessman sees the opportunities in the challenge. Like my pastor will say, you make money by solving problems. The more problems a country does have, the more opportunities there are. With federalism being pushed, with states now having the power to do more around energy, it means those of us seated here have the opportunity to collaborate with states, to collaborate with sub-nationals, and generate income from solving problems and from such collaborations. Esheo.
Thank you very much, Dr. Oni. Thank you very much. Ẹ ṣé púpọ̀ fún explanation on gas to power sector. I must commend that you have really opened up our minds to the opportunities in the gas to power sector, the downstream, and of course the LPG. You had talked about renewable energy, and looking at Nigeria, that we have not tapped so much from this opportunity. How do we as lawyers take advantage of these opportunities?
Okay, I'll say two things. And I've seen more senior lawyers who are successful do this. Okay. When you have the opportunity to advise, at times those companies are willing to give small equity for your advisory. You can always do a mix of professional fees and equity in the business. I wouldn't want to mention further names, but I see a few of my egbons here who have done that in the past. They do not know I know, but they've done that in the past. So that's one opportunity, beyond investing directly yourself. And the learned Senator and learned Silk previously had mentioned partnerships. So we can partner to set up small businesses. I've heard it said that you can start small, just do not remain small. You can pivot, you can accelerate. So it's two ways: partnership, or when you have the opportunity to advise, you take a mix of equity and professional fees.
Thank you very much. I also want to ask you, conversation around gas to power. When we talk about our cars, we fuel our cars through fuel, petrol. Do we have other opportunities for Nigerians to power their vehicles?
Okay, interestingly, I'm not necessarily a fan of Elon Musk. I'm more pro-Trump when it comes to energy policy. So I think that whilst there are opportunities around conversion to CNG, and those technologies have been proven to work, you also have battery vehicles. You have EVs, electric vehicles. Those opportunities exist, and you save. Actually, research has shown that you save. And for fuel, we did do research in one of the businesses I am invested, and there was a 28 to 32% savings when we moved from using diesel to using LPG to power the generator. So it does exist, that opportunity, whether it's for cars, whether it's for machinery.
Lastly, I'm going to ask you, you talked about starting small scale, and you made examples of people that could not even speak good English and how they cash out on daily basis. As lawyers, in what areas can we tap this opportunity? You know, we like the tying of tie, wearing corporates. How do we now come to the level of partnership or doing businesses of doing gas business?
Okay, several opportunities exist. One of those is even consultancy. Many lawyers you see on boards of gas companies, of oil companies, started by just advising them. With time, they value the quality of your advice and they ask you to join their board. From joining the board, you may then have opportunities to buy equity. That's one. Secondly, it could even be as small as writing on the sector. You'll be shocked at opportunities. And I can tell you a quick story, maybe not directly related. I wrote an article in 2008, 2010. In 2014, I was going to give birth to my daughter, and I didn't even have enough money. We went abroad, and it was so expensive. And I just got a mail from someone from Shell about an article I'd written, and they needed professional advice. And they paid me, I think, 4,000 euros then. So writing, you don't never know where what you write will get to. Thirdly, starting small can be as small as an add-on LPG plant in a fuel station. And then you can then expand to a standalone gas plant. So those are areas that many people take for granted, but there are serious opportunities and income that you could generate from those areas. Thank you.
Thank you very much, Dr. Oni. I'll give opportunity for the audience if we have questions or comments. 2 people, please, from the audience. Questions or comments? Do we have anyone? Questions or comments? Unfortunately, our discussants, Dr. Oladuni is not here, so we'll round up the session. Thank you, Dr. Oni. It's been an insightful one, and we hope we can get your papers so that we can get them across to delegates. Thank you for your time.
Thank you very much for having me.
So the session is closed.
Okay. Dr. Muritala Abdulrasheed, ẹ jọ̀ọ́. Ẹ wá bá wa ṣe presentation yìí, sir. Àwọn àlejò wa yẹn náà ó yà pé wọ́n náà tòbí náà. Àwọn tó kù ti lọ. Distinguished Senator, sir. Dr. Emabo, sir. Then I'm sick. Mr. Yogunle, please come. Mr. Kunle Shobaloji, Senior Advocate of Nigeria, sir. Can you do us the honor of Mr. Folabi Kuti, Senior Advocate of Nigeria. Mr. Remi Oguntoye. Aderemi Oguntoye. Otilo.
To Dr. Ayodele Oni, the oil and gas guru, on behalf of the leadership and the entire membership of Egbe Amofin Oodua, I present to you this plaque in appreciation of your insightful and engaging contribution as a speaker at the Egbe Amofin Oodua National Conference 2024. Thank you very much. To our very wonderful moderator, Ajia Aminat Adeola Folani. Yes. Yes. On behalf of the leadership and the entire members of Egbe Amofin Oodua, I present to you this plaque in appreciation of your insightful and engaging moderation at the Egbe Amofin Oodua National Conference 2024. Thank you. Thank you.
Ẹ ṣé.
Distinguished ladies and gentlemen, we thank you very much for your attention, your presence, your cooperation today. We appreciate your presence and the participation, which has been quite enthralling. Tonight, we have the cultural night. A ní àṣálẹ́ àṣà léyìí tó jẹ́ àsìkò tí a ó fi kóra wa lẹ́nu jọ, tí a ó sì tún fi láǹfààní láti jó dáadáa. Gbogbo ẹ̀yin tí ẹ bá lè jùdíréke, ẹni tí ó lè tàpá bàtà, ẹ jẹ́ ká kóra wa jọ ní déédéé agogo bíi méje. 7 p.m. we have the cultural night that we tag Ashale Asha. It's going to be explosive. It is here. It is holding here. It's going to be explosive. It's going to be interesting. Lot of food, lot of drinks to take. So please, if you drank in heaven before coming to this world, don't bother to drink this night. But if you never drank in heaven, you can come and drink tonight. Then tomorrow morning, 10 a.m., is the annual general meeting of Egbe Amofin. That tomorrow's program is strictly for members. Strictly for members. Non-members are excused after tonight's party. So we have a party tonight starting from 7 p.m., which is tagged Ashale Asha, a cultural night. Let us endeavor to be present. Please, it is not a night of jeans or suit or whatever. You come in your resplendent cultural display. That is what we want. And then tomorrow morning at 10 a.m., there's going to be the annual general meeting of Egbe Amofin Oodua. Ní àárọ̀ ọ̀la ní dédé agogo mẹ́wàá la ó ṣe ìpàdé gbogbo ilé, ìpàdé ọmọ ẹgbẹ́. Ní àárọ̀ ọ̀la àwọn kòmẹ́sẹ̀ wọn ó yọ, ṣùgbọ́n gbogbo ọmọ ẹgbẹ́ tó bá wà ní agbègbè tí ò bá tí ì lọ kí ó jọ̀wọ́ kí ó dúró láti bá wa ṣe ìpàdé náà, torí pé ọ̀la ni a ó fi sọ àwọn nǹkan tí ó ń dùn wá lọ́kàn, ọ̀nà wo ni a ó gbà tí a ó fi ní ìlọsíwájú tí iná rẹ̀ tí ó máa jó geere. Ẹ ṣé púpọ̀, a dúpẹ́ o. Dákun, ọ̀gá mi onílù, gbà yín lẹ̀. Àjọ tí a kó jọ fún ètò ìfikùnlukùn lórí ọ̀rọ̀ òṣèlú nínú ẹgbẹ́ amòfin orílẹ̀-èdè Nàìjíríà, èyí tí a pè ní Consultative Committee ti ẹgbẹ́ amòfin Oòduà, yóò máa jókòó ní alẹ́ yìí ní ìgbà tí a bá jó tán, tá a bá ṣe àwẹ̀jẹwẹ̀mú tán níbí báyìí. Gbogbo ọmọ àjọ náà, ẹ dákun, ẹ má ṣàì wá sí ìpàdé náà torí pé ó ṣe pàtàkì. Síbẹ̀, ní ìpàdé náà la ó ti máa fi ìkùnlukùn lórí bí a ó ṣe ní ìlọsíwájú lórí ètò òṣèlú ní inú ẹgbẹ́ amòfin orílẹ̀-èdè Nàìjíríà. Ẹ ṣé púpọ̀, a dúpẹ́ o.
A dúpẹ́ lọ́wọ́ gbogbo àwọn tí a fìwé pè tí wọ́n wá gbé wa lárugẹ. A gbà ládùúrà pé a ó máa rí yín bá o ní agbára àwọn tó kó ètò yìí jọ àti agbára Ọlọ́run Elédùmarè. A gbàdúrà pé délé bá re o, àrìnàkóre ẹ nípàdé léṣù lọ́nà o. Mo pe gbogbo àwọn tí àwọn alábẹ́sẹ́kẹ́lé, àwọn planning committee àti executive ẹgbẹ́ amòfin fún session photograph níbí báyìí. Abigerad. Baruada. Barua. Ah, ẹ jọ̀ọ́ màá fẹ́ tọrọ gáfárà lọ́wọ́ ọ̀gá wa Dave Ajétọ́mọbí. Wọ́n ti wà ń bí tipẹ́tipẹ́, ó yẹ ká ti ṣàfihàn wọn. Ọ̀gá Dave, ẹ jọ̀ọ́ ẹ bá wa náwó sọ́wọ́ kí wọ́n rí yín, ẹ má bínú o.
Ladies and gentlemen, it's a photograph session. The planning committee of the Egbe Amofin Oodua Conference 2024. That will be followed by a picture of the ESCO members, the executive committee of Egbe Amofin Oodua. May I also use this opportunity to express our profound gratitude to each and every one of you that graced this occasion, this conference. Your participation indeed has made it a resounding success. We are most grateful, and God bless you all. It's time for pictures, please. Members of the executive committee of Egbe Amofin Oodua. Members of the executive committee of Egbe Amofin Oodua. Okay. Members of the governing council of Egbe Amofin should please come forward. Mr. Adetunji Osho, Mr. Komolafe, where are you? Members of the governing council, Egbe Amofin Oodua. Ààrẹ Akinboro, please come forward, please. Senator Ajibola Bashir, please come forward now. Mr. Shina Adegbite, now. Adiola Folarin. Diola Folarin, please come forward now. From wherever you are hiding, please come forward. I'm joining now too. Adiola Folarin, please come forward. Moshood Abiola, please come forward. Mr. Adetunji Osho, please come forward. If you are here, please come forward. Abiola Moshood, please come forward. Mr. Rotimi Olorunfemi, please come forward. Mrs. Lai Babatunde, please come forward. Ando de Ima. Mr. Idris Tani, please come forward. Oh, no, okay. I said no. Mr. Abib Ashad. Mr. Abib Ashad, please come forward. Um, Please, may I remind non-Yoruba speakers, ESCO members, governing council members, please. Members of the governing council of the Egbe. Okay. Members of the governing council of the Egbe, please. May I also use this opportunity to remind us that we are reconvening here at 7 p.m. today for the Ashale Asha. 7 p.m. we are reconvening here for Ashale Asha, an event where our cultural values, norms, and traditions are going to be showcased. It also guarantees an opportunity for you to mingle, to connect, to network, as well as to dance. So we hope you are going to turn up at 7 p.m. CPC members, strictly conference planning committee members. Yes. Conference planning committee members, please come forward. Leonard Silk, Mr. Shegun Fabumi, please come forward. Leonard Silk, Mr. Kunle Adegoke, SAN, aka KRAD, please come forward. The one and only Erelu Olaide, please come forward. Chairman Ikeja branch. our noble chairman, Ikeja branch. Noble chairman, Ikorodu branch, please come forward. Every other member of the conference planning committee, please come forward. Laide Erelu, where are you?
Where's your tag?
Oh, amen. Oh, amen. Oh.
Good evening, everyone. Àwọn alága àti ìgbìmọ̀ ẹgbẹ́ amòfin Oòduà wọ́n ní kí n dúpẹ́ lọ́wọ́ gbogbo yín adúpẹ́ o ẹ ṣé o gbogbo àpàdé tó bá ti di aago méje ìrọ̀lẹ́ yìí ẹ ṣé adúpẹ́ o thank you so much.